The Judiciary Committee will please come to order. A quorum being present, without objection, the chair is authorized to declare recess at any time. Pursuant to Committee Rule 2 and House Rule 11, Clause 2, the chair may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote for the ayes and nays are ordered. I would like to remind members that we have established an email address and distribution list dedicated to circulating amendments, exhibits, motions, or other written materials that members might want to offer as part of our markup today. If you'd like to submit materials, please send them to the email address that has been previously distributed to your offices, and we'll circulate the materials to members and staff as quickly as possible. I would also ask all members, both those in person and those appearing remotely, to mute your microphones when you're not speaking. This will help prevent feedback and other technical issues. You may unmute yourself anytime you seek recognition. Pursuant to notice, I now call up H.R. 5455, the Terry Technical Correction Act for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 5455 to amend the First Step Act.
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 5455, the Terry Technical Correction Act, makes clear that the retroactivity provision of Section 404 of the First Step Act of 2018 is available to all offenders who were sentenced for a crack offense before the Fair Sentencing Act of 2010 became effective, including individuals convicted of small quantities of crack. After decades of unfair sentences that most often apply to low-level dealers and impacted minorities disproportionately, this committee has worked in a bipartisan manner to right some of the wrongs of the misguided war on drugs. In 1986, in response to a surge in the use of crack cocaine and several high-profile cocaine-related deaths, Congress passed the Anti-Drug Abuse Act, which created mandatory minimum penalties for drug offenses and introduced a 100-to-1 sentencing disparity between crack cocaine and powder cocaine offenses. This meant that a person who distributed 5 grams of crack cocaine received the same 5-year mandatory minimum sentence as a person who distributed 500 grams of powder cocaine. And a person who distributed 50 grams of crack cocaine received the same 10-year mandatory minimum sentence as a person who distributed 5,000 grams of powder cocaine. It soon became evident that this sentencing disparity had also created a significant racial disparity. 4 years after Congress passed the Anti-Drug Abuse Act, the average federal sentence for African-American defendants was 49% higher than the average for white defendants. As early as 1995, the Sentencing Commission began urging Congress to rectify the unjustified ratio. Besides the troubling racial disparities in sentencing, the Commission also expressed concern over the significant differences in punishment between street-level dealers of crack cocaine and the powder cocaine suppliers who sold the cocaine in the first instance. In 2010, Congress finally acted by passing the Fair Sentencing Act, which did not eliminate the disparity, but which significantly reduced the ratio from 100-to-1 to 18-to-1. This legislation, however, applied only to pending and future cases, leaving thousands of inmates without a path to petition for relief. In 2018, under Republican leadership, the First Step Act was signed into law and made the Fair Sentencing Act retroactive if an inmate received, quote, a sentence for a covered offense, as defined in Section 404 of the Act, providing a pathway to relief for some, but not all, individuals affected by the sentencing disparity. 3 years later, after roughly 4,000 motions for sentence reductions had been granted, the Supreme Court in Terry v. United States limited the availability of sentence reductions under the Fair Sentencing Act, contrary to the intent of Congress. Based on a narrow reading of the meaning of a covered offense, the court held that individuals convicted of crack offenses are only eligible for a sentence reduction under the First Step Act if their convictions triggered mandatory minimum penalties. That means that people like Mr. Terry, who possessed less than 4 grams of crack, are unable to seek sentence reductions, while people convicted of sentences involving much larger quantities of crack can seek a sentence reduction and have already done so, which is simply unfair and absurd. The First Act was meant to make retroactive sentencing relief available to all individuals sentenced for crack cocaine offenses before the Fair Sentencing Act of 2010 took effect. As Justice Sotomayor's concurring opinion in Terry reminds us, Congress has numerous tools to correct this injustice, and H.R. 5455, the Terry Technical Correction Act, is one of those tools. The bill provides a new expanded definition of covered offense that includes a list of drug offenses in the criminal code that do not trigger mandatory minimum sentences. The bill also ensures that no person seeking a sentencing reduction under Section 404 will be barred from filing a new petition solely because a judge previously denied relief based on a determination that they had not committed a covered offense under the meaning provided in the First Step Act. The Terry Technical Correction Act ensures that the intent of the First Step Act is fully realized. I am proud to co-sponsor this bipartisan legislation that will give people left behind in prisons across the country the opportunity to seek relief from what we now know are harsh and unjust sentences. I thank Crime Subcommittee Chairwoman Jackson Lee for her leadership in introducing this important bipartisan legislation. I also thank our colleagues, Representatives Cicilline, Owens, and Massey, as well as Congresswoman Eleanor Holmes Norton, for joining her and for their continued efforts to make our criminal justice system more fair. I urge all of my colleagues to support this bill. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. This legislation responds to the Supreme Court ruling last year that held certain low-level drug offenders to do not qualify for resentencing under the retroactive provisions of the First Step Act. That was not our intent in adopting the First Step Act, and the bill before us makes the necessary corrections to address this concern. This problem dates back to the drug epidemic of the 1980s. At that time, Congress enacted harsh penalties for federal drug offenses, including mandatory minimum sentences. The Anti-Drug Abuse Act of 1986 established harsher punishments for individuals convicted of or sentenced for federal crimes related to crack cocaine as compared to powder cocaine. The law created 101 sentencing disparity, as the chairman mentioned in his opening statement, between crack and powder cocaine, meaning an individual convicted selling 5 grams of crack cocaine would receive the same sentence as someone convicted of selling 500 grams of powder cocaine. In 2010, Congress passed the Fair Sentencing Act, which reduced the sentencing disparity from 100 to 1 to 18 to 1, as the chairman mentioned. In 2018, Congress passed and President Trump signed the First Step Act into law. The First Step Act made the sentencing disparity provision retroactive, allowing individuals convicted of or sentenced for federal drug offenses related to cocaine to move for a resentencing. This legislation today makes technical corrections, brings parity back to crack-related offenses, and I yield back the balance of our time.
Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in nature of substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 5.
Without objection, the amendment in nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. The amendment in the nature of a substitute makes 2 changes to the underlying bill, both of which are minor and technical in nature. The ANS removes the findings and corrects a grammatical error by adding an omitted word in Section 2. Neither of these change the substance of the bill in any way. Therefore, I urge members to support the amendment. I yield back the balance of my time. Are there any amendments to the amendment in the nature of a substitute? For what purposes, Ms. Jackson Lee seek recognition.
I rise to strike the last word.
And ladies recognized.
Thank you, Mr. Chairman. As Justice Thomas noted in his opinion in Terry versus United States, citing my introduction of H.R. 4545, the Drug Sentencing Reform and Cocaine Kingpin Trafficking Act of 2007, which confirms historically that I introduced the first bill on one-to-one crack cocaine. I've long worked to address the sentencing disparity between crack cocaine and powder cocaine offenses, introducing legislation to eliminate the disparity completely. That is why I'm honored that the committee is considering my bill today, H.R. 5455, the Terry Technical Correction Act, which reaffirms Congress' intent to provide retroactive sentencing relief to all individuals convicted of crack offenses before the Fair Sentencing Act of 2010 took effect. With the declaration of the war on drugs in the early 1970s, began a dramatic rise in the U.S. prison population, fueled largely by excessive unwarranted drug sentencing. It is good this morning to see our Chairman Nadler, who has advocated for these reforms, joined by Ranking Member Jordan, who in his remarks indicated the harshness of Congress's laws as relates to drugs in our early years. The federal government played a pivotal role in America's era of mass incarceration during the 1980s and 1990s. Congress passed several pieces of legislation that moved away from rehabilitation toward excessive punishment. I saw the deep and abiding pain among mothers and fathers as children, yes, children, youth in the ages of 19, 20, early 20s, went into prison in very long sentences. One such example is the Anti-Drug Abuse Act of 1986, which created mandatory minimum penalties for most drug offenses and established a 100-to-1 cocaine to crack disparity. And as Judge Sotomayor acknowledges in her concurrent opinion in Terry, African Americans bore the brunt of this disparity. It's a painful era. Between 1992 and 2006, roughly 80 to 90% of those convicted of crack offenses were African Americans. It was a nightmare. There were many who sounded the alarm during that time, including the U.S. Sentencing Commission, which repeatedly called upon Congress to revisit this mandatory minimum sentencing structure because of the racial disparities ongoing, continuing, and unceasing in cocaine versus crack sentencing. Sadly, Congress refused to listen, even though those who utilized cocaine were certainly more economically able and didn't see incarceration as much as those addicted to crack and really sick because of crack cocaine. But members of this committee, on an increasingly bipartisan basis, have worked hard to reduce the harmful impact of the failed policies of the war on drugs, including putting an end to the impact of the crack to powder sentencing disparity. Through our efforts, we have learned that there is no greater danger to public safety from crack offenders than powder cocaine offenders, and that the 100-to-1 ratio overstated the relative harmfulness of the two forms of cocaine and diverted federal resources away from prosecuting the highest level traffickers, that could be, in essence, trafficked. It is clearly important to assess where we are today. In 2010, Congress began the process to eradicate the devastating consequences of the poorly conceived war on drugs and the punitive response to the crack cocaine epidemic. The First Sentencing Act of 2010, which I was privileged to be at the White House when it was signed, took my bill and a number of other bills and determined that the sentence disparity would be 18-to-1. And the First Step Act of 2018 made the First Sentencing Act retroactive. Although the Terry decision authored by Justice Thomas bars crack cocaine from requesting the resentencing under the First Step Act, offenders convicted of offenses involving small amounts of crack, like the 3.9 grams of crack that the petitioner possessed, that does not trigger the mandatory minimum penalties. Congress can correct this injustice. H.R. 5455, aptly named the Terry Technical Correction Act, would guarantee the ability to seek a sentence reduction to all individuals who have unfairly lost years of freedom under the unfounded 100-to-1 disparity, including those whose requests for sentence reduction were previously denied based on the narrow interpretation of the First Step Act. So here we are today. I'm grateful that Chairman Nadler is bringing this bill forward up for consideration, and I appreciate his co-sponsorship, along with Representative Cicilline, Jeffries, Owens, Massey, and Delegate Holmes Norton. And I ask unanimous consent to submit into the record the letter of support dated September 21, 2022, the Major Cities Chiefs Association, which says that MCCA strongly believes that Congress should eliminate the federal sentencing disparity for crack versus powder cocaine offenses. And so even law enforcement recognizes the wrong direction, and I ask my colleagues to support this legislation. Mr. Chairman, I yield back.
Gentlelady yields back for purposes. The gentleman from Ohio seek recognition.
Strike last word.
Gentleman is recognized.
Thank you, Mr. Chairman. This legislation is a straightforward fix that will clarify the legislative intent of the First Step Act and allow individuals convicted of crack cocaine, particularly those at very low levels, to seek resentencing if appropriate. Like our ranking member, Mr. Jordan, I do support it. However, we have far more pressing matters that this committee needs to address, including efforts to combat America's current drug crisis. Last year, annual drug poisoning deaths rose above 100,000 for the first time in American history, and over 70% of those deaths were due to fentanyl, which is killing so many, particularly young Americans, but many Americans across the board. It's now the leading death the leading cause of death in the United States for adults between 18 and 45 years of age. And that's a lot of people. And it's a driving factor in the opioid epidemic, which continues unabated in this country. Fentanyl is so common that the DEA now, they warned law enforcement to take necessary precautions when they're handling any drugs and to assume that all drugs that they're handling contain fentanyl because it can basically be absorbed and affect them, and it can be deadly to law enforcement to handle fentanyl almost at any level. And President Biden's open border policies have only fueled the fentanyl crisis, with drug smugglers having free rein at our southern border. Shockingly, last year, fentanyl trafficking across our border increased by 132%. In July 2022, Customs and Border Protection reported seizing a record 2,130 pounds of fentanyl, enough for over 480 million potential lethal doses. So more than the entire population of the United States could have died from this fentanyl. And that's just what we seized. And we know that there's far more fentanyl that's come into the country that wasn't seized. So this is like death coming across our borders. We're not talking about that today. This is a catastrophic public health crisis that continues to accelerate under the Biden administration. Democrats recognize the open southern border is fueling the fentanyl crisis. That's where it's coming from. Yet they continue to refuse to do anything about that open southern border. The administration's border policies have caused tens of thousands of deaths in America and devastated communities and families all across the country. We need to fight this epidemic at its source, the U.S.-Mexican border, and increase penalties for criminals flooding our communities with deadly drugs and illegal narcotics. And it's still incredible to me that the person most responsible for protecting that border, the head of Homeland Security, came before this very committee and said the southern border is secure. Incredible. The southern border is secure. All you got to do is turn on your TV set and you'll see people flowing across the border. And now it's controversial because some of our governors have said, since the administration won't enforce our borders and we got all these people coming into my state, well, I maybe send some of those folks up to where the people that are supporting these open border policies are, and now they're screaming bloody murder about it because they can't handle a very small percentage of the load that's based upon this administration and their policies. So that's what Mayorkas said, the border secured. And then the Vice President of the United States recently, who President Biden put in control of securing our southern border. Apparently, according to her, she did her job, because according to her, our southern border is secure as well. I guess they don't have TV sets, because all you have to do is turn on your TV set and you'll see with your own eyes, your own lying eyes, apparently, according to them, that the border is clearly not secure. So it's just amazing to me that we continue in this fabrication that we got a southern border that's secure, because it's absolutely not. So yes, I'm supportive of this legislation, and I know some of my colleagues, particularly Ms. Jackson Lee, I know to her credit, we've been on this committee together a long time, and she's been consistent in trying to get this done. Congratulations, you're getting it done. But I would say we got bigger problems, and let's get to those problems. I yield back.
The gentleman yields back. Who seeks recognition? No one seeks recognition. Oh, for what purpose does the gentleman from Arizona seek recognition? Colorado. I'm sorry, I don't mean to insult Colorado. What purpose does the gentleman from Colorado seek recognition?
Move to strike the last word.
Gentleman is recognized.
Mr. Chairman, I understand that individuals in prison, to some people, create some sympathy. I actually have attended a lot of funerals for the murder victims of those folks who are in prison. And I can tell you that the families of those murder victims are also very sad. And to suggest that we equalize the level of crack cocaine and powder cocaine is absolutely absurd. Crack cocaine is highly addictive. Powder cocaine is not. It's as if we were trying to equalize powder cocaine and heroin, or powder cocaine and meth. The qualities of these drugs are so fundamentally different. And what happened and why Congress reacted in the past and increased the penalties for crack cocaine was because of the skyrocketing death rate among young black males. I read from an article entitled "The Lingering Lethal Toll of America's Crack Crisis," and it concludes and it estimates that the murder rates of black males aged 15 to 24 doubled soon after the crack epidemic hit their cities. We continue to see, as my friend from Ohio has mentioned, we continue to see other drugs taking the place of this crack cocaine epidemic, and the murder rates continuing. Another article entitled "U.S. Murders Soared Nearly 30% in 2020, FBI Reports." Another article, "Homicide is Pandemic's Biggest Killer of Young Black Men." Another article, "It's Just Crazy, 12 major cities hit all-time homicide records. It's worse than a war zone around here lately," a police official said. Chicago shootings, 3-year-old girl among 63 shot, 9 fatally in weekend violence. Chicago reached at least 800 homicides in 2021, a level not seen in 25 years. 5 major cities on pace to pass steep 2021 homicide totals halfway through 2022. A weekend of gun violence in Philadelphia shows the incalculable yet cruelly normal level of trauma that residents must endure. New Orleans police sound alarm on desperate situation with homicide rate 4 times higher than Chicago. Mr. Chairman, I understand the sympathy that some must feel for those who are in prison because they've murdered somebody, because they have spewed poison around our cities. I think it is high time that this committee take this issue seriously and start protecting young black men in urban America. That's the crisis we have right now. It's not a crisis or an epidemic for those who are in prison. They have earned their way to prison, and hopefully they stay there for a long, long time. And if you release them, they will re-earn their way to
Did the
prison.
gentleman yield?
Yes.
Thank you. I just point out to the gentleman that in 2010, the ratio was established at 18-1, not 1-1. No one is suggesting we change that. We're simply giving, and subsequently Congress made clear that that was retroactive, and there was a Supreme Court decision that narrowly interpreted the retroactivity provision, which is all this bill seeks to correct. So it really bears very little relationship to the murder rate. I'd yield back.
There's a little relationship between addictive drugs and murder rates?
No. There's little relationship between this bill, which simply reconfirms the retroactivity of the 18-1 disparity between this bill and the murder rate.
Well, Mr. Chairman, I can tell
Lowest
you,
level offenders, which is what this applies to.
I reclaim my time, what little there is left. Mr. Chairman, I can tell you that there is a direct relationship between letting people out of prison and seeing more crime. And we will feel that relationship. And unfortunately, the ones who will feel it the most are the young black men in urban America, and I yield back.
Gentleman yields back. Does anyone else seek recognition? If not, the question occurs on the amendment and nature of a substitute. For the purposes, the gentleman from Tennessee seek recognition.
Strike the last word.
Gentleman is recognized.
I just want to say I agree with Mr. Shabbat on the problem with fentanyl, and we need to do all we can to cure that scourge. Of course, if Mexico's the problem, they didn't pay for the wall, and if they would have paid for it, we'd have had it. So that's a problem. I'd like to yield the remainder of my time to Ms. Jackson-Lee.
I thank the gentleman for that, and I think we will echo the gentleman's comments. I don't think anyone here is a champion or an advocate of fentanyl, and I know that we have begun some work here in this committee on this issue. The Terry fix stands on its own 2 feet. None of us in any way condones the loss of life. I do believe that all of the medical leaders in this area will indicate that cocaine is very addictive, crack is very addictive, and even police officers, major chiefs, understood that there is value to reducing the stark disparities that were between crack cocaine. I was proud to introduce the bill, which was cited by Justice Thomas, that I introduced in 2007, dealing with drug kingpins, focusing on the drug kingpins and also recognizing that we were victimizing the people who were sick. And that was ultimately recognized by then Chairman Goodlatte some years later when he took on the opioid crisis and declared it out of this committee a health crisis, which I was able to add some sense of Congress language that indicated that crack is a health crisis as well. So I am glad for the bipartisan effort of this particular legislation. I thank my colleagues. I want to take note of the fact that the U.S. Sentencing Commission estimated as of March 27th, 2021, that no more than 232 inmates may be eligible for a sentence reduction on the Terry correction. That estimate remains the same today. And let me take note of the numbers of diverse groups that are supporting this: American Civil Liberties Union, the American Conservative Union, Americans for Prosperity, the Drug Policy Alliance, Due Process Institute, FAM, Federal Public and Community Defenders, Justice Action Network, the Leadership Conference on Civil and Human Rights, Major Cities Chief, National Association of Criminal Defense Lawyers, and National District Attorneys Association, Prison Fellowship, R Street Institute, Right on Crime, and the Sentencing Project. So I think that we have brought together people of differing political philosophies, but as Justice Thomas drew us to this particular issue in his opinion, he wants, and we are able to, as members of Congress, to do the right thing. And I ask my colleagues to support this legislation. With that, I yield back.
You yield back to Mr. Cohen.
Yield back to Mr. Cohen.
I yield back the rest of my time.
The gentleman yields back. For what purpose does the gentleman from Florida seek recognition?
Move to strike last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I support the Terry fix. I can't imagine being one of the 232 people sitting in federal prison right now thinking if I had committed the exact same offense after President Trump had signed the First Step Act, I wouldn't be here anymore. I'd be with my family. But instead, because of, I think, a flawed determination that didn't allow retroactivity, we are treating people differently for committing the same offenses. We're incarcerating some people for the very same offenses that they would otherwise not be incarcerated for. And so I think that's an appropriate fix. There has been discussion today of fentanyl, and it irks me every time I hear someone talk about fentanyl overdoses, because no one overdoses on fentanyl, because I don't think anybody really sets out to score some fentanyl for a good time. I get why it's hard to keep cocaine from coming into the country. People in the United States like using cocaine. They seek it out. They pay high dollar amounts for it. And so that would be something hard to stop. But since people don't set out to use fentanyl, since it's something we don't want in our country, we should be totally capable of stopping it. And the only reason we aren't is because we purposefully allow our border to degrade. Not by accident, not because of some lack of capability or some unsolvable problem set, but because there are some groups on the right and left who think that they will do better economically if we just let millions of people into the country and depress the wages of Americans. And the cost they're willing to pay for that are the funerals and the deaths and the broken lives as a result of fentanyl poisoning, because it is not an overdose. It is a poisoning that happens. We're in the month of September, and I know all of us thought back to September 11, 2001, when we have to relive this day, and you think about thousands of Americans needlessly dying, and then us going off into like 20 years of wars in every Central Asian cave where there might be a terrorist hiding to avenge those thousands of lives. And I think today about the tens of thousands of lives that we are losing over and over again in every community in our country, and we seemingly like clutch our pearls at the suggestion that we might think about dropping off a few Tomahawk missiles in the Sinaloa Mountains where we know that fentanyl is being manufactured. So I don't think it was unreasonable for President Trump to ask the question about whether or not we ought to authorize the use of military force against the very people that are killing tens of thousands of Americans for stuff that we don't want. So I think it's a great fix to the Terry Act, but I think if we really want to get serious about what's harming far more than 232 Americans, we would get tough on the border and even tougher on the Sinaloa cartel. And I yield back.
The gentleman yields back. Does anyone else seek recognition? If not, the question occurs on the amendment, nature of a substitute. All in favor say aye. Aye. Opposed, no. The ayes have it. And the opinion of the chair, the ayes have it. The amendment, nature of a substitute, is agreed to. The reporting quorum being present, the question is on the motion to report the bill H.R. 5455 is amended favorably to the House. Those in favor respond by saying aye. Aye. Opposed,
Aye.
Opposed, no. The ayes have it, and the bill is ordered reported favorably. The bill as amended is ordered reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 5651, the Fresh Start Act of 2021, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
HR 5651 to establish a grant program for
Without
states.
objection, the bill is considered as read and open for amendment at any point. I'll begin by recognizing myself for an opening statement. H.R. 5651, the Fresh Start Act, is bipartisan legislation to address the collateral consequences of a criminal conviction by supporting state efforts to implement criminal record sealing and expungement programs. It is estimated that 112 million Americans have a criminal record. That is 1 out of every 3 people. The existence of a criminal record, even just an arrest, can present lifetime barriers to obtaining jobs, housing, and education, and put other opportunities out of reach. Criminal record expungement and sealing offers a pathway to employment opportunities for individuals with a criminal record, enabling them to participate fully in their communities. At a time when many industries continue to face labor shortages, these pathways are desperately needed. Employers like Walmart, J.P. Morgan Chase, and other members of the Second Chance Business Coalition recognize the value that formerly incarcerated individuals can bring to their workplace. Criminal record sealing and expungement enables greater access to employment for formerly incarcerated individuals and allows employers to hire a greater number of capable and qualified workers. This bipartisan bill supports sealing and expungement programs that have already been enacted at the state level. States such as Pennsylvania, Utah, Michigan, Connecticut, Delaware, Oklahoma, and Colorado have recently passed clean slate laws, and nearly all states have some form of criminal record sealing. The Fresh Start Act will support states in their implementation of automatic record clearing through federal grant resources. This bill does not prescribe for each state how they should develop their expungement or sealing program. Instead, it allows the states to determine the scope and parameters that meets the needs of their specific state. In order to ensure that this program is successful, the bill requires the Department of Justice to consult with all relevant stakeholders, including state and local law enforcement agencies, prosecutors, and courts, in the development of this program. Expanding access to employment makes communities safer and increases public safety. When individuals have access to good, stable employment, they are less likely to commit new crimes. The Fresh Start Act takes the important step of providing the resources states need to effectively implement criminal record sealing and expungement programs so that individuals can overcome the collateral consequences of a criminal conviction, access employment, housing, and benefits, and participate fully in their communities. I thank Representative David Trone and his bipartisan co-sponsors, including several members of this committee, for introducing this important legislation. I urge all members to support the bill, and I yield back the balance of my time. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. Congress doesn't need to help states be kinder to criminals. Democrat-run jurisdictions have shown they can do this on their own, and we've seen the result. Public safety is down, crime is up. This legislation is a waste of federal tax dollars and an encroachment on an area that should be left to the states. The bill provides federal tax money to states that have laws that automatically seal or expunge criminal records. States can already seal or expunge records on their own, but this bill would create a federal financial incentive for them to do so. Our states are supposed to be laboratories of experiment for different policies. We should not be bribing them to take certain action. And this money would not only go to states that change their laws, it would also give money to states that have already adopted these policies. 10 states have authorized some form of automatic sealing or expungement process without the need for federal grants. This bill would allow them to get grants too. In other words, in these cases, the legislation is just a subsidy for state governments. Many states have a budget surplus. Due to the reckless and irresponsible spending by Democrat colleagues, the federal government does not. Families around the country are struggling in the Biden economy to put food on their table, to pay for the most basic necessities. You would think they're going to be happy with their hard-earned tax dollars being, they're going to be happy with their hard-earned tax dollars being used to weaken public safety. We should not be putting the American people further into the debt by enacting another soft-on-crime policy that does nothing to address the record-level crime that we see in cities across our country. I urge my colleagues to oppose this legislation and yield back.
Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 5.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I recognize myself to explain the amendment. This amendment in the nature of a substitute adds a provision to require that the Department of Justice consult with all relevant stakeholders when developing the grant program established under the bill. These stakeholders include law enforcement agencies, directly impacted individuals, state and local prosecutors, state court officials, organizations with expertise in justice information sharing, civil rights and civil liberties groups, and others. The amendment also makes a few minor technical and conforming changes. I urge all members to support the amendment, and I yield back the balance of my time. Are there any amendments to the amendment in the nature of a substitute? What purpose does the gentlelady from Texas seek recognition?
I move to strike the last word.
Gentlelady is recognized.
Mr. Chairman, I rise to support H.R. 5651, the Fresh Start Act. It is a bipartisan legislation that would provide vital resources to states with existing criminal record sealing or expungement laws to support their implementation. Let me be very clear. Resources to states with existing criminal record sealing or expungement laws to support their implementation. This is not the federal government leaping down to create anything in the states. It is states who have this process, procedure, protocol, scheme in place. An arrest or prosecution, even for a low-level nonviolent offense, can result in extensive, oftentimes unintended consequences. These consequences include barriers to steady employment, as well as access to affordable housing, education, opportunities, and vital social services. H.R. 5651 recognizes the need to support state efforts to address these collateral consequences through the expungement and record sealing by making certain existing state programs achieve the greatest impact. Emphasize over the existing state programs. Federal resources are desperately needed because many people who are eligible to receive these life-changing benefits rarely do so because the process is costly and complicated. A 2020 study in Michigan found that 90% of those eligible for expungement or set-asides do not even apply. That can change one's life forever. More and more states are looking to ease the burden of expungement and record clearing by making the process automatic. The funding provided in this bill could help states find ways to streamline the process, reach more eligible people, and change their lives, and create the opportunity for people to amend the direction that they have taken and to get a job. We know that most job applications still today ask for arrest and conviction, and that may be a signal that you will not be hired. Importantly, the bipartisan Fresh Start Act will allow each state to determine the scope of their programs to meet their specific needs and allows them to decide how they should develop and improve their programs. This bill also requires states to provide data from implementation of their programs, such as the number of people eligible and the number of people received an expungement or record sealing, accounting for race, ethnicity, and gender. Important information for the federal government as well. This important data will be made available to the public to ensure transparency and to better understand the barriers to equitable access to record sealing and expungement. Because while approximately 77 million Americans, or 1 in 3 adults, have a criminal record, statistics show that Black, Latino, and Indigenous people are disproportionately criminalized and more likely to have a criminal record. And this has gone on for decades. And so there is a bounty of individuals in those categories who have suffered that and who attempt to start a new life. The Fresh Start Act would provide the resources states need to effectively implement their criminal record sealing and expungement programs so more people can free themselves of the burdens of unnecessary collateral consequences, start a new life, be law-abiding citizens, access employment, housing, and benefits, and participate fully in their communities and support their families and support their communities and be active contributors to the freedom and democracy of this nation. I thank Representative David Trone for his hard work, constant work, and continuous advocacy for the 21 bipartisan original co-sponsors for introducing this important bipartisan bill that will bring relief to people with a criminal record, and I urge my colleagues to join me in support of this bill. With that, Mr. Chairman, I yield back.
Gentlelady yields back. For what purposes the gentleman from Ohio seek recognition? Gentleman is recognized.
Thank you, Mr. Chairman. This is the second criminal justice reform bill considered by this Democrat-controlled committee today, and yet neither of these bills does a thing to combat America's crime crisis, which everybody who has a television set realizes is a real problem across America today. This legislation would authorize the Attorney General to make grants up to $5 million to a state with existing eligible criminal record sealing and expungement laws to support implementation of an automatic sealing or expungement process. States should adopt policies that meet the needs specific to their state without the interference of the federal government, us. Most state legislatures have already provided a mechanism for certain records to be sealed or expunged through a court petition. While this process may come with its own set of challenges and barriers, it's for the states to address based on their own circumstances. Some might want to adopt automated processes and some may not, but they don't need the federal government telling them how to do it. As proof, without any assistance from the federal government, some states have already taken action to implement an automated record clearing process that would solve many of the burdensome challenges that may accompany petitioning a court. Ignoring this reality, this legislation would use federal taxpayer dollars to financially incentivize states to implement automatic sealing or expungement processes that states have shown they can fund on their own if they do choose. Worse, it would give federal dollars to states who have already changed their laws, meaning they didn't need this incentive at all. Mr. Chairman, this is an unnecessary waste of taxpayer dollars that does nothing to address the record level of crime in Democrat-run cities across this country. So what type of policies have the Democrats in Congress initiated in recent years to deal with the crime across the country? Well, one thing, and it was actually a member of this committee and some others have talked about defunding the police. And they've actually done it in communities across the country, and we've seen the results in skyrocketing crime rates in some cities. We've seen homicide rates, for example, at record times. It's never a good time, in my view, to defund the police, certainly not when you've got crime as rampant as it is right now. In New York City, for example, it was, I believe, $1 billion they took out of the police budget, and now they're seeing the results of that. This committee, the Democrats on this committee, and then it was ultimately, I believe, taken up by the House Democrats as well, one of their priorities when it came to dealing with record crime was to do away with something called qualified immunity. What's that? That's basically what protects police officers from being personally sued for their duties and their responsibilities and their actions as police officers. Right now, if they follow what they've been taught at the police academy when they're dealing with a defendant, the city that they work for, et cetera, could be sued, but not the police officer, him or herself. But if you do away with qualified immunity, they could be personally sued. By the nature of the job itself, when you're a police officer in this country, or really any country across the globe, but if you're a police officer, you're going to come into contact periodically with the public. It's the nature of the job. Domestic violence cases, DUIs, there will be physical confrontations on occasion. And as I say, they're protected as long as they don't do something particularly violent. They followed what they were taught to do. But if you could take away their pension, their kids' college funds, their equity in their home, who's going to want to be a police officer in this country? And I've been around to many police departments in my district, and police departments are having a hard time getting people who actually want to become police officers and go into that profession, and that's very dangerous for this country. So, Mr. Chairman, this committee, instead of this legislation, which is bad legislation, should instead focus its immediate efforts on reining in crime, combating this nation's drug epidemic, and securing our southern border to prevent illegal drug trafficking and smuggling. That's what we ought to be focused on, not this. And I yield back.
Gentleman yields back. What purpose does the gentleman from Tennessee seek recognition?
Strike the last word.
Gentleman is recognized.
Mr. Chair, when you said the bill that was up, I jumped to attention because I've had the Fresh Start Act for over 10 years now. So I thought, my gosh, my bill has been scheduled. But it's not been scheduled. Somebody else took my title, which I guess is legal, unusual politically, but done. So sayonara, Fresh Start Act. Mr. Trone's bill is a reasonable bill. I think expungement is a good thing to get people back into society. The bill I have would have simply applied to federal offenders, and it would have been a one-time offender, a nonviolent offense, and 7 years of conduct that was without any criminal behavior or any questions. And then the federal judge could consider expungement. I still believe that should be the law. I believe Ms. Rochester has a bill that's coming up that I'll also support because I don't want to get in the way of good policy. But I think the better policy would be limiting it to a 7-year exhibition of good conduct and only for nonviolent offenses. Her stresses marijuana, and that's good. I will support both bills to try to move society forward, and will sadly relinquish the title of Fresh Start Act.
Would you
I
yield?
back
Would
to
you
Ms.
yield?
Gentleman
Would you
yields.
yield?
I yield to Ms. Jackson Lee.
Let me, and I'll be quick because I know the chairman asked for it, but let me say to the chairman of the Constitutional Subcommittee, I think there are many opportunities for additions to the work that you've done over the years, and I know that this committee and subcommittee would look forward to engaging with the work that we've done. We've worked very closely together, the two committees, and I would look forward to working, and I know this committee welcomes the idea of continually improving on criminal justice reform. Mr. Chairman, I wanted to add into the record a number of articles, and as I do so, I just want to give just a snippet of these articles. This is the New York Times, dated on September 13, 2022. The case for exposing criminal records, and it just says the consequence of a run-in with the law can persist for decades after the formal sentence has been served. I think that one sentence says it all. This is what happens to men in my community, women in my community. It lasts forever and ever and ever. It lasts when they mature. It lasts when they marry. It lasts when they have children. It lasts when they take the children to school and they don't have the means to uplift. It lasts when they try to get into a community college. I asked, and he asked was unanimous consent. I'll put them all in at the same time. As arrest records rise, Americans find consequences can last a lifetime. This is an article, and it says America has a rap sheet. For the past 20 years, authorities have made more than $250 million arrests. And the FBI estimates, as a result of the FBI currently 77.7 million individuals on file in the master criminal database. Those people are not able to move their lives forward, even if they have made amends and changed their ways. If you paid your debt to society, you should be allowed to work. 1 in 3 American adults, more than 70 million, have a type of arrest or criminal record that, unfortunately, these Americans who are incarcerated or have a conviction on their record are essentially unable to secure good jobs. They ask unanimous consent. After 20 years, business owner thankful for felony expungement from Project Clean Slate. And he says, I knew if I was the owner and operator, I wouldn't have to ask anybody for a job. And that comes from a mentality of being turned down so much, he said. Now my company is in a position to do international commerce I couldn't get to Canada before. As unanimous consent, a criminal record shouldn't be a life sentence of poverty, and this is the biggest element of what happens to those who have gone awry, if you will, and have to have background checks. It is impacting people in a negative manner. As unanimous consent
objection.
for all these articles to be, and I yield back to the gentleman.
Thank you.
Gentleman,
Thank you. Thank you very much. And I think I'm going to come up with,
gentleman yields.
I yield.
Thank you. I just want to thank the gentleman for his work on this issue. He's been a long-time champion of expungement legislation and of criminal justice reform generally. His work helped pave the way for the legislation we're considering today, and I hope to continue working with him on this and other important areas of reform.
Thank you, Mr. Chairman. I appreciate that. And the new Fresh Start Act will be available soon.
Does the gentleman yield back?
I yield the balance.
Mr. Chairman.
Gentleman yields back. Who else seeks recognition?
Chairman,
For what purpose does the gentleman from New York seek recognition?
move to strike the last word.
Gentleman is recognized.
Thank you, Mr. Chairman, for your leadership. I also look forward to the Steve Cohen Fresh Start Act in the coming days or weeks, and appreciate the gentleman's work in this area. I rise today in strong support of H.R. 5651, the Fresh Start Act of 2021, a bill to help states that already have record sealing or expungement laws in place to automate their criminal records. Criminal records can make it substantially more difficult to find work, housing, or get access to education. People who want to be productive, follow the law, and contribute to their communities are too often hindered by the scarlet letter of a criminal record. That is why nearly every state has some form of criminal record sealing on its books. These laws are beneficial, but the process for filing for a record-clearing petition can be complex, cumbersome, and costly. To enable Americans to receive the second chance that many of us on a bipartisan basis agree should be forthcoming when someone has paid their debt to society, many states are working to simplify the process. The Fresh Start Act of 2021 will support these efforts by providing federal funding for states to improve their automated record infrastructures. While the states have been clear leaders in this space, we have an opportunity here to utilize federal resources to help them implement their initiatives and deliver on the promise of a fair criminal justice system that believes in the power of redemption and rehabilitation. I'm proud to support this critical bipartisan legislation sponsored by my friend, Representative David Trone, and so many others, including Representatives Rodney Davis, Dan Crenshaw, Stephanie Bice, Lisa Blunt Rochester, and many members of this distinguished committee. I also point out that this legislation that helps ensure that people can successfully reenter society and be productive citizens is a crime-fighting technique that will save taxpayer dollars by helping to ensure that individuals who want to live productive lives can do so, contribute to American society, and limit the temptation for folks, because of obstacles they confront, to go back into a less productive life that can be harmful to the community or to the country. And so I thank the bipartisan co-leads of this legislation and the chair for bringing it forward, and urge that members support its adoption. I yield back.
Gentleman yields back. For what purposes, gentleman from Texas seek recognition?
Strike the last word.
Gentleman is recognized.
Yeah, and I really appreciate the comments of my friends across the aisle, and basically am in awe of the way people can have such conflicting arguments on different issues on on certain things. For example, when it comes to guns, people on the other side go ballistic, as you know, I did, like when the Air Force failed to have in their records a conviction which would have kept a guy from getting a gun that killed people, could have saved lives if the Air Force had just listed the conviction. And yet we have this big effort to push for expungement. And as someone who has practiced law in federal court and, you know, been a prosecutor and sentencing judge in a state district court, I know how the systems work. And in federal court, it's not uncommon to have a plea agreement. In state court, you could have a prosecutor recommend a specific sentence that the judge would either go along with, or the defendant could withdraw the plea. Not so in the federal courts. The federal prosecutors, as my friend Mr. Buck knows, they'll make deals and say, look, we want the guy, Mr. Big, above you, and we've got you with a gun, and that's going to cause you a lot of extra time. We've got you with violence, and that's going to cause extra time, but we're willing to not pursue the gun, simply charge you with possession if you'll testify against the people above you. That happens all the time that I've seen in our federal courts in Texas, and I understand it happens other places. So I was all for not just going from the 1986 100-to-1 difference between crack and powder cocaine, and hearing from Lundgren, Dan Lundgren, when he was here back before 2010, he was saying that in 86, when the 101 ratio between crack and powder cocaine was done, that there were a number of members of the Congressional Black Caucus who had said, if you don't vote to have 100 times more strong sentence for crack cocaine than powder cocaine, then you are a racist, because crack cocaine is destroying Black communities. So Dan said, look, we went along, we didn't want to be called racist, so we voted for the 101 disparity. And then in 2010, until Dan pointed that out, we had people calling anybody racist for going along with the 100-to-1 when they voted for it to avoid being called racist. But I never understood that crack should be that kind of, have that kind of difference. And I asked our own top Republican member back in 2010, why don't we just make it 1-to-1? And I was told in no uncertain terms that that was the deal, and that's the way it had to be. I didn't think it ought to be 18-to-1. I thought it ought to be 1-to-1. My problem with legislation that does not consider what the judges did, like the fact that a judge can consider all the data in the pre-sentence report, the evidence that there, and then we come along as legislators and say, we don't care what the judge was thinking. We don't care that he followed the law, considered all of this data, that information, evidence about this individual. We come along and say, we're just going to knock all that stuff out from people that knew what they were doing and substitute our opinion. And expungement, do people not realize that if you make it too easy to expunge, then we'll have other Congresses come back in screaming about these people that had convictions. They were known drug dealers involved in violence, even though they didn't plead or convict of that because of a deal. Look, we should not be pronouncing from Mount Olympus here in DC. We need to leave this to the states. I yield back.
The gentleman yields back. For what purpose does the gentlelady from Pennsylvania seek recognition?
Mr. Chairman, to move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman. First, I rise in acknowledgement of the long history that Mr. Cohen has of working on these issues. So I thank you very much for your extraordinary work. Sorry about the name confusion. I don't like when that happens here. I also rise today in support of H.R. 5651. America has spent decades trying to arrest our way or hide away our problems behind bars, and we are facing the consequences every single day. We've seen decades and decades of over-criminalization resulting in between 70 to 100 million Americans with criminal records that appear in routine background checks, a world where 1 in 3 Americans have a criminal record. And as we know, those arrests were not equally distributed throughout our society. Black and brown communities across the country have received the blunt end of failed policies. Criminal records every day keep people from obtaining jobs, seeking educational opportunities, even finding safe housing. That's why I am delighted to be a co-lead of the Fresh Start Act with my colleague David Trone. This bipartisan bill will streamline the records clearing process through a federal grant to help improve states' automated records infrastructure. This bill is a common sense measure. Record clearing is not only very expensive, but a daunting, time-consuming process. Only 10% of people who are eligible to have their records clear have been cleared. This means that current laws are failing 90% of Americans who have paid their dues. People who have paid their debt to society deserve a chance to live as full participants in our society. Access to employment, good jobs, a safe place to rest one's head at night, help keep people from reoffending. Criminal records should not permanently damn someone to a life without access to their communities. I urge strong support for the Fresh Start Act, and I yield back.
The gentlelady yields back. Who seeks recognition? Does Ms. Scanlon seek recognition? Gentlelady is recognized.
Thank you. I move to strike the last word.
Gentlelady is recognized.
Thank you. Having a minor or decades-old criminal record shouldn't be a life sentence, but millions of Americans can't get a fresh start because clearing the record is so burdensome and expensive. I spoke with someone just this week who is seeking to move up in their field and has been unable to do so because of a decades-old conviction and criminal conduct that's never been repeated. So I strongly support this bill. The bureaucratic delays and high legal fees that perpetuate the cycle of poverty and make it more difficult for people to transition back into society successfully are a barrier to our economy, to all of us. In 2018, lawmakers in Pennsylvania from both sides of the aisle acknowledged this problem and came together to send a clean slate bill to our governor's desk. And when it was signed into law, it made Pennsylvania the first state to seal criminal cases by an automated computer process. Now, this has opened the door for thousands of Pennsylvanians and helped break down barriers to full employment, housing, and education that too many people face despite having paid their debt to society. So now that other states have followed suit with their own common sense legislation, we see it reducing recidivism, helping more Americans become active members of their communities. So as states across the country consider and pass these measures, it's important that we don't let a lack of technological infrastructure get in the way of these well-earned new beginnings. I was proud to join Congressman Trone as a co-lead on this legislation to help more Americans get the second chance they deserve. So I look forward to moving the bill out of committee today and urge all my colleagues to support the bill. I yield back.
Gentlelady yields back. Does anyone? What purpose does Mr. Bishop seek recognition?
To speak on the bill.
The gentleman is recognized.
And I'm going to be brief, I think, but, you know, it's interesting. A number of folks have noted that or begged the question why it's appropriate to essentially incentivize states to make this decision when states can certainly make the policy decision of their own. I respect those whose opinion is that eliminating from consideration, you know, conviction history through expungement, denying the public information about them, that's good policy because it'll encourage employment and maybe reduce recidivism that way. I respect that, but it certainly seems that we could leave that decision to states and that there's not a reason for the federal government to pay for it, but there is another level of freedom that you might at least take into consideration, and that's people. It is interesting and to me highly disrespectful to individuals throughout this country who make decisions about whom to employ, whom to associate with for business reasons, and what they can take into consideration. To those people, you're saying, we're going to conceal government information from you that you might find useful. And in a lot of states have the ban the box provisions. They're saying to people who want to make business decisions, we're going to tell you what you can and can't consider in terms of somebody's criminal record. I think it would be better to just let people be free about what they decide to do and to appeal to their sense of fairness and responsibility and consideration of all possibilities, rather than have the mighty hand of the federal government try to impose it on people, impose it on states, impose. And so I just think I think we conceal too much government information. I think we ought to have more transparency. Let people know have access to the facts and respect them and count on them to make good decisions. That would be, I think, better policy. So I'll be voting against this for that reason.
Gentleman yield?
I'll yield back.
To Mr. Gates.
I'll yield to Mr. Gates.
I thank the gentleman for yielding upon my request. Prior to joining the Congress, I was the criminal justice chairman in the Florida House of Representatives, and we encountered a lot of legislative proposals regarding expungement, banning the box, and we were able to have the debates that Mr. Bishop just framed up in his remarks, and I believe fervently, having had that experience, that the best place for that debate is in the halls of our state legislatures, not in Congress. And I think that when we dangle federal money to get states to all kind of, do things that we command or that we're incentivizing, we're functionally federalizing that entire decision-making process. So while I have been supportive of clean slate provisions at the state level of various form and kind, I do think that doing it at the federal level is wrong, and I think that whether it's federal grants for local law enforcement, federal grants for criminal justice process issues, it all erodes our federalist system. It limits innovation and creativity at the state level, and it sort of imposes a monolithic view. And so while I certainly agree that the goals of the legislation are laudable, I think that the process endeavored upon is flawed. And I yield back to the gentleman from North Carolina.
And I thank the gentleman from Florida, and that point is well made. And it just seems to me, to your point, if you want to do it at the state level, part of my argument would apply even then. I just trust people more than I trust, the brilliance of the legislators in the General Assembly in North Carolina, for where I used to serve, and certainly the brilliance here. And I just note that the general philosophy of the left, which is to say, we're going to tell you what to do. I count on people to figure things out for the best. But even, Mr. Gates, the situation you described in Florida, that you've been an advocate for these things in Florida and the state, at least you have an opportunity then for experience to be a teacher, right? If you have, if you do that really aggressively in Florida, and then crime rates go up in Florida, then the people in North Carolina might not want to follow your example. Or contrarily, if it shows that, boy, it really makes a big difference, and people's lives are better, and recidivism falls, and crime falls, and employers are not really suffering any disadvantage, then North Carolina might want to follow you. But when you do this and you put the heavy hand of the federal government, and the other thing liberals always act is if the money's unlimited. This money will be borrowed from China. And that's something to think about in every occasion, but it never is thought about, and there's never any consideration of the dignity and the individual and the freedom of individuals, and I'm out of time.
Gentleman yields back. Who seeks recognition? For what purpose does the gentleman from California seek recognition?
Move to strike the last word.
Gentleman is recognized.
Mr. Chairman, I'd like to be for this, but I've got a couple of reasons that I won't be, and I just want to briefly go over them. One of them is I'm a Californian, and we have lost track of prosecution. We've lost track of penalties. We've created an environment in which our crime is rising because we're not even bothering to create the record on criminal behavior. And so it seems to be an inappropriate time to fund California's ability to wipe away the past as quickly as possible, while in fact not holding people accountable. Being less parochial to my state, though, you know, the bill that would have been first and now will be second deals legitimately with what we do at the federal level, what our clean slate proposal will be, what our expungement will be. And I'm sad that we're taking this one first, because I think we should have taken the federal one first. We are a national federal committee. Our primary responsibility, and certainly the primary responsibility of taxes, money taken involuntarily from the various states, is not to send it back to the states in the way of inducement. What we spend at the federal level on people who have been convicted of federal crimes and how we deal with the database is our first responsibility. Oddly enough, the bill that will be considered next, as far as I can see, doesn't have a similar funding. So I might suggest, if this were not to prevail, that this $250 million might be applied to what you want to accomplish in the database federally, since there's no authorization for money on that act. But having said that, I also would like to be very, very personal for a moment. To a certain extent, we are mandating this expungement in the idea that things will disappear, which is no longer realistic. If anyone wants to look at my Wikipedia, I would hope they wouldn't if they want to be my friend, but if they want to look at my Wikipedia, they'll probably still see that when I was a teenager, I had an unregistered firearm, and I pled to it. Now, it was expunged a generation ago, actually before databases. It should never have been in a searchable database, but not only did it find its way into a searchable database, but it showed up in the LA Times in a hit piece. So guess what? It is forever going to be part of Wikipedia. I was 18. It was an unconstitutional conviction then, and it was still an unconstitutional. I defiantly believe I did nothing wrong, and that the law was wrong, not me. But having said that, let's be honest. You no longer can expunge and expect something to disappear. It isn't part of the reality of our environment today. If anyone here were to be picked up as, for example, the Speaker of the House's husband was, it is not disappearing no matter what the outcome of the case is. It will be there on the internet forever. So it's one thing to pass laws, as we did on the Oversight Committee under Elijah Cummings, that say you cannot use this information in the determination of a job, a federal job. That's a good thing to consider, to give people that opportunity, that they not have that forever barring them. But it is unrealistic to believe that expunging databases is somehow going to change the ability to research and find it. It's going to be found. And if it isn't found when it needs to be found, it's even worse. So I will not be supporting a $250 million nice-to-have handed to the states so that they can have us pay for what is their responsibility. I will continue to support a sensible ability to have those who have done their time and need to get on with their lives and have sensible employment opportunities have them. And for that reason, I think I've explained why I'll be voting no, but I thank the chairman, and I yield back.
Gentleman yields back. Does anyone else seek recognition? If not, the question occurs on the amendment in the nature of a substitute. All in favor say aye. Aye. Opposed, no. And the Opinion of the, in the opinion of the chair, the ayes have it. The amendment is agreed to. The question occurs, reporting quorum being present. The question is on the motion to report the bill H.R. 5651 is amended favorably to the House. Those in favor respond by saying aye. Aye.
Aye.
Opposed, no. No. The ayes have it. Roll call is requested, and the clerk will call the roll.
Mr. Nadler.
Aye.
Mr. Nadler votes aye. Ms. Lofgren.
Aye.
Ms. Lofgren votes aye. Ms. Jackson Lee. Ms. Jackson Lee votes aye. Mr. Cohen. Mr. Cohen votes aye. Mr. Johnson of Georgia.
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch. Ms. Bass. Mr. Jeffries. Mr. Cicilline. Mr. Cicilline votes aye. Mr. Swalwell. Mr. Liu. Mr. Raskin.
Aye.
Mr. Raskin votes aye. Ms. Jayapal.
Aye.
Ms. Jayapal votes aye. Ms. Demmings.
Aye.
Ms. Demmings votes aye. Mr. Correa.
Aye.
Mr. Correa votes aye. Ms. Scanlon.
Aye.
Ms. Scanlon votes aye. Ms. Garcia.
Aye.
Ms. Garcia votes aye. Mr. Neguse.
Aye.
Mr. Neguse votes aye. Ms. McBath.
Aye.
Ms. McBath votes aye. Mr. Stanton.
Aye.
Mr. Stanton votes aye. Ms. Dean. Ms. Dean votes aye. Ms. Escobar.
Aye.
Ms. Escobar votes aye. Mr. Jones. Mr. Jones votes aye. Ms. Ross.
Sorry, Ross votes aye.
Ms. Ross votes aye. Ms. Bush.
Bush votes aye.
Ms. Bush votes aye. Mr. Jordan.
No.
Mr. Jordan votes no. Mr. Shabbat. Mr. Shabbat votes no. Mr. Gomert.
I vote no.
Mr. Gomert votes no. Mr. Issa.
No.
Mr. Issa votes no. Mr. Buck. Mr. Gates. Mr. Gates votes no. Mr. Johnson of Louisiana. Mr. Biggs. Mr. Biggs votes no. Mr. McClintock. Mr. McClintock votes no. Mr. Stubbe.
No.
Mr. Stubbe votes no. Mr. Tiffany. Mr. Massey. No. Mr. Massey votes no. Mr. Roy. Mr. Bishop. Mr. Bishop votes no. Ms. Fishbach. Ms. Fishbach votes no. Ms. Sparts. Ms. Sparts votes yes. Mr. Fitzgerald. Mr. Benz. Mr. Owens.
Owens, no.
Mr. Owens votes no.
Are there any other members who wish to be recorded, haven't been recorded?
Mr. Chairman, how am I recorded?
Mr. Buck, you are not recorded.
I vote no.
Mr. Buck votes no.
Mr. Liu?
Mr. Chair, how am I recorded?
Mr. Liu, you are not recorded.
I vote aye.
Mr. Liu votes aye.
Mr. Raskin?
Aye.
Who's that? Clerk will report.
Mr. Chairman, there are 22 ayes and 13 noes.
The ayes have it, and the bill is amended as ordered, reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 2864, the Clean Slate Act of 2021, for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 2864, to require automatic
Without
sealing.
objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 2864, the Clean Slate Act of 2022, is bipartisan legislation that would help millions of Americans with minor criminal records seal their federal criminal records so that they can find employment, housing, and have access to the economic and social opportunities that are necessary to rebuild their lives. Having a criminal record, even a record of an arrest without a conviction, can create lifelong obstacles that affect individuals, families, and society as a whole. This is because no matter its severity, a criminal record significantly impedes a person's ability to find a job and leads to lower earnings for those who are lucky enough to find jobs, fewer housing options, and fewer educational opportunities. And as many as 112 million Americans have some sort of criminal record. That's 1/3 of our population that is saddled by burdens that prevent them and their families from reaching their full potential. In recognition of these burdens, our states have been at the forefront of passing laws that allow individuals with criminal records relating to qualifying offenses to have their records sealed so that they can successfully compete for jobs, housing, and educational opportunities. At least 40 states have enacted some sort of clean slate legislation that allows people who have successfully completed all aspects of their sentences and post-sentence supervision to have their records sealed. But the federal criminal justice system lags far behind. Currently, there is no mechanism for the sealing of federal criminal records, with the very limited exception of the records of people under the age of 21 who are convicted of simple possession of narcotics. The Clean Slate Act aims to address this gap by providing for the automatic sealing of the records of all federal offenses relating to simple possession of controlled substances and nonviolent offenses relating to marijuana. Automatic sealing for these low-level offenses will eliminate the need for qualifying individuals to deal with forms, fees, and other barriers to record sealing. The Clean Slate Act would also create a new record sealing process for other qualifying nonviolent offenses, allowing certain individuals convicted of such offenses to petition a federal district court to have their records sealed. It is important to note that the Clean Slate Act would not allow for the sealing of records relating to violent offenses, sex offenses, or offenses related to terrorism or national security. It is intended only for nonviolent offenders and would apply only to those who have already fully paid their debt to society by completing every aspect of their federal sentence, including any prison term imposed and probation or supervised release. Nor would the bill impede law enforcement in any way. Law enforcement agencies and prosecutors would continue to have access to the sealed records and would be able to use them for law enforcement and prosecutorial purposes as they do today. What this legislation would do is prohibit the existence of a sealed record from being included in a background check, except for a background check in relation to employment for a position in law enforcement or employment involving firearms or controlled substances, and would allow individuals whose records have been sealed to decline to disclose the existence of any information contained in the sealed records without being subject to prosecution for perjury or making false statements. That way, when they're applying for jobs, housing, student loans, or any number of other opportunities, they will in fact start with a clean slate. This legislation is critical in helping those with nonviolent criminal records to rebuild their lives. Currently, 90% of employers conduct background checks on job applicants, and those with criminal records are 50% less likely to receive a callback than those whose records are clean. At a critical juncture of their lives, more than 60% of formerly imprisoned people remain unemployed a year after their release. The Clean Slate Act is an attempt to remedy this situation. This legislation is at its core a jobs bill. That's why Clean Slate legislation is supported by J.P. Morgan Chase, Walmart, and the Business Roundtable, among other prospective employers. It also enjoys widespread public support. Recent polls show that 71% of Americans support a federal Clean Slate Act. I thank Representatives Blunt Rochester and Reschenthaler for introducing this sorely needed piece of bipartisan legislation, and I urge all my colleagues to support the bill. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Thank you, Mr. Chairman. America's in the middle of a nationwide crime epidemic, especially in Democrat-run cities. Now is not the time to send a message that breaking the law will actually get rewarded. In 2020, the United States tallied more than 20,000 murders, the highest total since 1995, and 4,000 more than in 2019. In New York City, NYPD's data shows the overall crime rate rose over 11% in October 2021 compared to October 2020. This jump in crime continued after New York City defunded its police to the tune of $1 billion. Likewise, Los Angeles County homicides increased 23% over between 2020 and 2021. The increased homicide rate occurred after Los Angeles defunded its police department by $150 million. The legislation before us embraces a, quote, soft on crime approach favored by Democrats at a time when the American people need law and order more than ever. This bill requires the automatic sealing of records for certain drug offenders just 1 year after they've been released from prison. Many people convicted of simple drug possession were involved in more serious crimes, like drug smuggling, and pled down to a simple possession plea. Think about that. Under this bill, a drug trafficker could have his or her drug charge sealed just 1 year after release from prison. I think this is the wrong message to be sending, and particularly at a time when we see crime on the rise in every major urban area around the country. I urge opposition to this legislation and yield back the balance of our time.
Without objection, all other statements will be included in the record. And I recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 2.8.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I recognize myself to explain the amendment. Among other things, this amendment in the nature of a substitute changes the original bill text to clarify what types of violent and other offenses will disqualify an individual from petitioning to have their records sealed. It also provides exceptions to sealing for background checks relating to certain high-risk occupations. In addition, the ANS includes language to ensure that non-federal law enforcement will have access to federally sealed records for the purposes enumerated in the bill. I urge all members to support the amendment. I yield back the balance of my time. I now have an amendment to the amendment in nature of a substitute at the desk. The clerk will report the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 2.8.
Without objection, the amendment is considered as read, and I will recognize myself in support of the amendment. As we have continued to consider and discuss this bipartisan legislation, we have determined that the pilot program in Section 3 of the ANS could benefit from further refinement. I'm therefore moving to strike Section 3 from the bill so that we may continue to shape the contours of the pilot program in a way that best promotes the purposes of the bill. I urge all members to support the amendment, and I yield back the balance of my time. Does anyone else seek recognition? For what purpose does the gentleman from Florida seek recognition?
I have an amendment at the desk.
No, we're on an amendment.
All right, well, I have an amendment to your amendment. I yield back.
Does anyone else seek recognition on the amendment, on the Nadler amendment? For what purpose does the gentleman from Ohio seek recognition? Gentleman is recognized.
Thank you, Mr. Chairman. The goal of this legislation may be commendable, to provide individuals a second chance to meaningfully participate in society and contribute to their communities, but the unintended costs far outweigh its potential benefits. The legislation would automatically seal an individual's federal criminal record for conviction of or possession of a nonviolent offense involving marijuana. The legislation allows for offenders to petition for the sealing of certain criminal offenses. However, when deciding whether to seal a federal criminal record, the court may not consider an individual's state criminal record when making its assessment. When making its determination, the court should consider the totality of the circumstances, including a state criminal record that may include drug and
Would
alcohol
the gentleman yield
crimes.
for a moment?
Yes, I'd be happy to yield.
Yeah, what you said a moment ago is not correct.
All right.
The court may consider state convictions. The only thing it may not consider is state arrest that did not lead to a conviction.
All right, I stand corrected, but it's still bad legislation.
I yield back.
All right, and the bottom line really is here, this is once again, this is the third bill where we're essentially moving forward with Democrat soft on crime things. And the problem in this country isn't that we're too tough on criminals, it's that we're too weak on criminals and we're not standing up for the law-abiding public. We're essentially, and if you look at what's going on in state after state, particularly in the Democrat-controlled cities, the public is just outraged at the behavior that's occurring, the victimization of law-abiding citizens. The Democrats' solution over and over is, oh, well, let's just take away the guns, even though there's more guns out there than there are American citizens right now. And it's not the law-abiding citizens who essentially don't break the laws. It's the criminals that are committing the crimes, and it's prosecutors who won't enforce the law anymore because you got a bunch of leftists who have been pushing these left-wing prosecutors on the public, and they're not enforcing the law. And rather than pointing the finger at the criminals who are committing the crimes, they're essentially blaming the police. And that's where the defunding police comes in, and not every Democrat in Congress is for that, but an awful lot are, and there are Democrats across the country that are also pushing this defund the police agenda. So rather than waste our time on this type of legislation, which I would put in the category, again, of soft on crime legislation, we ought to be focused on enforcing the law, and when criminals commit crimes, they ought to go jail, and they ought to stay there. And yes, most, unless it's a particularly heinous murder, they're oftentimes going to be released at some point. And I do think it's in society's interest to get them the skills that ultimately they can come out and hopefully not go back to prison and not prey on the public, for example. Unfortunately, there still is far too much recidivism in the country, and they do end up going back for good reason because they've committed more crime. But I would say to my colleagues on the other side, they ought to stay focused on the real problem, and that's that crime has been rampant in this country, and we need to have secure neighborhoods and secure cities as well, and that's the problem is principally in the cities, although it's all over the place. This just isn't the answer. So for that reason, I'm opposed to the legislation, and I yield back.
Gentleman yields back. Are there any further? For what purposes, Ms. Jackson-Lee seek recognition? Gentlelady is recognized.
Well, I want to do something to make Mr. Shabbat happy, and apparently he's not happy with any of the bills that are giving a second chance to individuals who have been, if you will.
One moment, please. What is the stenographer? Everything okay?
Okay. To strike the last, who have seemingly been stifled by not having the opportunity to have their records expunged or cleaned. And frankly, there is no quarrel about this approach to criminal justice reform. Voters across party lines support clean slate legislation, as indicated by an article that I asked unanimous consent to be put in the record dated June 20th, 2018.
Without objection.
So it has been going on. Nearly 7 in 10 American voters support the legalization of marijuana. We've already done that. 7 in 10 voters support efforts to automatically seal the records of nonviolent offenders. We know that the height of incarceration, the 80s and the 90s, were clearly examples of over-obsessiveness with thinking that low percentage drug offenders were going to solve the crime issue. Now, we're not discussing this right now, but we know that the proliferation of guns, which I wish my colleagues would support, in the regularization of gun safety laws that we have worked to pass, is really what's elevating the crime here in America and all cities. There is no bias of one city's political leadership versus another city's. It's every city, every rural hamlet that is facing this uptick. And it is a variety of issues dealing with this question. Race has something to deal with it. Lack of education has something to deal with. Lack of investment in intervention has something to deal with. That is why these expungement laws that we've just debated and now H.R. 2864, the Clean Slate Act, is so important. Today, there are over 100 million Americans living with a criminal record, a record that can mean a life sentence to joblessness, homelessness, and poverty, a sentence which no judge ever imposed or intended. But that's what continues. Because we know that 9 in 10 employees, as I've said previously, 4 of 5 landlords, 3 of 5 universities conduct criminal background checks on applicants, people with even minor criminal records lose countless opportunities, those who've just been arrested due to minor crimes they committed decades ago or for crimes for which they were merely arrested with no charges ever being filed. Here are the facts. 1 in 3 U.S. adults have been arrested by the age of 23. And while this problem affects all of us, as the burdens of criminal records lower our nation's economic productivity as much as $87 billion per year, the impact falls heavily on communities of color, as I've indicated previously in the Terry debate, in the debate on the previous legislation, and African-American men are 6 times more likely, and Latino men are 2.5 times more likely to be incarcerated than white men. My friends cannot ignore these glaring numbers. Criminal records create lasting burdens that are intergenerational. Nearly half of all American children have at least one parent who has a criminal record, which impacts that parent's ability to provide for their child. But there is hope. Almost every state has some sort of record-sealing expungement statute to allow people to move on with their lives and help their families. And evidence has shown that these laws promote public safety by increasing access to jobs, housing, and other opportunities that promote community reintegration and stability, and not a life of crime. It is long past time to bring a redemption to the federal system. Those who pay their debt to society deserve to have their slates wiped clean. The Clean Slate Act of 2022 would do just that. This historic bipartisan legislation would, for the first time, establish automatic record sealing for low-level drug offenders, and it would create a new path for sealing the records of other nonviolent offenses by petitions filed in the court through the federal system. Following the lead of the states, we can also learn from existing expungement and record sealing opportunities. In my own state of Texas, current law allows people the opportunity to clear certain criminal records, but the process is difficult to navigate, preventing many eligible people from obtaining that relief to which they are entitled. They have to be all huge programs. I ask my colleagues to recognize the importance of the Clean Slate Act, which avoids pitfalls. It helps other nonviolent offenders, and the Act provides a streamlined approach that gives petitioners, prosecutors, and even victims the right to be heard on whether a person's record should be sealed. It also provides counsel. Finally, recognizing law enforcement legitimate need to access an individual's complete criminal record, it ensures that officers and prosecutors would have access to records that are sealed under the Act. I ask my colleagues to support this very thoughtful legislation and thank Lisa Blunt Rochester and Restenthaler for their work, and other members who've joined on this. They worked real hard, real long, and we ask our colleagues to join them in this legislation. I yield back, Mr. Chairman. Thank you.
Gentlelady yields back for purpose is Ms. Sparks to seek recognition.
I move to strike the last word.
Gentlelady is recognized.
I want to bring 2 things. First, I want to echo my Republican colleagues that we do have serious concerns with crimes, and it's a very serious situation, and what's happening at our border has to be dealt. I hope we can deal with it on a bipartisan basis, because drug trafficking, human trafficking is becoming very significant, and we have a very powerful cartel that's making a lot of money, and it poses a lot of dangers, and I'm not going to cover all of them now. But we also need to think about a few other issues. And I was a state senator and was involved with and the majority of crimes we deal with are really state crimes that states do, and states really need to look seriously on the reforms, and some states to do terrible enforcement, and this needs to happen. But I also deal with a lot of issues where I, as a state senator, had a hard time dealing with the federal government for some people that be able to restore some constitutional rights, to be able to be having second chance in life, and I think it's a big problem. So because federal government is not very responsive anymore to the state government. So I might support it for different reasons than some of my Democrat colleagues, but I think we need to be a society where we have crimes, have a proper punishment, and punishment has to fit the crime, and let some people to be rehabilitated, let people go back into the society, but we do need to have a mechanism for that. So I'm looking supporting these bills just because there is some way should be facilitation, and states, should be able to help people to deal with some of these federal crimes and records that can really suppress opportunities for people to go back and have a good life and be able, be contributing member of society and be able to have all of the constitutional rights that given Constitution after they did their dues and punished for what they did wrong. So especially for some low-level crimes. But we also cannot be a society where we constantly, allow people to get away with bad behaviors. The mechanism needs to happen. So there are legitimate points from both sides, but I am willing to address this issue, which is an important issue for a lot of people and affect very detrimental some people's lives, because we have, for example, terrible licenses law, different things, and people have bad access to be able to get good jobs, and that is something that we have to do a better job. But I'm willing to find common ground maybe on a narrow basis on these issues, but I also think we as an institution, we as this committee that has jurisdiction over immigration, over criminal justice system, we have a responsibility also to look, how we can do a better job, make sure that our criminal justice system is addressing significant material issues that we have especially in our big urban city, and I represent one of them. Indianapolis has actually higher crimes per capita now than Chicago, which is a very, very serious situation. And we deal with our border security and improve our legal immigration. I think this committee has an enormous amount of opportunity to look at these big issues that are very material for our country and find common ground. So I hope we will be able to do that at some point, maybe not before November, probably not before November, but at some point maybe we can find common ground, because this is the issues that are important for our country. This is issues that are important for our republic and important for the people we represent. So I'm supporting this bill because I know how important to have the second chances. But I think if we don't have proper mechanism and proper enforcement and proper reform in border security, we are going to have a big problem in our country, and we will have criminals controlling our country. And we do not want to have anarchy. We're a country of law and order, and we are not anarchy. And we sometimes moving into direction in some of these areas. So I will support this bill, and I hope we'll have a further collaboration and very important issues that my Republican colleagues brought up in this committee, because they are material, they're serious, and it is not a joke what's happening right now. We have real lives at stakes of a lot of people, as people that in the system, but as people get affected by criminals. And when we're dealing with people's lives, we have to take it seriously, because it's not just a paper, it's not just a bill. This is human lives of a lot of people. So I urge maybe some of my Republican colleagues to consider this, but I also understand why a lot of them will not support it. I yield back.
Gentlelady yields back for purposes. The gentlelady from Pennsylvania seek recognition.
I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman. I rise in support of this life-changing bill, the Clean Slate Act. And I'm pleased, delighted to hear of the support and the willingness to work with the gentlelady across the aisle. I know that we will be pleased to work with you. But let me be clear about a couple of things. I want to make sure that this bill is not used improperly or mistakenly. We're not talking about sealing the records of sex offenders. We're not talking about sealing the records of terrorists. We're not talking about sealing the records of those who committed violent crimes. We're talking about giving Americans access to the basic elements of life through sealing of records. We want Americans to be able to find an apartment. We want Americans to be able to get a job. We want Americans to be able to claim their own education. These basic needs and aspirations are often blocked for everyday Americans who have fallen victim to over-criminalization in our country. As has been said, 1 in 3 Americans have some type of criminal record that shows up if it is not sealed in a routine background check. The Clean Slate Act will automatically seal the records of nonviolent drug-related crimes and create a streamlined record sealing process for other qualifying nonviolent crimes. In Pennsylvania, the most common approach is filing a petition to have one's record sealed. But who is eligible? How can you apply? When do you apply? What is the cost? For average Americans, these complexities can be daunting. Once Americans complete their sentences and prove they will not commit new crimes, I truly believe they deserve the opportunity to become productive members of society. By supporting the Clean Slate Act, we can give Americans a second chance to live productive, fulfilling lives. I urge strong support for the Clean Slate Act, and Mr. Chairman, I yield back.
Gentlelady yields back. Who seeks recognition? For what purpose does the gentleman from North Carolina seek recognition?
To speak on the bill.
Gentleman is recognized.
You know, a couple things. I wonder whether anybody on the other side has any insight on this. There is, the Supreme Court of the United States has recognized a First Amendment-based right of public access to court records. And so every time currently a federal court seals a record, they go through this analysis predicated on what the factors are there. And if it's a record that falls within the concept of what they believe to be a judicial record, then there has to be any provision requiring it to be sealed must be narrowly tailored to a compelling state interest. It can't just be sort of a policy disagreement over which would be best. So I would think initially that says essentially blanket rule, as soon as you've had a year after your conviction on a whole host of crimes, the presumption is it's got to be sealed, and the government bears the burden of showing that it shouldn't be. I don't think that's akin to the typical expunction law that's individuated, generally takes a long period of time, and the person comes in and shows they had a long history of compliance with the law. You don't have anything like that here, and you're taking something to which the public has a constitutional right under the First Amendment. There are 4 seminal cases, a couple of them in which Justice Brennan played a big role. Right now, I'm drawing a blank on what their names are, but a couple came out of California. Anyways, developed over the course of the last 20, 30 years to be a very robust First Amendment protection. I think you're violating that with this statute, but I'd be curious if somebody has a reaction to it. The other thing that strikes me as I look at this is, you know, it's hard to anticipate all of the crimes that seem to be covered, because it says, you know, nonviolent crimes, and anything that other than, and then it gives a list of the things that would not be included. That leaves everything else out there. One that strikes me is financial crimes, embezzlement, securities frauds, all of that. So you take, and it's funny, there's a place in here where you have an exception for law enforcement. You know, if somebody's going to be hired for a law enforcement job or for certain other government jobs, you provide an exception. They can consider these crimes. They can get access to the information. But out there in the private sector, if you're trying to deal with somebody who's a scofflaw and a serial embezzler, or maybe serial is not the right word to use, but somebody who's engaged in embezzlement against an employer, I think this automatic sealing, the 1-year time frame, the presumption in favor of doing it, all appears to apply. I would certainly associate myself with the comments, for example, of Mr. Shabbat, who talks to you about how it's just a continuation of a soft-on-crime mentality that's just destroying people's lives out in America with burgeoning crime, and you ought to be going the other direction. But how about those specific things? The fact that it seems to be unconstitutional in violation of the First Amendment right of public access to court records in the absence of a compelling government interest and narrowly tailored exceptions, and the fact that frauds don't seem to be, you're just ripping away the protection of people from learning about people who've been inclined toward various forms of fraud when they have to engage in employment decisions. With that, I yield back. Well, I'll see if anybody else wants time, and seeing none and hearing no one volunteering to address the concerns I raised, I guess because it can't be addressed, I'll yield back.
The gentleman yields back for For what purpose does the gentleman from Rhode Island seek recognition?
I move to strike the last word.
The gentleman is recognized.
Thank you, Mr. Chairman, and thank you for bringing this important bill to a markup. According to the Department of Justice, nearly 1 in 3 Americans have some type of criminal record. The consequences of a criminal record, even without a conviction, can last a lifetime, creating barriers to accessing safe housing, employment, professional licenses, and even something as basic as a government identification. When formerly incarcerated people have their basic needs met, like a safe place to live and stable employment, it can significantly reduce the likelihood they will commit a new offense, and as a result, make our communities safer. Yet, especially as technology makes it easier to do, a majority of employers and landlords run background checks on potential employees and tenants. This makes it harder for individuals with criminal records, even minor ones, to find the stability they need to move on with their lives. And this, let me just quickly reject this notion by our Republican colleagues that somehow smart, good public policy that will make communities safer means you're soft on crime. I'm not going to be lectured by anybody on that side of the aisle. I was mayor of a city for 8 years. And in that role, I served as the Public Safety Commissioner for the city of Providence. I didn't fill that position, and it brought about the lowest crime rate in 40 years by making sure we support good policing and we hold police officers accountable. So I'm not going to be lectured by Republicans about being soft on crime. The reality is, if you're serious about reducing crime, making certain that people can re-enter the community safely and have a path to success reduces the likelihood that people will re-offend and commit more crimes. This is not a complicated idea. And in fact, research shows that record sealing and expungement can counteract these trends of reoffending. In fact, a study in Michigan found that individuals who received expungement earned 22% higher wages and had just a 2.6% of expungement recipients were rearrested for a violent offense within 5 years of receiving their expungement. The Clean Slate Act will automatically seal the records of individuals convicted of non-violent federal offenses and create a process for individuals with other qualifying non-violent criminal records to petition the courts to have their federal records sealed. This will remove barriers to employment, housing, education, and other services that individuals need to successfully rebuild their lives. This is not only essential to ensuring those with non-violent records can re-enter society and provide for themselves and their families, but also it will boost our workforce, a particularly important benefit today as America faces massive labor shortages. And so for those of us that are really interested in policies that will reduce crime, making it possible for those who have committed an offense to re-enter the community successfully. When I was mayor, we created a re-entry council because one of the impediments was even minor convictions or contact with the law made it incredibly difficult for people to find work, find a landlord willing to take them as a tenant, get the papers necessary to have a proper identification, and the list goes on and on. You know, people talk a lot about the ability of people to redeem themselves and pay for their wrongdoing and acknowledge their wrongdoing and then move on with their lives. That's the whole principle of rehabilitation. And these expungements are essential. I can tell you that as a member of Congress, I continue to get contacted by my constituents who've had some minor contact, but because it could not be expunged, they are finding it impossible to get a job, to find a place to live, to take care of their families. This creates enormous stress and it increases the likelihood that person will reoffend. So if we're serious about public safety and we don't want to just use it in a television ad, here's something you can do about it. Pass this bill, and with that, Mr. Chairman, I yield back.
Gentleman yields back. For what purpose does the gentleman from Tennessee seek recognition?
Strike the last word.
Gentleman is recognized.
I want to let Mr. Bishop know that he's going to love the new Fresh Start Act when it gets here because it takes into consideration financial crimes, and over a certain amount of money, you cannot participate.
Glad you'll be against this one, Mr. Cohen.
And then I do my other job, and that's to yield to Ms. Jackson Lee.
I thank you so very much. The Crime Subcommittee is pleased to be part of helping to rebuild Americans' lives and hope that our colleagues will be on the floor of the House agreeing with a huge number of advocates and support across America. Let me now emphasize some points that are important. One, this whole down a rabbit hole misdirection of crime. As I said, crime is uptick everywhere, and it has surged after the pandemic for a variety of reasons. Certainly in my state, where you don't even have to put a dot on a piece of paper to get a gun. It's a field day for criminals. Open carry, permitless carry. That's Texas' contribution to the surge in crime. And our law enforcement officers, my friends, in Houston and beyond, are struggling every day. A father went out for whatever reasons with his 2-year-old in the car seat. He's dead and the 2-year-old is dead. I'm mad as heck. Mad as heck. He was killed with a gun. Killed with a gun. So what we're trying to do is to take a detour for these individuals with low offenses as it relates to drugs. And law enforcement will not be blocked from opening and accessing these records under this legislation, H.R. 2864, because it ensures officers and prosecutors would have access to the records. The sealed records would not, however, be disclosed as part of a routine backup check, as I said before, of employment, housing, or other services, unless the employment is potentially with law enforcement, or firearms, or controlled substances. Under other circumstances, including applications for countless other services, that people need to rebuild their lives. They need to restore their lives. They need to be different from the same pattern that they were in before. They need to be accessed job training. They need to be accessed how to handle your finances, how to be a good parent. All of that are services that could be denied. And they can go forward knowing that their past will no longer stop them from getting jobs. Two of the major corporations in America, Walmart, JP Chase, a bank, have supported this legislation. And it is clear that they understand at a time industries are facing labor shortages. Everywhere it is more necessary to have full employment with people who can restore their lives and be contributing Americans. 1 in 3 Americans have a criminal record. That's shocking. I wish that wasn't the case. All around, mostly drugs. And the lifelong barriers create a lifelong of poverty, moving from place to place, getting one job after another, being terminated when the employer finally looks up and says, oh, you have a criminal record, or showing up with your neat, shiny shoes and a brand new suit that you may have gotten from Goodwill and doing your best in the interview, and then they find out that you had some criminal activity 5 years ago, 10 years ago, that was a low offense. And our states have shown us that they have this kind of program. But as I said, the states are too complicated. You've got to jump over hurdles, climb trees, and fly to the moon. Families are suffering, starving, being hungry because we have this kind of circumstance. So I'm pretty tough on us not doing this in the right way. The Terry fix that we just passed to not discriminate against people who have an infinitesimal amount of crack or drugs versus those who had a big amount and didn't get retroactivity under the first step. That's going to help a lot of people. The number is about 200, but it may help some others. So I'm grateful to Lisa Blunt Rochester and to Rutz Holler, who was on this committee with us before. And I want to indicate that Walmart has specifically said this would help to ensure that all people, regardless of background, can pursue a career with meaningful work. We urge the committee to act, ask unanimous consent to put that into the record, Mr. Chairman.
Without objection.
And then I would also add, again, how about this? Americans for Tax Reform, Brennan Center for Justice, Business Roundtable, Center for American Progress, Code for America, Community Legal Services, JP Chase, Walmart, R Street Institute, The Third Way, Americans for Prosperity, Right on Crime. A combination of diverse groups supporting this legislation. I ask my colleagues to support it, and I hope we can call for the question. I yield back.
Gentlelady yields back.
I seek recognition.
Oh,
I yield to Mr. Gates.
the gentleman's time has expired.
What purpose does Mr. Gates?
For what purpose does the gentleman from Florida seek recognition?
I move to strike the last word.
Gentleman is recognized.
Thank you. All of the groups and businesses in corporate America that the gentlelady from Texas just mentioned can hire whoever they want now. Like if they want to go hire people with criminal records, there's nothing in the law that stops them. And if they want to be willfully ignorant or informed as to the background of the people that are applying, there is no prohibition. And so the enthusiasm is a bit confusing because they are in control of their own destiny. Similarly, I heard the gentleman from Texas be hypercritical of open carry and constitutional carry, and I am an enthusiastic supporter of both of those measures, and had the great privilege to be in the wonderful Houston area recently and saw folks vindicating their Second Amendment rights by openly carrying, and I just thought it kept everybody real cordial and felt real safe there, and enjoyed it a great deal. I yield to Mr. Bishop.
I thank the gentleman. I appreciate Mr. Cohen's acknowledgement that not dealing or addressing financial and fraud crimes in this statute is a problem. And I thought I'd just elaborate something I said before, maybe just trace over, elaborate just a bit more. So there are exceptions here. If the law enforcement can access these records otherwise sealed to the public for investigatory or prosecutorial purposes, for a background check that relates to employment with a law enforcement agency, any position that a federal agency designates as a national security position or high-risk public trust position, so maybe all the 87,000 IRS agents, I don't know, manufacture, importation, sale, transfer, possession, or carrying of firearms, explosives, or ammunition, employment for somebody in the in an area, in a business that is defined under the Controlled Substances Act as somebody handling the importation, sale, or transfer of controlled substances. So all those things, and I guess that's private enterprise, right? That last one. All this other stuff you're protecting government. But what about somebody who's got to hire for a bank tellers? What about every business out there that needs to hire a bookkeeper and needs to know whether the person's been convicted of financial crimes or embezzlement, a bookkeeper or a controller? What about somebody who's been convicted of laundering money for a criminal cartel? That's not within the excluded crimes here. Somebody who's been convicted solely of laundering money for terrorists, but is otherwise
Well,
not part of their...
Mr. Bishop, I mean, aren't those wrong place, wrong time kind of crimes? I mean, you've heard our colleagues on in the majority talk about folks who just, they end up in the wrong position, maybe made a wrong choice.
You don't want somebody's life to be defined.
Why do you lack such empathy for those who are engaged in financing terrorist organizations and money laundering for cartels?
How about this one, Mr. Gates? I appreciate that. They have one exception here, or one of the excluded offenses is domestic violence, interstate domestic violence, but there's no exception for somebody who's been convicted under Title 18, Section 117 for domestic violence by a habitual offender on federal property. Why not? Is there some reason that the committer of domestic violence on federal property should have their life defined by the offense, but the person who travels interstate to commit domestic violence should not?
You're underscoring Mr. Rice's point earlier that when we get into parsing out these individual offenses, we invariably are going to cut the cloth wrong and incorrectly in one area or another. And rather than trying to use the strong arm of the federal government to really put a blindfold on private enterprise as they seek to engage a workforce, why not just become maybe a little more graceful society? Maybe here it's not a law that is needed, but the understanding that in our places of work, if someone did in fact have a drug offense, a nonviolent offense, an offense that wouldn't directly affect employment, we ought to be more caring. I don't think you can legislate around the hearts of people in middle management making hiring decisions, and maybe it's a cultural issue perhaps more than a legal one. I'd yield back to the gentleman from North Carolina.
But if you're balancing these things out and you're undertaking to do that, it does seem to me that the question ought to be, at the end of the day, shouldn't your care be reserved for folks out there in ordinary private life in America who are trying to get by and are going to be subject to being re-victimized by crime because they're deprived of information they'd like to have access to? But we're always solicitous of government, of the federal agency, of the 87,000 IRS agents. Make sure the IRS is effective when they come down on Americans. Yield back.
Gentleman yields back. Does anyone else seek recognition? In that case, the question occurs on the amendment. All in favor of the amendment say aye. Aye?
Aye.
Opposed, no? In the opinion of the chair, the ayes have it. The amendment is agreed to. For what purposes does Mr. Owens seek recognition? For what purpose does Mr. Owens seek recognition?
Mr. Chairman, I'd like to strike the last word.
The gentleman is recognized.
Mr. Chairman, I would like to unanimous consent to submit for the record a letter written by friends Brett Tolman and Lars Tredman at the organization Right on Crime in support of HR 2864.
Without
Some of my
objection.
colleagues,
Without objection.
some of my colleagues might remember Brett Tolman, who testified before the crime subcommittee last year. Brett is the executive director for Right on Crime, a conservative organization dedicated to criminal justice policies that promote public safety and individual liberty and whole communities. Brett previously served as a United States attorney for the District of Utah, as an assistant U.S. attorney and chief counsel for the crime and terrorism for the United States Senate Judiciary Committee under Chairman Orrin Hatch. I'd like to submit Brett's entire letter for the record. Would like to share a few thoughts, a few highlights. Providing for an opportunity for deserving individuals to seal their records from the view of most members of public, not law enforcement, is an important rehabilitative tool that makes it easier for these individuals to contribute as productive members of society and avoid reoffending. Even a relatively minor entry on a criminal record, including one not resulting in any conviction, can make it more difficult for that individual to access employment, housing, and other opportunities. While sometimes these barriers are logical and clearly within the public interest, preventing a sex offender from working at a child care facility, for instance, frequently they bear little relationship to the offense or public safety. To the contrary, by placing barriers between the person and gainful unemployment or some other basic needs, they might make rehabilitation more difficult and recidivism more likely. Sensible public policy should therefore provide a means by which deserving individuals can eliminate or reduce these impediments. Record sealing, which preserves the underlying record for law enforcement purposes, provide exactly such an avenue. And that's the end of the portion of the letter I'm reading. I would like to add a few more points about the Clean Slate Act. This bill does not allow sex offenders to seal their records. This bill would not allow those convicted of terrorism, treason, or other national security related offenses to seal their records. This bill would not allow for sealing of records if a petitioner has been convicted of other violent crimes. I believe this is a common sense solution to help non-violent offenders leave their drug crimes in the past and join the workforce when so many of our industries are in crisis for workforce shortage. I urge my colleagues to join me in supporting the this Clean Slate Act. Thank you. Now you.
Gentleman yields back. Who seeks recognition? For what purpose does the gentleman from Florida seek recognition?
I have an amendment at the desk.
The clerk will report the amendment.
Mr. Chairman, I reserve a point of order.
Point of order is reserved.
Amendment to the amendment in the nature of a substitute to HR 2864.
Without objection, further reading the amendment is the amendment is considered as read, and the gentleman is recognized for 5 minutes to explain his amendment.
Thank you, Mr. Chairman. This amendment limits the opportunities in the legislation for expungement to those who are U.S. citizens. When I originally reviewed the bill, I thought it purported to be a right-on-crime bill, and I wanted to be open-minded and think through many of the points that have been made in debate today. But what I've come to learn is that this bill is actually an immigration bill in drag. And the provisions of the bill that would limit the ability to ascertain whether or not an offense had been committed by some government officials would limit the ability to decipher where there had been disqualifying offenses for immigration into the United States. For example, if a consular's office was determining whether or not to grant a visa to a non-U.S. citizen who wanted to come to the United States, they would not be able to have full access to that information. And with an immigration system right now in shambles, with a border that has been converted to a turnstile, I don't think we should make it harder for the administration of an immigration system that would stop people from coming to our country who are not U.S. citizens and who have committed otherwise disqualifying offenses. That's the amendment. I yield back.
Gentleman yields back. I recognize myself in, does this gentleman insist on his point of order?
I do not, Mr. Chairman.
The point of order is withdrawn. I recognize myself in opposition to the amendment. This amendment is completely, frankly, absurd. The expungement provisions have nothing to do with whether someone is a citizen of the United States, and considerations behind them have nothing to do. I'm sorry, the sealing provisions have nothing to do with the citizenship of someone in the United States, and has nothing to do with immigration. If someone lawfully present in the United States commits a crime, then under the same circumstances as any citizen, his crime, his record should be sealed. If his record should not be sealed, under the same considerations as any other person. If the person is unlawfully present in the United States, he should be deported. But this amendment has nothing to do with any of that. I don't understand the point of the amendment. A record should be sealed.
Chairman, yield?
Yes, I will.
Because the bill covers them. If they're if they're in the United States unlawfully and they are convicted of such a crime and they stay around for the year, they get the benefit of this bill, don't they?
Sealing does not expunge the record, and DHS can still access the record.
Well, I understand DHS, but the public can't.
Also, neither can
Well,
a
the
consular.
public should not be able to, under the same considerations as anybody else. And of course, if the person is undocumented, they can't legally work in any
Will
of
the
it.
chairman yield for a question?
Yes, I will.
How would a consular's office access that information under the provision that would allow the DHS to?
It allows for investigation. The answer is that the bill allows for investigations under such circumstances.
Would the chairman yield for a follow-up question? So, as the chairman reads the investigation provision, it's your belief that that provision applies to an investigation that a consular would do on an immigration matter, not necessarily an investigation into criminal conduct? I'm just trying to understand how you see the word investigation playing out practically.
Well, wait a minute. The consular office is part of the Department of State, and I wouldn't do an investigation if the country's already if the person's already in the country. DHS, however, can do such an investigation.
Well, it's just not relevant.
Yeah,
It's just not relevant.
Well, but would a consular's activity to determine this information be considered an investigation within the construct of the bill? And I ask that question because it seems...
Yes.
But it seems as though the bill, and I believe Mr. Bishop has the provision, limits that investigation to law enforcement activity. And if the consular's office is in the Department of State doing that immigration activity, it's not, it is modified by whether or not it's law enforcement.
It does not. But if you'd like an amendment to clarify that point.
But Mr. Chairman, if you look at
There's a law enforcement function within the
page
state.
7, line 15. Page 7, line 15 is where you see that it has to be a law enforcement activity, and it's only below that on page 7 at line 22.
And the State Department is able to...
I yield to the gentleman from
The
Rhode
State
Island.
Department has the ability to do and performs law enforcement functions. So it's not limited to just an agency. It's a law enforcement function, which would cover any law enforcement function of any department. And Mr. Chairman, if you'll yield, you are absolutely right. This has nothing to do with immigration. Don't struggle too hard to try to figure out the amendment. This is an effort to take a piece of legislation that will make communities safer by allowing people to successfully re-enter and jam in an immigration question so they can be on Fox News talking about immigration. Let's be honest. I yield back.
It's his time, right? Oh, then I'll yield back to. Does anyone else seek recognition? For what purpose does Mr. Johnson of Louisiana seek recognition?
Strike last word.
Gentleman is recognized.
Yield to the gentleman from Florida.
I'll assure my friends and colleagues that one does not require a right on crime bill to go on Fox News and talk about immigration.
Oh, we know that.
One would simply have to go to Martha's Vineyard.
We understand.
And see deportation work.
See human trafficking at work. Yes, no question about it.
Efficiency.
Yes.
But back to the bill at hand. My concern is that on page 7, if you go to line 22 where it talks about the investigations, that is all shelled within what constitutes law enforcement activity. And while I heard the gentleman from Rhode Island assert that the activities of a consular when evaluating a visa request from someone from India would somehow be considered law enforcement. I don't think that's true. I don't think that's clear in the legislation. I think there's no law one is seeking to enforce. There's no criminal matter. It's a determination as to whether or not one can come in the country. I would yield to the gentleman from Rhode Island if he would like to maybe point out what I've missed there.
No, I'm happy. I think the legislation makes it clear that for law enforcement functions and determining whether or not someone is lawfully in the United States has a law enforcement component, it would be covered by the proposed legislation.
Okay, yeah, I don't think that's true. And then here's what the American people need to know about this bill now, okay? This bill is not for, the person who as a teenager made a mistake and now wants to contribute to society and we want to create a good on-ramp to a productive life. Now what the bill is it is a shield for people wanting to come to our country who are not citizens so that we don't get to know the full picture.
Will the gentleman yield I don't want you to... I'm sorry?
It's actually Mr. Johnson's.
Oh, Mr. Johnson, will you yield?
I'll yield.
Okay, just to be clear, this statute is not available for people outside of the United States. So this argument that somehow people who want to come to the United States are going to go to court and get something expunged before they arrive here, that simply isn't true. So this notion that somehow this is helping people come into the United States, not true.
Okay,
if you are outside the United States, you are not eligible to get an expungement for something that happened in the United States.
We are almost at bump stock level of misunderstanding here, my friend. There are, I know this may surprise some, but there are people who actually come to the United States, leave, and then seek to come back. So the scenario I'm describing, let's say someone from India had come to the United States, had committed an offense, availed themselves to the provisions of this bill, went back to India, wanted to return with a visa. There is no way the consular's office would be able to get that information in this bill, which means this bill is now a shield for people who are not citizens of our country, not our fellow Americans. It's about something vastly different. I'll yield back to the gentleman from Louisiana.
Yield, Ms. Bishop.
I think the gentleman from Louisiana. I'll give an example. In North Carolina on August 12, 2 illegal aliens murdered a sheriff's deputy in Wake County. It's since emerged in news that they have a brother who also is in North Carolina, also illegal, entered as an unaccompanied minor. He's been arrested for possession of ammunition by an illegal. If he had the conviction on that, as best I can read under this bill, because there are exceptions for firearm possession and there's exception for explosive materials, but this individual, this illegal, he'd be entitled to expungement of a conviction within a year for that offense, as best I can tell.
Would the gentleman yield?
And it's not my time. I'll yield back to Mr. Johnson.
Yeah, I think that analysis is right, and in the 1 minute I have left, I cannot help but share the data that we got this morning that should be the most alarming thing among all the conversations, and that is that we have shocking numbers. We're talking about the border here and illegals coming in. We have shocking numbers of known terrorists who are now entering the country every day.
Would the gentleman yield?
I will not. We've caught 78 this year alone. And what we all know here, all of us know, the Biden administration has no idea how many are here among the 1 million plus gotaways who've entered streamed over the border, how many terrorist cells are set up. And as this gentleman, Tom Feely, who's the former director of New York ICE Removals, New York, he said this morning, we'll never know they're here until it's too late. This is happening. Everybody knows it. Administration, Secretary Mayorkas, doing nothing about it. I'm not sure there's anything more important that we could discuss. I yield to Mr. Bishop. You have something else?
The only thing I'd add is if a bill like this, you could clean that possibility up at least in this bill.
Sure.
If they just take this amendment, but they won't even do that, even facing the circumstances that you just accurately described.
Mr. Bishop, they're not interested in solving the problem, and that's clear for all the American people. I yield back.
Gentleman yields back. Well seeks recognition. In that case, the question occurs on the amendment. All in favor of the amendment, say aye. Opposed, no. No. In the opinion of the chair, the noes have it. Roll call is requested. The clerk will call the roll.
Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson-Lee? Ms. Jackson-Lee votes no. Mr. Cohen? Mr. Johnson of Georgia. Mr. Johnson of Georgia. Mr. Deutsch. Ms. Bass. Mr. Jeffries. Mr. Cicilline. Mr. Cicilline votes no. Mr. Swalwell. Mr. Liu. Mr. Raskin. Ms. Jayapal.
Jayapal votes no.
Ms. Jayapal votes no. Ms. Demmings. Mr. Correa.
Correa votes no.
Mr. Correa votes no. Ms. Scanlon.
No.
Ms. Scanlon votes no. Ms. Garcia.
No.
Ms. Garcia votes no. Mr. Neguse. Ms. McBath.
McBath votes no.
Ms. McBath votes no. Mr. Stanton.
No.
Mr. Stanton votes no. Ms. Dean.
No.
Ms. Dean votes no. Ms. Escobar.
No.
Ms. Escobar votes no. Mr. Jones. Ms. Ross.
Ross votes no.
Ms. Ross votes no. Ms. Bush.
Bush votes no.
Ms. Bush votes no. Mr. Jordan. Mr. Jordan. Mr. Jordan votes yes. Mr. Shabbat. Mr. Shabbat votes aye. Mr. Gomert.
Aye.
Mr. Gomert votes aye. Mr. Issa. Mr. Buck. Mr. Gates. Mr. Gates votes aye. Mr. Johnson of Louisiana. Mr. Johnson of Louisiana votes aye. Mr. Biggs.
No.
Mr. Biggs votes no. Mr. McClintock. Mr. McClintock votes aye. Mr. Stubbe. Mr. Tiffany.
Tiffany, aye.
Mr. Tiffany votes aye. Mr. Massey.
Mr. Chairman, this is Biggs. How am I recorded?
Biggs, I'll come back to you as soon as we finish the roll call.
Mr. Roy. Mr. Bishop. Mr. Bishop votes yes. Ms. Fishbach.
Aye.
Ms. Fishbach votes aye. Ms. Spartz. Mr. Fitzgerald. Mr. Benz.
Skimming's recorded.
Mr. Owens.
Owens, aye.
Mr. Owens votes aye.
Mr. Biggs, I believe you have a question. Oh, I'm sorry.
How is Lofgren recorded? It's not on
Ms. Lofgren, you are not recorded.
I vote no.
Ms. Lofgren votes
Mr. Chairman, Hank Johnson, how am I recorded?
Mr. Johnson?
Mr. Johnson, you are not recorded.
Vote no.
Mr. Johnson,
Mr. Biggs, I believe you have a query.
Yes, Mr. Chairman, how am I recorded?
Mr. Biggs, you recorded as no.
I want to be yes, please.
Mr. Biggs votes yes.
Mr. Chair, how is Lou recorded?
Mr. Liu, you are not recorded.
Lou,
Mr. Liu, you're not recorded?
How did the chair vote?
No.
Lou votes no.
Mr. Liu votes
Ms.
yes.
Demings?
recorded?
Ms.
Ms.
Demings?
Demings, you are not recorded.
Ms. Demings votes no.
Ms. Demings votes no.
Has anyone else, would anyone else like to vote who has not been recorded? Oh, Mr. Buck. One moment, please. Mr. Buck.
Mr. Buck votes no. Mr. Buck votes yes.
You were right the first time.
This is Steve Cohen out here.
Mr. Cohen.
Hello, Mr. Chair. This is Steve Cohen. I'm supposed to ask, yes, I didn't vote, but I'm supposed to ask, how am I recorded?
Mr. Cohen, you are not recorded.
I'm not recorded. Right. So I want to vote no.
Mr. Cohen votes no.
Has anyone else not voted who would like to be recorded? Ms. Garcia, did we get you? The clerk will report.
Mr. Chairman, there are 12 ayes and 18 noes.
The amendment is not agreed to. Are there any further amendments to the amendment in the nature of a substitute? The question occurs, seeing none, the question occurs on the amendment in the nature of a substitute. This will be followed immediately by a vote on final, as amended, I'm sorry. This will be followed immediately by a vote on final passage of the bill. All those in favor respond by saying aye. Aye. Those opposed, no. In the opinion of the chair, the ayes have it. The amendment in the nature of a substitute is agreed to. No, this is amendment in the nature of a substitute. A recorded vote is requested, and the clerk will call the roll.
Mr. Nadler.
Aye.
Mr. Nadler votes aye. Ms. Lofgren.
Aye.
Ms. Lofgren votes aye. Ms. Jackson-Lee. Ms. Jackson-Lee votes aye. Mr. Cohen. Mr. Cohen votes aye. Mr. Johnson of Georgia.
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch. Ms. Bass. Mr. Jeffries. Mr. Cicilline. Mr. Cicilline votes aye. Mr. Swalwell. Mr. Liu.
Aye.
Mr. Liu votes aye. Mr. Raskin.
Several of them have known about the conversation.
Ms. Jayapal. Ms. Demings. Mr. Correa.
Someone is not muting their microphone.
Mr. Correa votes aye. Ms. Scanlon. Ms. Garcia.
Aye.
Ms. Garcia votes aye. Mr. Neguse. Mr. Neguse.
Neguse votes aye.
Mr. Neguse votes aye. Ms. McBath.
McBath votes aye.
Ms. McBath votes aye. Mr. Stanton.
Aye.
Mr. Stanton votes aye. Ms. Dean? Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Jones? Ms. Ross?
Ross votes aye.
Ms. Ross votes aye. Ms. Bush?
Bush votes aye.
Ms. Bush votes aye. Mr. Jordan? Mr. Jordan votes no. Mr. Shabbat? Mr. Shabbat votes no. Mr. Gomert?
No.
Mr. Gomert votes no. Mr. Issa? Mr. Buck? Mr. Buck votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson, Louisiana? Mr. Biggs?
No.
Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Stube? Mr. Tiffany?
It basically says,
Mr. Massey? Mr. Roy? Mr. Bishop? Mr. Bishop votes no. Ms. Fishbach? Ms. Fishbach?
Fishbach.
Ms. Fishbach?
Votes no.
Ms. Fishbach votes no. Ms. Sparts?
Yes.
Ms. Sparts votes yes. Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Bentz? Mr. Owens?
Owens, yes.
Mr. Owens votes yes.
Ms. Dean?
Jayapal votes yes.
Ms. Jayapal votes yes.
Ms. Dean?
Dean votes yes.
Ms. Dean votes yes.
Mr. Chairman,
Mr. Stube?
Congressman Stube votes no.
Mr. Stube votes no.
Mr. Jeffries?
Jeffries votes yes.
Mr. Jeffries votes yes.
This is Mr. Cohen. Am I recorded?
Mr. Cohen, you recorded as aye.
Well, that's right.
Mr. Chairman, how is Representative Tiffany recorded?
Mr. Tiffany, you are not recorded.
Mr. Tiffany? No.
Mr. Tiffany votes no.
How about Mr. Johnson? How am I recorded?
Mr. Johnson, Louisiana, you are not recorded.
Johnson, Louisiana is a no.
Mr. Johnson, Louisiana votes no.
Mr. Johnson of Georgia? Has he voted? Okay. Are there any members of the committee who haven't voted who haven't been recorded who wish to be recorded? Clerk will report. Clerk will report.
Mr. Chairman, there are 20 ayes and 13 noes.
The amendment in nature of a substitute is adopted. A reporting quorum being present, the question is on the motion to report the bill H.R. 2864 as amended favorably to the House. Those in favor respond by saying aye. Aye. Opposed, no. No. The ayes have it. The bill is. A recorded vote is requested. The clerk will call the roll.
Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren? Ms. Lofgren?
Aye.
Ms. Lofgren votes aye. Ms. Jackson Lee? Ms. Jackson Lee votes aye. Mr. Cohen?
We all benefit
Mr.
from our
Cohen
leadership
votes
and
aye.
those young minds
Mr.
that come
Johnson,
in.
Georgia?
Someone's microphone is not muted.
Johnson votes aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch? Ms. Bass? Mr. Jeffries?
Jeffries votes aye.
Mr. Jeffries votes aye. Mr. Cicilline? Mr. Cicilline votes aye. Mr. Swalwell?
Aye.
Mr. Swalwell votes aye. Mr. Liu?
Aye.
Mr. Liu votes aye. Mr. Raskin? Ms. Jayapal? Ms. Dimmings? Mr. Correa?
Aye.
Mr.
Correa votes aye.
Mr. Correa votes aye. Ms. Scanlon? Ms. Garcia?
Excuse me, aye.
Ms. Garcia votes aye. Mr. Neguse?
Aye.
Mr. Neguse votes aye. Ms. McBath?
McBath votes aye.
Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Dean votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Jones? Ms. Ross?
Ross votes aye.
Ms. Ross votes aye. Ms. Bush?
Bush votes aye.
Ms. Bush votes aye. Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Shabbat?
No.
Mr. Shabbat votes no. Mr. Gomert?
No.
Mr. Gomert votes no. Mr. Issa? Mr. Buck? Mr. Buck votes no. Mr. Gates?
No.
Mr. Gates votes no. Mr. Johnson of Louisiana?
No.
Mr. Johnson of Louisiana votes no. Mr. Biggs?
No.
Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Stube? Mr. Tiffany?
Tiffany votes no.
Mr. Tiffany votes no. Mr. Massey? Mr. Roy? Mr. Bishop? Mr. Bishop votes no. Ms. Fishbach?
No.
Ms. Fishbach votes no. Ms. Sparts? Mr. Fitzgerald? Mr. Bentz? Mr. Owens?
Owens, yes.
Mr. Owens votes yes.
I've been going back and forth on it. Jayapal votes yes.
Ms. Jayapal votes yes.
Has Mr. Fitzgerald been recorded?
Mr. Chair, I vote no.
Mr. Fitzgerald votes no.
Are there any other members who wish to be recorded who haven't been recorded? Clerk will report.
Mr. Chairman, there are 20 ayes and 12 noes.
The ayes have it, and the bill is amended as ordered reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 8770, the expanding the Voluntary Opportunities for Translations in Elections Act, or the Expanding the Vote Act for purposes of markup, and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 8770 to modify.
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.R. 8770, the Expanding the Voluntary Opportunities for Translations in Elections Act, or Expanding the Vote Act, is a modest but important proposal that would update Section 203 of the Voting Rights Act and improve voting access for citizens with limited English language proficiency. In the 1970s, Congress determined, based on evidence of historical discrimination, that state and local officials were exploiting the limited English language proficiency of language minority citizens to deny them the right to vote. During the 1975 reauthorization of the Voting Rights Act, Congress addressed this problem by amending the act to add Section 203. In essence, Section 203 requires jurisdictions to provide voting materials and assistance in a language other than English if a minority group with limited English proficiency meets certain population thresholds as determined by the Director of the Census Bureau based on American Community Survey data. To be clear, Section 203's current requirements are not unduly burdensome on covered jurisdictions. It does not require a jurisdiction to provide voting materials in every language. It merely requires voting materials in a language relevant to a sufficiently sized minority voter population based on a carefully developed population trigger. Moreover, Section 203 applies only to Spanish, Alaska Native, Native American, and Asian American languages. Currently, 331 political subdivisions are covered by Section 203. 3 states, California, Texas, and Florida, are covered in their entirety for the Spanish language, with Los Angeles County required to provide assistance in 6 languages, the most of any political subdivision or state. H.R. 8770 would make several clarifications and improvements to this critical provision of the Voting Rights Act. For example, the bill would amend Section 203 to require the Attorney General to provide notification to jurisdictions whose language and minority populations put them on the cusp of triggering Section 203's requirements. Additionally, this legislation would create a grant program to assist jurisdictions that want to voluntarily provide translations of election materials beyond the requirements of Section 203, though I would note for the purposes of this markup that this provision falls under the jurisdiction of the Committee on House Administration. These provisions, among the other clarifications and improvements included in H.R. 8770, would not only enhance voting access for minority populations, but will also aid jurisdictions, especially smaller, more rural localities, in complying with their legal obligations under Section 203. As such, if enacted into law, one result of this legislation may be an overall reduction in the need for costly and time-consuming voting rights litigation. As I have stated at several Constitution Subcommittee hearings held by Chairman Steve Cohen over the past 2 Congresses, during the House's efforts to pass H.R. 4, the John Lewis Voting Rights Advancement Act, the right to vote is the foundation upon which our democracy is built. It is still critical for the Senate to act on H.R. 4. Although voting discrimination continued to evolve in the decades since the Voting Rights Act's passage, the Supreme Court reignited the game of whack-a-mole, again being played between the Justice Department and private litigants, and the states that continued to implement new and discriminatory voting restrictions when it effectively gutted Section 5 preclearance in its disastrous 2013 Shelby County decision. The lack of an operative Section 5 preclearance regime continues to be one of the most pressing voting rights issues of our time. For decades, the Voting Rights Act rightfully enjoyed broad bipartisan support as the crown jewel of federal civil rights legislation. It's my hope, however, that H.R. 8770, a modest but critical update to an important provision of the Voting Rights Act, will find bipartisan support on this committee. With that, I want to thank Congresswoman Nikema Williams for her leadership on this important legislation, and I urge all members to support the bill. I now recognize the ranking member of the Judiciary Committee, the gentleman from Ohio, Mr. Jordan, for his opening statement.
Mr. Chairman, the Constitution is clear. Policies related to elections are an area that we should leave to the states. The federal role is by design limited. The election clause of the Constitution gives state legislatures the authority to prescribe the time, place, and manner of holding elections. The 15th Amendment requires that states ensure that voting is accessible and available to every American, and the laws enacted at the federal level are already plenty sufficient to protect voting rights. As everyone here knows, in 1965, Congress passed the Voting Rights Act in response to resistance and barriers in some Democrat-led states that prevented racial minorities from exercising their right to vote. 2022 is not 1965, and it has never been easier for eligible Americans to vote. During the 2020 election, voter turnout was higher across all racial groups as compared to the prior presidential election. Voting laws should make it easy to vote and hard to cheat. The legislation before us allocates $15 million to further interject the federal government into this area that is best reserved for the states. Some Democrat-run areas have even taken the drastic step of allowing illegal aliens to vote. Federal tax dollars should not be forced to subsidize radical policies of left-leaning states. Meanwhile, recent voting reforms in Republican states, reforms aimed at improving election integrity, have been mischaracterized and demonized by Democrats. But these reforms are largely welcomed by all voters. I urge opposition to this legislation, Mr. Chairman, and yield back.
The gentleman yields back. Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 8770.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I will recognize myself to explain the amendment. This amendment in the nature of a substitute makes a single technical change, but makes no substantive changes to H.R. 8770. I urge all members to support the amendment, and I yield back the balance of my time. Are there any amendments to the amendment? I ask unanimous consent to put into the record a letter from the Lawyers Committee for Civil Rights under Law dated September 21st, 2022 in support of H.R. 8770 without objection. For what purpose does the gentlelady from Texas seek recognition?
Mr. Chairman, I move to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman, and thank you so much, and thank you to my colleague, Ms. Williams, for bringing this forward. There are approximately 20 million eligible Hispanic voters, and we are now one of the fastest growing voting blocs nationwide. This is especially true for my home state of Texas, with Hispanic residents accounting for 40.2% of the state's population in 2021. Even more so in my district, which is 77% Latino. However, states like Texas have passed laws restricting drop boxes, adding requirements for mail-in ballots, limiting polling hours, and restricting access to non-English assistance at the polls. These restrictions weigh heavily on Hispanic Latino voters and prevent them from exercising their fundamental legal federal right to vote. Texas' most recent changes cruelly target these voters and anyone who might assist them with increased burdens and unnecessary criminal penalties. These provisions are unlawful and are part of a long history in Texas of implemented discriminatory anti-voter measures. Mr. Chairman, we've been asking people in the census of what English they speak at home since 1890. And as you mentioned in your opening remarks, 331 political subdivisions are covered by Section 203. However, there is still widespread noncompliance with 203. Regrettably, even in my state of Texas, even in my own district, at every single election, Mr. Chairman, I get calls, and the majority of calls are from people complaining about being denied to bring assistance to, in their own language to be able to vote. Many places do not have an interpreter, so then they don't allow someone to come with them. People want to question their capacity. They want to, they want to cross-examine whether or not they're really interpreters. It's almost ridiculous. So these issues are real. So contrary to the remarks, and I certainly respect his right to say what he thinks, but the ranking member is incorrect. I mean, we do need Section 203. We need it in Texas. We need it in California. We need it in all the states that require it, but we need it fully complied with, because we've got to make sure that everyone that's eligible to vote can register to vote and have a full and meaningful opportunity to participate in the process. Voters with limited English proficiency have the same right to vote as any other American. And Mr. Chairman, 21.5% of the people in our country speak a language other than English at home. That's millions and millions of voters. H.R. 8770 creates a grant program that encourages non-Section 203 jurisdictions to translate materials into additional languages beyond the current requirements. They can do it voluntarily. It supports local governments with resources to serve their constituents and ensures that every eligible voter can have, again, a full and meaningful opportunity to have their voices heard at the ballot box. I urge my colleagues to vote for this very important legislation. Again, we're not talking about a few. We're talking about millions of Americans across our country who want and need full access to our ballot. 12 million eligible voters, Latinos alone. Thank you, Mr. Chairman, and with that, I yield back.
Gentlelady yields back. Who seeks recognition? The gentleman from Ohio, Mr. Shabbat, is recognized for 5 minutes.
Thank you. Thank you, Madam Chair. Voting is a fundamental tenet of our democracy, and as such, we have a compelling interest in ensuring that everyone who has, excuse me, the legal right to vote has the opportunity to cast a ballot. As I know that the chair, the actual chair, not the acting chair, Mr. Nadler, I was the chair of the Constitution Subcommittee, and he was the ranking member at that time, and we led a bipartisan effort to reauthorize the Voting Rights Act. And we held 12 hearings, and we heard testimony from nearly 50 witnesses, and as a result, we heard a wide variety of opinions on many topics that relate to ensuring voting rights for all U.S. citizens prior to consideration of the legislation of such a magnitude. And the result of our efforts was the Fannie Mae Hamer, Rosa Parks, and Coretta Scott King Voting Rights Reauthorizations and Amendment Act of 2006. And Madam Acting Chair, I remember you being at that signing ceremony down there.
And Barbara Jordan to that list.
Right, right. And President Bush was present at the time, which passed Congress nearly unanimously in both houses and was signed into law, as I mentioned, by President Bush, and a number of us were at that signing ceremony. At the time, members of both parties lauded it as legislation which would help ensure a fair, efficient, and transparent means of conducting elections. A portion of Bill Section 203 required that in jurisdictions where at least 5% of eligible voters spoke a particular language other than English, election materials be made available in that language. We've conducted several elections since that requirement was implemented, and while various issues have been raised with some of those elections in other areas, of course, none of them pertain to this Section 203 provision. As such, I don't see the need to mandate the expansion of the threshold beyond the current 5%. However, where jurisdictions feel it's beneficial for their local population to voluntarily provide translated election materials, I think that makes sense. By providing assistance for those voluntary efforts, this legislation will help to ensure all U.S. citizens can exercise their right to vote under the 15th Amendment. As we can all agree, every eligible voter should be able to cast a ballot, and legally cast ballots should be counted. As this legislation, I believe, will help that effort, I intend to support it, and I yield back.
The gentleman yields back. Who seeks recognition? Ms. Ross. Ms. Ross, you're recognized for 5 minutes.
Thank you, Madam Chair, and I want to thank Mr. Gomert for his support of this. It really is an extension of many of the provisions of the Help America Vote Act. I also want to point out that, many states, including southern states like North Carolina, put things like literacy tests into our Constitution and have inhibited the right to vote for people, not just people from other countries who might speak another language, but people from this country who didn't receive a full education and simply cannot understand everything that is on the ballot. And in North Carolina, we've had some pretty complicated constitutional amendments on the ballot. And for people whose first language is not English or who have difficulty understanding it, they are citizens. They have a right to vote, and we need to make it as easy as possible for them to exercise their franchise. As I said, access to the ballot is an essential part of being an American citizen. But there are many barriers for voters who do not speak English as their first language. Section 203 of the Voting Rights Act requires the provision of translated election materials in any jurisdiction in which 5% or a population of 10,000 people speak another language. This is a high standard, and it leaves many Americans who use other languages behind without easy access to voting materials that they can easily comprehend. Today, when elections are sometimes won or lost by less than a percentage point or hundreds of votes, it's time for us to rethink this provision and determine whether another threshold might be better to ensure equity in voting. This bill will expand upon Section 203 by offering federal grants to aid communities in distributing non-English ballots and voting materials. It will require proactive notification to jurisdictions that need to provide translated materials so these communities are prepared to provide translations. And it will commission a report on the potential impact of adjusting the threshold in Section 203 of the VRA. I strongly support this bill, which will enable immigrant citizens, many of whom are in communities of color, to have their voices heard at the ballot box. Thank you, Madam Chair, and I yield back.
Yields back. Who seeks recognition? Mr. Jones, you're recognized for 5 minutes. Mr. Jones of New York.
Thank you, Madam Chair, and I move to strike the last word. Our democracy is in crisis. We are living through the worst assault on voting rights since the Jim Crow era. The modern-day Republican Party, like fascist movements before it and like fascist movements across the globe, knows that it cannot win elections on the merits of its deeply unpopular policy ideas. Consider the GOP's opposition to the right to an abortion, a right supported by the vast majority of Americans, including majorities in states like Texas, Kansas, and Georgia. Consider the GOP's opposition to allowing Medicare to lower the cost of prescription drugs, a policy preferred by 88% of the American people. Consider the GOP's attempts to dismantle health care for millions of Americans, and even recent efforts to ban the history of slavery. The party of Donald Trump has become so extreme that the only way it can win elections is by disenfranchising Black and brown voters. And now they're saying they won't even certify elections. 2/3 of House Republicans and 3/4 of the Republicans on this committee voted against certifying the 2020 election. And GOP Secretary of State nominees this cycle in places like Nevada, Arizona, and Michigan have all said they would not have certified the 2020 election. This is a constitutional crisis, and the Supreme Court has been an accomplice. Since 2013, and the court's gutting of the Voting Rights Act in Shelby County v. Holder, Republican state legislatures across the country have been busy rolling back access to the ballot. They have doubled down on punitive voter ID laws, purged eligible voters from the voter rolls, closed accessible polling locations, restricted early voting and voting by mail, told elderly people waiting on long lines in the Georgia heat that they can't even have a bottle of water, and they have even made it difficult to register to vote. When Republicans lost big in the 2020 election, they intensified their efforts to disenfranchise communities of color. According to the Brennan Center, in the year 2021 alone, there were more than 440 Republican-led bills that were voter suppression bills that were introduced in 49 states, with 34 laws enacted in a total of 19 states. This all happened last year. And they were all aimed at making it more difficult for minority communities to participate in our democracy. This year has seen even more of the same. This is why bills like Congresswoman Nikema Williams' Expanding the Vote Act are so important. And it's why I'm proud to co-sponsor this legislation. Section 203 of the Voting Rights Act only works if we enforce it. And unfortunately, there is widespread non-compliance in many states and localities in this country. Today, we can fix that. by enacting this bill to allow the federal government to take a more proactive role in notifying states and localities when they're about to reach Section 203 thresholds, and financially assisting them to implement Section 203 once they do. But our work to protect minority voters from racist and xenophobic voter suppression laws does not end here. The Senate has to abolish the filibuster and pass the Freedom to Vote John R. Lewis Voting Rights Act, which would restore the preclearance provisions that were gutted in Shelby County v. Holder. In doing so, Madam Chair, we would restore the promise of the Voting Rights Act, and we would strengthen our ailing democracy. I yield back.
Yields back. Who seeks recognition? Mr. McClintock, you're recognized for 5 minutes.
Thank you, Madam Chairman. I have an amendment at the desk.
Gentleman has an amendment at the desk. The clerk will report the amendment.
I reserve a point of order.
Point of order has been reserved.
Amendment to the amendment in the nature of a substitute to H.R. 8770, offered by Mr. McClintock of California. Page 1, beginning on line 8, strike subsection G and insert subsection H. Page 2, line 8, after 0.5%, insert the following. G, rule of construction. Nothing in this section may be construed, 1, to permit any non-citizen to vote in a federal election, or 2, to encourage or require a state or political subdivision to permit any non-citizen to vote in a state or local election.
The amendment has been read. The gentleman is recognized. The point of order is reserved. Gentleman is recognized.
Thank you, Madam Chairman. A requirement of citizenship is to speak English. This is fundamental to a democratic society, the abilities of citizens to talk things out among ourselves. The American concept of sovereignty is unique. Unlike other democracies, our government is not the sovereign. The people are the sovereign. And unlike other sovereigns, the American sovereign doesn't govern. The American sovereign hires help to govern. That's what all of us are at this dais. We're hired help. And once we hire the help, we watch them. We debate their policies and their performance. And then every 2 years, we decide whether to keep them or throw them out and hire others. This requires an awful lot of talking among ourselves. That's why freedom of speech is so central to our democracy and why censorship is so deadly. And that's also why we require every citizen to speak and understand English fluently. Talking out our differences is what this institution was designed to do. And we are simply a reflection of the much larger debate that goes on among the American people every day over the future of our society. If citizens cannot debate issues through a common language, democracy cannot function. This concept has already been severely undermined by the rise of bilingual ballots that seem to assume that voting citizens cannot speak English and therefore cannot fully debate the issues before us as a society. I think this bill continues to expand this dangerous trend. My amendment simply seeks to reinforce another critical tenet of a democratic society, the principle that American citizens, and only American citizens, have the right to decide the fate of our democracy. Those who are citizens of other nations, whether they're here legally or illegally, are guests of our democracy, and we kindly thank them for not interfering in our deliberations and our decisions. There are many examples of foreign nationals who voted in our elections. Perhaps the most celebrated was a Mexican national who assassinated the Mexican presidential candidate. It was discovered he was illegally registered to vote in California. California recently admitted that it had registered at least 1,500 non-citizens to vote as a result of its practice of automatically registering driver's license applicants to vote. North Carolina just prosecuted 19 illegal aliens for casting votes in its election in 2016. Many such examples can be found through a simple Google search, and many academic studies have posited estimates that the total number of illegal votes by non-citizens can be significant, if not decisive, in close elections. So this amendment just makes it clear that this bill does not intend to permit or encourage non-citizens to vote. Now, if that's not the intent of the bill, my colleagues should have no problem including this assurance in the text of the bill. But if it is the intent of this measure, well, then I can understand their opposition. Yield back.
The gentleman yields back. Gentleman yields back. I recognize myself for 5 minutes and will not take all of that. First of all, in the history of this nation post the 2020 election, which was the largest turnout of Americans, regardless of their party, regardless of the language they originally spoke, or regardless of the origins, where they first came from, whether they were immigrants and now citizens. And so the tragedy of that is that the spirit of voting had been crushed. And so this legislation reignites the spirit of voting by a fair proposition of making sure that citizens have the ability to read the ballot and to be conversant with the issues. But as it relates to this particular legislation, federal law already states that a non-citizen cannot vote. It is already a violation. You cannot vote if you are not a citizen. And as it relates to states, which the gentleman comes from and other members come from, distinctive and different states, those states have a right to make their own decisions. I know that my colleagues know often the citation of the 10th Amendment. They have cited it often. And so I oppose the gentleman's amendment, and I'd ask my colleagues to oppose it. And I need to make sure that Mr. Johnston has, Mr. Jones has withdrawn his point of order.
Madam Chair, I withdraw my point of order.
And you are Mr. Jones of New York. Thank you so very much. And my ears heard something else. But in any event, and so I have to oppose the amendment. The point of order has been withdrawn. Does anyone else seek recognition?
Madam Chair, I seek recognition.
Let me,
This is Mr. Cohen.
Mr. Cohen, Mr. Bishop, and then you, Mr. Bishop, you're recognized for 5 minutes.
I thank the chairman. I certainly concur with the points made by Mr. McClintock, and I believe they go to the underlying bill as much as to the amendment. It is significant that Americans learn to speak the same language. That's why citizenship laws require that folks learn English, and after becoming a citizen, one presumes that one should continue to learn English so that we can function together, as Mr. McClintock stated. I thought I would speak for just a moment, though, to respond to the earlier comments by Mr. Jones of New York about these accusations of voter suppression, and they are so tiresome that I think everybody's kind of gotten done with them.
And fascism, Mr. Bishop.
But I guess I thought I would point out what really is voter suppression. It occurred in North Carolina, and it was done by the Supreme Court of North Carolina. In 2018, actually in 2013 for the first time, North Carolina legislature passed voter ID. It's something that, talking about popular will, that Mr. Jones was making reference to certain issues on which there seems to be polling positions, but polling positions consistently indicate 75, 85% of people favor the simple act of proving who you are when you go to vote by tendering an ID. And North Carolina legislators, the representatives of the people, first made that the law in 2013. A federal court, Fourth Circuit, Obama heavily appointed court, subsequently held that that was discriminatory and struck it down. And that was on the way to the United States Supreme Court, but in further frustration of the representatives of the people, the Democratic Attorney General of the state sabotaged the appeal so it wouldn't be able to be heard. And the Supreme Court, kind of tossed it because of the irregularity in the process of the appeal. He succeeded in frustrating the people's voice that way. And I think that occurred in 2017 after the 2013 activity, or after the 2013 legislation adopted voter ID. So so you had 5 years pass until 2018. And the legislature then proposed constitutional amendments to the state constitution for the people to consider. And the people subsequently decided to pass voter ID by a 10-point margin, 55 to 45. Also considered at the same time another amendment to tax the income, or to cap the income tax in the state at 7%, passed that by a 15-point margin. So just a month or so ago, 4 Democrat Supreme Court justices in North Carolina, facing the dissent of 3 Republican justices, held that, in effect, that those 2 amendments may be able to be struck down, even though the people of North Carolina voted for them by an overwhelming margin. In fact, what they held in effect is that whenever the perpetual attacks on apportionment through litigation, one hits its mark and the legislature has to be apportioned, well, for some indefinite period of time, the people of North Carolina are stripped of their power to amend their Constitution. That's what they held. You want to talk about disenfranchisement? That one makes all the accusations that are rendered by leftists and by Democrats in this country utterly ridiculous. The people of North Carolina voting for the simple expedient to secure elections of tendering a voter ID, overwhelmingly, a court took that away from them. Now, the good thing is that in North Carolina, the court is elected. And the good people of North Carolina are going to have an opportunity to have the last word on whether they can be. In a nation that recognizes that the people are sovereign, Mr. McClintock, that all power comes from the people, says the Constitution of North Carolina, and it further explicitly says that the people always retain the power to alter or abolish their form of government as set forth in the Constitution. That whenever 4 Democrats say so, it doesn't matter what the vote is in North Carolina, by any margin, they're going to be disenfranchised, to use Mr. Jones's term. Nothing, no provision passed by any Republican legislature that you can point to is anything like that. In fact, all of them have resulted in increased voter participation. So we know who's really suppressing the vote. And I look forward to North Carolina voters correcting it this November. I yield back.
Gentleman yields back. For what purposes, gentleman from Tennessee seek recognition.
Thank you, Mr. Chair. I'm a little confused.
Gentleman,
and maybe
gentleman is recognized.
Thank you. Strike the last word. Maybe Mr. McClintock, is he still in the room?
Yes, I am.
Is this your amendment?
Yes.
Is it on language or is it on citizenship?
Well, it's on citizenship.
Well, let me ask you a question. Your amendment would say you have to be a citizen to be able to vote?
No, it says that nothing in this bill is to be interpreted as encouraging non-citizens to vote or encouraging states to allow non-citizens to vote.
So like in Pennsylvania, where the Republican presidential senatorial candidate Oz is a citizen of Turkey as well as America and voted in Turkey, would he be able to cast half a ballot for himself or a whole ballot?
I don't know the circumstances that you're referring to, but if he's an American citizen, he may vote.
So if you're a citizen of 2 countries, you could vote.
Well, that's a separate discussion perhaps we ought to have in the future. I would certainly enjoy that discussion, but that's not what this amendment is involved with. This amendment simply says that nothing in this bill should be interpreted as encouraging a non-citizen to vote.
Thank you, sir. I appreciate your comment, and I look forward to a discussion with you on anything. You're a good member, and I enjoy your company. I do think that I can understand. I never understood how Mr. Oz could vote in Turkey and then vote in Pennsylvania. But I guess the people of Pennsylvania make that decision, and I'll yield back.
Will the gentleman yield?
Well, they will, Mr. Cohen,
Mr. Cohen.
if they can talk to each other and
Yeah,
understand
I'll yield to Ms. Lee.
Thank you.
Does the gentleman yield to the gentlelady from Texas?
That's my MO, yes.
Gentlelady from Texas.
You have been extraordinarily kind today, Mr. Cohen, and we thank you for the work that you've done on voting rights on your constitutional subcommittee, along with Mr. Nadler and all the members of the Judiciary Committee that are on our side of the aisle. I love Mr. Chabot making a very potent point, and that potent point was how, I don't know how I should say it, how different a few years are when the Senate voted 98 in favor of the Voting Rights Act of 1965 reauthorized, and the House voted some 400 and over 420 plus. And a Republican president with great appreciation and respect, George W. Bush, held a Rose Garden signing ceremony. That is what America is. That is what America is. And Congresswoman Williams of Atlanta, in the seat that John Lewis has held, is speaking to America. And all of these Neanderthal legislative acts that have come down like a hammer on democracy post-2020 are tearing at the heartstrings and the very fabric of democracy. There's no glee to go to vote. You're afraid of monster poll watchers. You're afraid of dying of thirst in the hot sun in Texas and Georgia and other places. You're afraid of being charged of being a felon. You're afraid of being charged because you have an accent or you are speaking a different language, that you're not a citizen. No one knows what the heck they're going to face when they go to the voting polls in November 2022. Let me pronounce, Americans, come out to vote. We'll know if you're not a citizen. It's federal law. This legislation that we're debating is to make sure that you can read, understand, and vote with integrity if you don't have English as your first language. But how dare anyone be opposed to opening the doors of justice and opportunity? Because it is poor people, people of color, women. Look where we are today. We don't have any reproductive freedom. Why? Because we're facing a court system dominated by those who have been voted in and then selected individuals who have no qualms of taking constitutional rights away. I want to make sure that honest citizens who have come to this country in a variety of ways, and so I am a variety of ways, are able to vote. I'm supporting H.R. 8770 because it protects the voting rights of language minorities by strengthening the protections in Section 203. And I'm begging this Congress to pass the John Robert Lewis Voter Enhancement Act and vote for it now. It is absurd. Democracy has to prevail. Mr. Chairman, I ask for support of this, and I yield back.
The gentleman's time has expired. Does anyone else seek recognition? Okay, the question occurs on the amendment. All in favor say aye. Aye. Opposed, no.
Aye.
No. In the opinion of the chair, the noes have it. The recorded vote is requested. The clerk will call the roll.
Mr. Nadler.
No.
Mr. Nadler votes no. Ms. Lofgren.
No.
Ms. Lofgren votes no. Ms. Jackson-Lee. Ms. Jackson-Lee votes no. Mr. Cohen.
No.
Mr. Cohen votes no. Mr. Johnson of Georgia. Mr. Deutsch. Ms. Bass. Mr. Jeffries. Mr. Cicilline. Mr. Cicilline votes no. Mr. Swalwell. Mr. Liu.
No.
Mr. Liu votes no. Mr. Raskin.
No.
Mr. Raskin votes no. Ms. Jayapal.
Jayapal votes no.
Ms. Jayapal votes no. Ms. Stimmings.
No.
Ms. Stimmings votes no. Mr. Correa. Ms. Scanlon.
Scanlon votes no.
Ms. Scanlon votes no. Ms. Garcia.
No.
Ms. Garcia votes no. Mr. Neguse. Ms. McBath?
McBath votes no.
Ms. McBath votes no. Mr. Stanton? Mr. Stanton?
No.
Mr. Stanton votes no. Ms. Dean?
No.
Ms. Dean votes no. Ms. Escobar?
No.
Ms. Escobar votes no. Mr. Jones? Mr. Jones votes no. Ms. Ross?
Ross votes no.
Ms. Ross votes no. Ms. Bush? Mr. Jordan? Mr. Jordan votes yes. Mr. Shabbat?
Aye.
Mr. Shabbat votes aye. Mr. Gomert? Mr. Isa? Mr. Buck?
C.
Mr. Buck votes yes. Mr. Gates? Mr. Johnson of Louisiana? Mr. Biggs? Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Mr. Stube?
Yes.
Mr. Stube votes yes. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Bishop? Mr. Bishop votes yes. Ms. Fishbach?
Yes.
Ms. Fishbach votes yes. Ms. Sparts? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Benz? Mr. Owens?
Owens, aye.
Mr. Owens votes aye.
How was Swallow recorded?
Mr. Swallow, you are not recorded.
Nope.
Mr. Swallow votes no.
How was Jeffries recorded?
Mr. Jeffries, you are not recorded.
Jeffries votes no.
Mr. Jeffries votes no.
How's Correa recorded?
Mr. Correa, you are not recorded.
Correa votes no.
Mr. Correa votes no.
How is
Mr. Gates
Johnson
votes aye.
recorded?
Mr. Johnson of Georgia, you are not recorded.
I vote no.
Mr. Johnson of Georgia votes no.
How is Tiffany recorded?
Mr. Tiffany, you are not recorded.
Tiffany, yes.
Mr. Tiffany votes yes.
Are there any members who seek to be recorded who haven't been recorded? Mr. Johnson? Clerk will report.
Mr. Chairman, there are 12 ayes and 21 noes.
The amendment is not agreed to. For what purpose does Ms. McBath seek recognition?
Thank you so much, Chairman. I move to strike the last word.
Gentlelady is recognized.
I'd really like to thank my Georgia colleague, Representative Nikema Williams, for introducing what is in particular really for Georgia an extremely important bill, which is designed to expand our constitutional right to vote for Americans across the country. And we know that expanding voting access for Americans is one of the most important things that we can do to uphold and uplift democracy. We have to ensure that Americans have the tools necessary to take part in democracy. And that's in fact, a basic defense of our Constitution. And we are blessed to be a country that is filled with individuals who speak a multitude of languages. And I believe it's one of the things that makes this nation so special. we've got to just make sure that we are doing all that we can as Americans, no matter what language we speak, that we're all able to perform that All-American Act, which is the right to vote. And the Expanding the Vote Act would really enhance enforcement of the Voting Rights Act of 1965 by requiring that the Department of Justice provide jurisdictions with protective modifications or notifications if they're close to triggering the requirements of Section 203, which would require the jurisdictions to provide voting materials in languages other than English. It would also create a federal grant program to help jurisdictions that want to voluntarily provide translations of election materials beyond the requirements of Section 203 to do so. My district of Georgia, Georgia 6th, over 26% of people report speaking a non-English language at home as their primary language. And so that is much higher than the national average, which is 21.5%. These languages include Hindi, Arabic, Spanish, Cantonese, Vietnamese, Yiddish, and just the list goes on. These Americans deserve to be able to play just as active a role in our democracy as those do who speak English as their predominant language. I urge my colleagues to please vote yes, which we are doing on this important bill. Doing so is just not a vote for HR 8770, but a vote for democracy and a vote for our constitutional rights. And I yield back.
Will the gentlelady yield? Gentlelady yields back for what purpose?
I was asking if the gentlelady was, sorry, Mr. Chairman. Will Ms. McBath, will you yield the balance of your time?
Yes, I yield the balance of my time to
Thank
the
you.
gentleman from Rhode Island.
Thank you, Mr. Chairman. Thank you for bringing this important bill to markup. I'm committed to ensuring that every eligible American not only has the right to vote, but also has the access and ability to exercise that right. Section 203 of the Voting Rights Act transformed voting access by mandating jurisdictions provide translated election materials in any language spoken by at least 5% of the population or 10,000 people. But this leaves countless Americans who speak a language not commonly spoken in their jurisdiction unable to understand vital election materials. Portuguese is the most commonly spoken language in Rhode Island behind English and Spanish. However, because Portuguese-speaking Americans are spread across jurisdictions, the state is not required to provide them with translated election materials. This forces voters within the community of over 10,000 Portuguese-speaking Rhode Islanders who speak English less than very well to turn to friends and family for help exercising their constitutional right to vote. The Expanding the Vote Act will finally address translation deficiencies in our voting systems by supporting jurisdictions that want to voluntarily provide additional translations of election materials. Importantly, this bill directs the Comptroller General to study the impact of expanding language access in our voting system. Thank you to my friend and colleague, Congresswoman Nikema Williams, for introducing this bill. I'm proud to co-sponsor the legislation and to support it today, the day after National Voter Registration Day. And with that, Mr. Chairman, I yield back.
The gentlelady yields back. For what purpose does Ms. Garcia seek recognition?
Mr. Chairman, I ask for unanimous consent to enter for the record a document from the United States Census Bureau on why we ask questions about language spoken at home. And again, this question about speaking a language other than English has been asked by the Census Bureau since 1890, and it's not a new progressive liberal thing. Thank you.
Without objection, are there any further amendments to the amendment nature of a substitute? If not, the question occurs on the amendment nature of a substitute. Those in favor say aye. Aye. Opposed, no.
Aye.
The amendment, in the opinion of the chair, the ayes have. The amendment nature of a substitute is agreed to. A reporting quorum being present, the question is on the motion to report the bill H.R. 8770 as amended favorably to the House. Those in favor respond by saying aye. Aye. Opposed?
Aye.
Opposed, no. The ayes have it. Recorded vote is requested. The clerk will call the roll.
Mr. Nadler.
Aye.
Mr. Nadler votes aye. Ms. Lofgren.
Aye.
Ms. Lofgren votes aye. Ms. Jackson-Lee. Ms. Jackson-Lee votes aye. Mr. Cohen.
Aye.
Mr. Cohen votes aye. Mr. Johnson of Georgia. Mr. Deutsch. Ms. Bass. Mr. Jeffries. Mr. Cicilline. Mr. Cicilline votes aye. Mr. Swalwell?
Aye.
Mr. Swalwell votes aye. Mr. Liu?
Aye.
Mr. Liu votes aye. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Ms. Jayapal? Ms. Demmings? Ms. Demmings?
Ms. Demmings, you need to unmute.
Mr. Correa? Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Ms. Garcia? Ms. Garcia votes aye. Mr. Neguse? Ms. McBath? Ms. McBath?
Ms. McBath votes aye.
Ms. McBath votes aye. Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Dean votes aye. Ms. Escobar?
Aye.
Ms. Escobar votes aye. Mr. Jones? Mr. Jones votes aye. Ms. Ross?
Ross votes aye. Ooh.
Ms. Ross votes aye. Ms. Bush?
Bush votes aye.
Ms. Bush votes aye. Mr. Jordan? Mr. Jordan votes no. Mr. Shabbat? Mr. Shabbat votes aye. Mr. Gomert? Mr. Issa? Mr. Buck? Mr. Buck votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana?
No.
Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. Stubbe?
No.
Mr. Stubbe votes no. Mr. Tiffany?
Tiffany, no.
Mr. Tiffany votes no. Mr. Massey? Mr. Roy? Mr. Bishop?
No.
Mr. Bishop votes no. Ms. Fishbach?
No.
Ms. Fishbach votes no. Ms. Sparts? Mr. Fitzgerald? Mr. Bentz? Mr. Owens?
Owens, no.
Mr. Owens votes no.
Jayapal
Mr.
votes aye.
McClintock votes no. Ms. Jayapal votes aye.
Neguse
How's
votes
Ms.
aye.
Mr. Neguse votes aye.
How's Ms. Demmings recorded?
Ms. Demmings, you are not recorded.
Demmings votes aye.
Ms. Demmings votes aye.
House Correa recorded.
Mr. Correa, you are not recorded.
Ms.
Correa
McBath?
votes aye.
Ms. McBath?
Mr. Correa votes aye.
Are there any members who haven't been recorded who wish to be recorded? Clerk will report.
Mr. Chairman, there are 22 ayes and 11 noes.
The ayes have it, and the bill is amended as ordered reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in nature of a substitute incorporating all adopted amendments. Staff is authorized to make technical and conforming changes. There are 4 votes on the House floor. The committee will stand in recess until immediately after the votes. The committee will come to order. Pursuant to notice, I now call up H.Res. 1343, a resolution of inquiry requesting the President and directing the Secretary of Health and Human Services and the Secretary of Homeland Security to transmit respectively certain documents to the House of Representatives relating to unaccompanied alien children for purposes of markup, and move that the committee report the resolution unfavorably to the House. The clerk will report the resolution.
H.Res. 1343 of inquiry requesting.
Without
the
objection, the
President-
resolution is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.Res. 1343, introduced by Representative Michael Burgess, requests the President and directs the Secretaries of Health and Human Services and Homeland Security to provide to the House of Representatives certain documents in their possession relating to unaccompanied children. More specifically, it asks the President and Secretaries to produce all documents, memoranda, advisory legal opinions, notes for meetings, audio recordings, records, correspondence, and any portion of any such communications related to the care of, vetting policies and procedures for Office of Refugee Resettlement volunteers and staff and potential sponsors, and information on any allegations of abuse or neglect of unaccompanied children in the custody of the ORR. I oppose this resolution for a number of reasons. First, this resolution is completely unnecessary. The minority has had no problem obtaining briefings or information on this issue. Just 2 weeks ago, ORR and the Department of Homeland Security took part in a regularly scheduled bipartisan multi-agency immigration briefing call in which they discussed their work caring for unaccompanied children. Staff for any congressional office is allowed to join and ask questions. Unfortunately, not a single question was asked of ORR by Representative Burgess' staff, or by any Republican staff for that matter, on that call. Further, many of the policies and procedures asked for in this resolution are already posted online. Without objection, I submit into the record the following materials, which largely address 5 of the 7 requests contained within the resolution. 1, ORR policy guide sections regarding the placement of unaccompanied children with a sponsor, which includes the requirement that all potential sponsors of unaccompanied children undergo background checks. All background checks must include a public records check, sex offender registry check, and with the exception of some parents or other immediate relatives who previously served as the primary caregiver, a fingerprint check. 2, ORR's hiring and training policies and the methods ORR utilizes to recognize the signs of and protect children from human trafficking and other exploitative activity. 3, an HHS Inspector General report issued 3 months ago on June 22, 2022, which details ORR's previous and current policies as it relates to COVID-19. And 4, ORR field guidance related to COVID-19 intake procedures for unaccompanied children, which was first issued in November 2020 and was last revised in April 2022. Committee staff found these policies on ORR's public website with a simple web search. As we showed last week, when ORR quickly provided the committee the documents sought by Representative Kelly with regard to HRES 1257, ORR has been very transparent when it comes to the care of unaccompanied children. That makes these resolutions unnecessary. I urge my colleagues to take advantage of the many avenues and opportunities already available to them to obtain information. Any member is more than welcome to reach out to our committee staff. We are happy to discuss a request for certain documents, or we can ensure that appropriate staff are on the next regularly scheduled bipartisan briefing. I oppose this resolution, and I urge all members to report it unfavorably. I now recognize Mr. Massey for an opening statement.
Thank you, Mr. Chairman. Mr. Chairman, every week our border crisis grows worse, and every week Democrats continue to ignore it. Since President Biden took office, U.S. Customs and Border Protection has encountered nearly 3.5 million illegal aliens along the southwest border. And 255,000 of these 3.5 million illegal aliens have been unaccompanied children. During the Trump administration, committee Democrats held multiple hearings attacking the administration for overcrowded conditions caused by unaccompanied children coming across the southwest border. But since President Biden took office, these same Democrats have been silent about the far worse conditions and the Biden administration's lack of concern with placement of these children with sponsors in the U.S. Through July of fiscal year 2022, there have been 128,845 unaccompanied alien children processed by CBP. The Biden administration began cutting corners to reduce the amount of time that unaccompanied children spent in the custody of Office of Refugee Settlement. Some of these actions are deeply troubling. For instance, ORR, expedited release policy, does not require fingerprint checks on all sponsors, and it only requires a background check on members of the sponsor's household, quote, as appropriate, unquote. If the Biden administration had the best interests, safety, and welfare of these children at heart, it would enforce U.S. immigration law to deter aliens, including unaccompanied children, from making the journey to the U.S. border. Instead, the Biden administration is intent on incentivizing illegal immigration, thereby placing UAC in danger. This ROI before us seeks important information related to children crossing our borders and related to the sponsors the Biden administration is releasing them to. This is information all members of the committee should want, and I urge support for this resolution to be adopted today. Mr. Chairman, I'm glad that you said that the information you have largely addresses 5 of the 7 concerns here. It doesn't completely address those concerns, the information you have, and 2 of the 7 concerns are unaddressed. Thank you, and I yield back.
The gentleman yields back. Without objection, all other opening statements will be included in the record. I now recognize myself for purposes of offering an amendment in the nature of a substitute. Clerk will report the amendment.
Amendment in the nature of a substitute.
Without objection, the amendment in the nature of a substitute will be considered as read. It shall be considered as base text for purposes of amendment. I recognize myself to explain the amendment. This amendment in the nature of a substitute makes a single technical change to the resolution of inquiry by spelling the number 14 instead of using the actual number. No other changes were made to the resolution of inquiry. I urge all members to support the amendment, and I yield back the balance of my time. Are there any amendments to the amendment in the nature of a substitute? Who seeks recognition? No one seeks recognition.
Mr. Chairman.
What purposes, gentleman from North Carolina, seek recognition?
To speak on the resolution.
Gentleman is recognized.
I think if I understand the purpose, the basis of resistance, it is that, or objection, it is that there are means available for some of the information to be obtained. And I don't understand why that's a basis for objection. The question, if there has been if some of these items could be obtained by other means, it doesn't change the fact that not all of them are. And Mr. Massey spoke to that, but beyond that, even if it's duplicative or cumulative, what the general experience here reflects is that the administration has not been forthcoming about the circumstances of the border generally, and certainly not concerning the handling of UACs. They've been flown around the country in the dark of night. There have been all sorts of irregular and housing decisions made that have been discovered by media from time to time, but Congress can't learn of them. We've had hard times since the beginning of the Biden administration obtaining quantification of information. There have been delays of reports that are regularly published by DHS, which is presumably because they didn't want the information within them that's usually divulged to be known to the public. It reminds me of what the FISA court said about the FBI, or about the Department of Justice, I guess FBI, that there was an institutional lack of candor. And nothing captures this better on the question of illegal immigration in the United States than the persistent answers to the questions asked, and I've seen it done in Homeland Security, I've seen it done here, I've seen it done elsewhere, we've seen it done on national television by Secretary Mayorkas, by the President himself, by Vice President Harris most recently, in response to questions about whether the border is open. The answer continues to be the border is secure. And it has become sort of a symptom of what ails the country that high officials will give an answer that is so bereft of truth over and over, audaciously, brazenly, in the face of all evidence to the contrary. Presumably, those who oppose this resolution of inquiry are content with that. In fact, they're endorsing it. But the posture of the United States Congress should be precisely the opposite. We should be requiring demonstrating with one voice, without partisanship, that the Department of Homeland Security should be forthcoming and transparent for once in this administration. This would be a good time to see that happen. I offer yield time, Mr. Massey, if you need any time. Mr. Massey not needing any time and no others seeking it, I will yield back.
The gentleman yields back. Who else seeks recognition?
Mr. Chairman. Mr. Chairman.
Who's seeking recognition?
Biggs,
For what purpose does Mr. Biggs seek recognition?
move strike last word.
Mr. Biggs, you have to turn on your camera.
Oh, it's on, just,
There you go.
All right, sorry.
For what
sorry about
purpose
that.
does Mr. Biggs seek recognition?
Move to strike last word.
Gentleman is recognized.
Thank you, Mr. Chairman. I support the Massey resolution. And I want to talk briefly about what's going on in the border. And then I will try and tie it into why it is so important to pass this resolution. First of all, when we see what's going on at the border, and we have an administration where the border czar, who's supposed to be assuring that our border is secure, tells us that the fact that they desire it and are considered important is enough, even though there's 2 million encounters at the border just this fiscal year. It raises some important questions. I go down to the border often. I just actually met with a Border Patrol agent right before this hearing recommenced. And my experience has been that we have all kinds of children coming across, unaccompanied minors and others in putative family units. And that term is, by the way, very broadly and loosely construed. Earlier this year, information came out that the whereabouts of 20,000 children who are unaccompanied has been lost. We don't know where they are. And there is no intention on the part of this administration to find them. When these children come over, the only time that biometrics are even used to determine whether there's a DNA analysis that would show that child is actually the relative of the individual that's claiming that it's a family unit, is when there's some kind of overt indicia that gives rise to suspicion that it is a fraudulent family unit. But in reality, we don't test, we don't know, because we don't have access to the necessary records and documentation which would determine and help understand if that child is actually related to the person claiming the relationship, the adult person claiming the relationship. But the reason that this is so important is because ORR takes charge of these children and then they place them. And we don't do an adequate background check of these individuals. Certainly their relationship to this country, whether an alien or a citizen or a legal alien, is irrelevant, actually. Moreover, we don't test and cannot test their background in a thorough fashion because we only have access to some US background records, not overseas or foreign countries. It is inconceivable to me that we would return this with an unfavorable, quite frankly. We need these documents. We are the committee that has the oversight authority and responsibility in this area. We should be going forward and getting these records and more. The border is in an absolute shambles and crisis. We don't control it. As some scholars have said, the sign of disintegration of a nation is actually the encroachment or devolution of their territorial integrity. And certainly ours is in jeopardy because our border is such a shambles. Mr. Chairman, I would urge you to reconsider your opposition to this and join us in seeking to find out the records, the documents, and the truth about what's going on with those who come into this country illegally or legally. And that's why this is such a great resolution on the part of Mr. Massey. I support it. I encourage everyone else to support it. With that, Mr. Chairman, I will yield to Mr.
Would the
Massey
gentleman
if he
yield?
needs time.
Yes.
Yes, I will.
I just want to clarify, this is Dr. Michael Burgess from Texas's resolution of inquiry, not mine, but I do support it wholly. I yield back to the gentleman from Arizona.
Thank you, and thank you. I thought that just the fact that you were the spokesman was enough to be persuasive. Thank you, Mr. Chairman. I yield.
The gentleman yields back. For what purpose does this gentleman from Texas seek recognition?
Move to strike last word.
Gentleman is recognized.
Well, I associate myself with the remarks of the gentleman from Arizona, as well as the gentleman from North Carolina, as I was coming into this debate, and apologize for being a couple minutes late. But I would note that much like all of the other objections involving the resolutions of inquiry, the point here ought to be asserted again that this is simply Article 1 demanding information from Article 2. This is not high controversy, right? This is something that, of all the things we should want to agree on a bipartisan basis, it would be, let's press the administration for information. And if it's classified or there's something like that, then let's do it in the SCIF or whatever. But we collectively should want facts and information to seek the truth. I don't think that should be that controversial. I noted last week when talking about a different issue, now it's much more relevant and on point even today, that in the Oversight Committee, I think about 2 months into my first year in Congress, I voted to subpoena individuals and information directly related to this point of the previous administration. It did not go over very well, as you might imagine, among kind of circles in the here in Congress as well as in the White House. But my view on this is not a political one. It's not an issue of, oh, well, Joe Biden's in the White House, so I want to go stick it to Joe Biden by trying to find something I can go pass. It's very simply put, I want answers to be able to answer questions. That's our job. And what we're talking about here are children, and we're talking about a border that has created an environment where we all must agree on a bipartisan basis, absolute, undeniable fact, children are being abused, children are being put into the sex trafficking trade as a result of the massive flow across our border. Even if my colleagues on the other side of the aisle don't want to acknowledge that there's a massive flow across our border, or they want to say, oh, don't worry, that's all asylum claims, don't worry about it, there's no issue, there's no gotaways, there's no fentanyl, there's no cartel issue, it's all fine. No worries. All the crap we're seeing of the 53 dead migrants in San Antonio, all the stuff happening to Texans, all the people dying. Oh, don't worry about all that. Ignore it. Even if we just accept, oh, don't worry about that. We can't agree that we ought to get every ounce of information out of the executive branch to be able to do our job and to seek the truth. I think that ought to be a straightforward inquiry, a straightforward question. A straightforward answer from us on the separation of powers, seeking the truth out of the executive branch in order to conduct our oversight responsibility, particularly when we're talking about the lives of children, the lives of individuals who are being abused by cartels, who are being put into the sex trafficking trade. And oh, by the way, we're talking about danger to Americans as well. And I think the gentleman from North Carolina has a question.
I thank the gentleman for yielding. Not so much a question, but just maybe an emphasis point. I made reference to these facts just a bit ago. But I'll use it here. A fellow named Rolando Marin Sotelo, 22 years old, entered the United States as a UAC. His brothers, Alder, Alfonso, and Arturo, 25 and 29, also illegal aliens in North Carolina, have been indicted for murdering Deputy Wade Byrd, I believe. His last name's Byrd. I may have the first name wrong. In Wake County on August 12th. This is the fact that Rolando, who has been arrested, been charged for possessing ammunition and a weapon by an illegal alien now, He also was stopped. The reason that was discovered is because he was stopped for an illegal tint and fictitious tag on an automobile. You know, we hear a lot in detail about in widespread the big numbers about UACs who are entering into the country. I think we lose sometimes the picture for the massive numbers that we know to be out there. But we know in just a case of an extremely tragic result in my state, resulting from illegal aliens, and you have an illegal alien youth with a family of other illegal aliens who has allegedly committed multiple crimes, is engaging in things like having fake license tags on automobiles, getting caught for that, having weapons. Not knowing what's happening to UACs throughout the country lends itself to that kind of chaos developing. That is what the majority has been completely insensitive to, doesn't care about one whit, and doesn't want the information to come out. I understand politically why, but I cannot understand any other reason that you would not want to let that out. I yield back.
I yield back.
Gentleman yields back. Well, seeks recognition. What purpose does the gentleman from Florida seek recognition?
Move strike last word.
Gentleman's recognized.
Yield to the gentleman from Texas.
Well, I think the gentleman from Florida, I just wanted to be able to engage in colloquy. The gentleman from North Carolina, and happy to do so some more. I do share the sentiment. I was going down the road of one part of the problem, which is the danger posed to the migrants who are abused, knowing where children end up, knowing whether or not they're put into the sex trafficking trade, knowing whether the person who claims to be that individual's uncle or aunt or father or mother is in fact that person and is in fact caring for that person in the supposed name of asylum and caring for kids in this dastardly broken system that has been created purposely by this administration and that is endangering those human beings. And they are human beings. Human beings, the 53 who were dead in the trailer I talked about in San Antonio, the 73 here in a stash house in Washington, D.C., our nation's capital, 12 of whom are children. This is real. This is a very real impact on human beings being used as political chattel. And that's the truth. And the fact is, as my friend from North Carolina was just talking about the abuse there, I assume one of my colleagues may have brought up the illegal immigrant who posed as a minor while crossing border charged with murder in Florida. A 24-year-old Honduran immigrant who's charged with murder in the brutal stabbing death of a Florida man had crossed the United States border illegally months earlier, posing as an unaccompanied minor. An investigation by this newspaper found. Yeri Noel Medina Ulloa was busted October 7th in Jacksonville, where he's found covered in blood after allegedly killing Francisco Javier Cuellar, 46, a father of four who had taken in the immigrant. Think about that. A father of four who had taken in the immigrant who told authorities he was 17. He killed him. And now that guy has fatherless children. Now, this is something we just simply, again, I want to take this back to the basics. This is a resolution of inquiry to seek information from the executive branch to pursue the truth. That's it. That's what we're talking about. And yet, my colleagues on the other side of the aisle are just going to block it. Doesn't matter. Every resolution of inquiry we're bringing up right now, blocked. No. What are my colleagues on the other side of the aisle afraid of? Are they afraid of the truth? Are they afraid that the American people will see that there are rampant abuses going on of both American children and immigrant children? Are they afraid that that truth is going to get out and the American people are going to be absolutely disgusted that the supposedly greatest country in the history of the world has a border that allows this to happen to kids? We just simply have requests for information. That is it. And again, I'd reiterate, I was happy to raise that question when it was a different situation and a Republican was in the White House. I was happy to press and say, you know what? I want that information out of HHS. When my colleagues on the other side of the aisle were grandstanding about kids in cages, when my colleagues on the other side of the aisle were wearing white pantsuits and crying looking through a fence, I was happy to say, you know what? I want to know the truth about where these kids ended up. You know what? I want to know the truth now. I don't give a damn who's in the White House, Democrat or Republican. What in the hell is happening to our border? What is happening to Texans? What is happening to North Carolinians, Floridians, a few Kentuckians? I'd yield to the gentleman from North Carolina if he has anything to add.
I think the point that you make, and the reason I used the example of Rolando Marin Sotelo from North Carolina is you see by examples, and you offered many more, the chaos in the people's lives who are the migrants and the chaos in the people's lives who are living in the community. You know, we heard a lot this week or in the last week or so about Martha's Vineyard not being in position to absorb 50 migrants. They don't have the resources. They're not. It's impossible for them to handle it. They don't have the resources. Usually, what you hear, but I mean, the fact is, I can tell you that in North Carolina, not in Burke County, not in Wake County, not in Orange County, where one of the arrests occurred, you can destroy lives anywhere if you have ungoverned, unmanaged migration and people being sent into unstable circumstances without providing any responsible care. And I yield back.
Yeah, if the gentleman from North Carolina, appreciate getting my time back to finish with this. What about the actual unaccompanied alien children? Reuters reported at the beginning of September that dozens of migrant children are missing in the Houston area. We literally just don't know what happened to them. The Washington Times reported in August on a 10-year-old girl who was smuggled into the United States and handed over to an illegal immigrant family that said they were related to that girl. The government approved the family as sponsors. Then the girl was beaten on at least 20 occasions, torn at the mouth, come out with a knife, and raped by at least 4 members of the family, at one point becoming pregnant before having a miscarriage. That's the state of our current system. I yield back.
Gentleman yields back. Who else seeks recognition? Seeing none.
Gomer,
Gomer,
would like recognition.
For what purpose does the gentleman from Texas seek recognition?
Like the last word.
Gentleman is recognized.
Yeah, and I know we waived the reading of this ROI, but I do think, in following up with what my friend from North Carolina and from Texas had to say, it's important to look at just what is being requested. And I've heard an indictment against both Republicans and Democrats in this committee that we have not, in either party, when either party has been the majority, done adequate oversight of things within our purview. And when we don't do adequate oversight, I don't care how perfect anybody is. I don't care if they're a man after God's own heart like King David was. When you have unaccountable people, then things are going to break down and bad things are going to happen. That's all there is to it. So all this request is asking for, and I'm quoting, I won't read the whole thing, the health and welfare of unaccompanied alien children, including the status of COVID-19 infections, treatment, and outcomes in the care and custody of Customs and Border Protection. Now, why are people, or is anybody going to vote no? We don't care about the health and welfare of unaccompanied aliens. These are unaccompanied. And that means there's a good chance they've been under the supervision of human or sex traffickers. Well, they've definitely been in the possession of human traffickers. That's how they got there. And we're not going to check and say, well, what about COVID? What about their treatments? What kind of outcomes have they had? What about whose care and custody they're in? Who's going to vote no? I know we're going to find out. And my friend pointed out politics would play a role. It shouldn't play a role when it comes to these things. And actually, something I share with a number of my friends on the Republican side is we have infuriated our Republican Party and been punished politically by our party for standing up when we believe that they're wrong and we need something. This is one of those things that people, regardless of their party, ought to stand up and say, you know, you're right. We need to know this information. We need to find out what's happening with these children. And for us to have anybody in this committee that says, you know what, I don't really care. When we need to make an issue out of this politically, like say a bunch of pictures of kids in cages arise, and then people find out, oh, that was during the Obama administration, then we better raise Cain about the Republicans. But then the next is Any current policy, procedure, guidance, or directive regarding the placement of unaccompanied alien children in the care and custody of the Office of Refugee Settlement. Why wouldn't you want to know? What are they doing? Or because I've been out there all hours. I'm telling you, I've watched minors being switched between adults. I've watched them change addresses as to where they want to say they have a relative and can be shipped by the U.S. government. Another request in this request is number of unaccompanied alien children placed by the Office of Refugee Resettlement with sponsors that did not undergo a background check. Holy cow, we really have people on our committee that don't care where these children are placed. I mean, our governmental employees that are placing these, they are so overwhelmed with over 3 million people in the last year or so, and we don't care what's happening. We don't even want to report as to what's happening. That shocks the conscience. Supreme Court's used that term before, and it fits here. What shocks the conscience? When people on this committee would rather just be blasé, oh no, I'll vote no on this. I don't really care what's happening to those children. I don't want to do oversight. Let's just trust the people that are overworked and they can't get their work done. And the kids, you know, they'll come out maybe with a sex offender or whatever. We don't care. This is too important to let this go. We ought to have everybody vote for reporting this favorably. I yield back.
Gentleman yields back. Does anyone else seek recognition? If not, the question occurs on the amendment and the nature of a substitute. The question is on the amendment, the nature of a substitute. This will be followed immediately by a vote on reporting the resolution. All those in favor respond by saying aye.
Aye.
Opposed, no. No. Oh, wait a minute. Aye. In the opinion of the chair, the ayes have the amendment, the nature of a substitute is agreed to. Reporting quorum being present, the question is on the motion to report the resolution HRES 1343 is amended unfavorably to the House. Those in favor respond by saying aye. Aye. Opposed, no. The ayes have it. The ayes have it. Roll call is requested. And the clerk will call the roll.
Mr. Nadler.
Aye.
Mr. Nadler votes aye. Ms. Lofgren. Ms. Jackson Lee.
Man.
Mr. Cohen. Mr. Johnson of Georgia.
Johnson of Georgia votes aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch. Ms. Bass. Mr. Jeffries. Mr. Cicilline.
Aye.
Mr. Cicilline votes aye. Mr. Swalwell.
Aye.
Mr. Swalwell votes aye. Mr. Liu.
Aye.
Mr. Liu votes aye. Mr. Raskin.
Aye.
Mr. Raskin votes aye. Ms. Jayapal.
Aye.
Ms. Jayapal votes aye. Ms. Stemmings. Ms. Stemmings votes aye. Mr. Correa.
Aye.
Mr. Correa votes aye. Ms. Scanlon.
Aye.
Ms. Scanlon votes aye. Ms. Garcia. Mr. Neguse.
Aye.
Mr. Neguse votes aye. Ms. McBath. Ms. McBath votes aye. Mr. Stanton.
Aye.
Mr. Stanton votes aye. Ms. Dean. Ms. Escobar. Mr. Jones? Mr. Jones votes aye. Ms. Ross?
Ross votes aye.
Ms. Ross votes aye. Ms. Bush?
Bush votes aye.
Ms. Bush votes aye. Mr. Jordan? Mr. Shabbat?
No. No.
Mr. Shabbat votes no. Mr. Gomert?
Mr. Cohen votes aye.
Gomer votes no.
Cohen, aye.
Mr. Gomert votes no. Mr. Issa? Mr. Issa votes no.
Cohen.
Mr. Buck?
We will get to members that haven't voted at the end of the roll call.
Mr. Buck? Mr. Buck votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana? Mr. Biggs?
No.
Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Stubbe?
No.
Mr. Stubbe votes no. Mr. Tiffany? Mr. Massey?
No.
Mr. Massey votes no. Mr. Roy? No. Mr. Roy votes no. Mr. Bishop? Mr. Bishop votes no. Ms. Fishbach?
No.
Ms. Fishbach votes no. Ms. Sparts? Mr. Fitzgerald?
No.
Mr. Fitzgerald votes no. Mr. Bentz? Mr. Owens?
Owens, no.
Mr. Owens votes no.
Mr. Cohen?
I vote yes.
Mr. Cohen votes yes. Ms. Garcia, you are not recorded. Ms. Garcia votes yes.
Mr. Chairman, how am I recorded?
Ms. Escobar, you are not recorded.
I vote yes.
Ms. Escobar votes yes.
How is Johnson recorded?
Mr. Johnson, you are not recorded.
Johnson votes no.
Mr. Johnson, Louisiana votes no.
Mr. Benz recorded.
Mr. Benz, you are not recorded.
Mr. Benz votes no.
Mr. Benz votes no.
Are there any other members who wish to be recorded who have not been recorded? Clerk will report.
Mr. Chairman, there are 19 ayes and 16 noes.
The ayes have it, and the resolution is amended as ordered reported unfavorably to the House. Members will have 2 days to submit views. Without objection, the resolution will be reported as a single amendment in nature of a substitute incorporating all adopted amendments. The staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.Res. 1356, a resolution of inquiry requesting the President and directing the Attorney General to transmit respectively certain documents to the House of Representatives relating to Ray Epps for purposes of markup, and move that the committee report the resolution unfavorably to the House. The clerk will report the resolution.
H.Res. 1356 of inquiry requesting the President and directing...
Without objection, the resolution is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. H.Res. 1356 is a resolution of inquiry seeking certain documents, communications, and related materials that refer to an Arizona man named Ray Epps. For those uninitiated in the conspiracy theories of the far right, Mr. Epps has been the object of wild and unsupported accusations that he was an FBI plant directed to instigate the January 6th assault on the U.S. Capitol. While he was at the Capitol on that fateful day, indeed, he was an ardent supporter of Donald Trump, a convenient yet utterly false narrative has been created around him in order to shift responsibility for the assault on our democracy that took place on January 6th. Despite these allegations being thoroughly debunked, he continues to be the target of sustained attacks on his character and his actions, not just by fringe elements on right-wing message boards, but also by such figures as Tucker Carlson, Donald Trump, and even certain members of Congress. In the process, Mr. Epps' life has been shattered. This resolution of inquiry has no foundation in facts. The January 6th committee interviewed Ray Epps twice. In doing so, they found that the cable news-driven theory surrounding him is just that, a baseless, albeit harmful, conspiracy theory. The Oath Keepers did not plant firearms around Washington, D.C. on January 5th simply because they heard an old man shouting that they should invade the Capitol the next day. No prospective rioters ran out to buy body armor and zip ties after a man in a T-shirt told them to march to the Capitol the morning of January 6th. Insurrectionists did not storm the Capitol because a man from Arizona walked around whispering in their ears. And they did not brutally assault law enforcement, desecrate the halls of these buildings, and construct a gallows with a noose while chanting "Hang Mike Pence" because a retiree convinced them that it would be a good idea. Rather, they committed these actions because of one person, Donald Trump. And that is exactly what the Republican Party wants us to forget. We all know that Mr. Trump and many Republicans refused to accept the results of the 2020 presidential election, even though his closest advisors told him that he had lost. We know that Donald Trump planned to contest the certification of the election and pressured his vice president to unilaterally overturn the 2020 election on January 6th. And thanks to the work of the January 6th committee, we know that Donald Trump planned well in advance for his supporters to march on the Capitol, despite the risk of violence. In spite of this overwhelming evidence, ever since the afternoon of January 6th, Trump's supporters have pointed fingers everywhere but at their leader. First, the real culprit was Antifa infiltrating the crowd. Then we were told that what we saw with our own eyes did not actually happen, that no buildings were vandalized, that no law enforcement officers were killed or injured, that it was just a normal tourist visit. Now the new fantasy is that an FBI agitator snuck through a crowd of peaceful protesters, planting the seeds of insurrection in otherwise innocent minds. Such conspiracy theories are easily proven false, and it appears nonsensical that any of them would ever warrant coverage on mainstream media, let alone consideration before a congressional committee. The facts are clear. So why are my colleagues giving this conspiracy theory the time of day? We are here because Republican candidates across the country benefit from the noise and confusion caused by conspiracy theories. In a world full of misdirection, they want to exploit voters' uncertainty, play on their deepest fears, and manufacture their own reality. Since January 2021, the GOP has doubled down on the fantastical assertion that Trump actually won the 2020 election. But the GOP's embrace of conspiracy theories has not been limited to these false claims. In recent months, the party's de facto leader, Donald Trump, has engaged with a broad range of provably false narratives. He promised a pardon and an apology to insurrectionists if he regains power, and he identified himself with the mass delusion known as QAnon. The latter is a movement that was labeled a domestic terrorism threat by the FBI because of its ability to incite violence among its believers. If this sounds like a dangerous game, well, it is. Conspiracy theories, especially those that use violent or hateful language to describe political opponents and our fellow Americans, are a danger to the very survival of our republic. Democracies persist when political leaders prioritize the sanctity of their Constitution and the peaceful transfer of power, not to mention fidelity to the truth over their own political successes. I believe our nation will withstand the forces of Donald Trump and his supporters, and that our democracy will transcend this moment in history. But to do so, we must move past the conspiracy theories that percolate on far-right extremist message boards. By rejecting this resolution, we can take a first step down that road together. I oppose this resolution, and I encourage my colleagues to do the same. I now recognize Mr. Massey for an opening statement.
Mr. Chairman, there's a deep concern in this country about the politicization of federal law enforcement. I'm glad that you talk about conspiracy theories. I wonder if it was a conspiracy theory that there were FBI informants and agitators helping to plot the kidnapping of a governor in Michigan. I guess that was just a conspiracy theory. I guess it was just a conspiracy theory that the federal government encouraged social media companies to withhold information that would have been pertinent to the last election. Maybe it was just a conspiracy theory that Hunter Biden's laptop was Russian disinformation. Oh, wait, that was the Democrat conspiracy theory. And what was the truth? The truth is it wasn't disinformation. The truth is that the federal government encouraged the media, the media who succumbed to this should have been ashamed, the social media, to withhold that for days, and that could have affected the last election. Just weeks ago, the FBI was unleashed on a former president of the United States and other political adversaries of the Biden administration. A member of Congress's cell phone. What about this speech or debate clause in the Constitution? A member of Congress's cell phone was taken by the FBI against his will. This is as wrong as it gets. Taxpayers deserve to know the full truth about how justice is being administered in the United States. That's why this resolution before us is so important. The resolution seeks critical information about a situation the DOJ has been wholly unwilling to tell us the truth about. The chairman's right about one thing. This is easily proven false. It could be thoroughly debunked, but it hasn't been because the administration, the FBI, even the Congressional January 6th Committee is withholding information that could do that. That's what this whole resolution is about. Let's debunk that. On January 5th, 2021, a video was posted on Twitter of a man, Ray Epps, shouting, "We need to go into the Capitol." Not to the Capitol, into the Capitol. There's this, the Democrats say that this was a well-planned, orchestrated raid on the Capitol. Well, the one shred of evidence that something happened the day before January 6th, that this wasn't spontaneous on January 6th, was this man on January 5th saying, "We need to go into the Capitol." He also said, "I'm probably going to go to jail for it. I'm probably going to go to jail for it, okay? Tomorrow, we need to go into the Capitol." The crowd around him started chanting, "Fed, Fed, Fed," repeatedly implying that Epps was a federal agent or was working on behalf of a federal agency. In other videos of Epps on January 6, 2021, he was seen standing outside the Capitol, speaking with other protesters just before the crowd begins to move past the barricades toward the Capitol. Epps was number 16 on the FBI's most wanted list in connection with the events of January 6th, but was removed from the list on January 1st, 2021, for unknown reasons, no explanation. In January 2021, a reporter spoke with Epps, who admitted to being in Washington, D.C. for the rally. When the reporter asked whether he had made the comment of "we need to go into the Capitol," he said the only thing that meant is we would go in the doors like everyone else. It was totally, totally wrong the way they went in. Well, if that's true, why did he say, "I'm probably going to go to jail for this"? Why did Ray Epps say that? He denied any wrongdoing, but many questions lingered. During a House Judiciary Committee, this very committee here, on October 21st, 2021, nearly a year ago, Attorney General Merrick Garland has had a year to clear this up, but because nearly a year ago, I asked him, "Can you tell us, without talking about particular incidents or particular videos, how many agents or assets of the federal government were present on January 6th? Whether they agitated to go into the Capitol, and if any of them did?" What was his answer? He could have stopped it right there. He could have told America, he could have looked at the screen, and he could have said, "No, I can assure you that did not happen." And instead, he said, "I'm not going to comment. I'm not going to comment on an investigation that's ongoing." He believes that FBI policy trumps the ability of this committee to have oversight into what the DOJ has done. It doesn't trump our ability. Similarly, during a Senate hearing on January 11th, 2022, Senator Ted Cruz asked then FBI official Jill Sanborn, "Did federal agents or those in the service of federal agents actively encourage violent and criminal conduct on January 6th? In response, Sanborn stated, quote, "Not to my knowledge, sir." Senator Cruz then asked, "Was Ray Epps a Fed?" And at this point, the FBI could have put this to rest. There's nothing in the law that says she couldn't answer this question. In fact, I would argue that the Constitution compels her to answer the question to a member of the Senate. But instead, she said, "Sir, I cannot answer that question." Mr. Chairman, this is a pretty simple question that goes to the heart of America's trust in their government. If Ray Epps was not working with federal law enforcement, they should say that without equivocation. If there were FBI agents or assets present at the Capitol on January 6th, the American people deserve to know. This resolution of inquiry would help us get answers to these questions. I urge support, and I yield back.
Gentleman yields back. Will seeks recognition.
Mr.
Oh,
Chair,
without objection, all other opening statements will be included in the record. Are there any amendments to the amendment? I now recognize myself for purposes of offering an amendment in the nature of a substitute. The clerk will report the amendment.
Amendment in the nature of a substitute.
Without objection, the amendment in the
HRS.
nature of a substitute will be considered as read and shall be considered as base text for purposes of amendment. I recognize myself to explain the amendment. This amendment makes only minor technical changes to the underlying resolution, such as including the full names of President Biden and Attorney General Garland. I urge all members to support the amendment. I yield back the balance of my time. Are there any amendments to the amendment in the nature of a substitute? For what purpose does Mr. Jones seek recognition?
Mr. Chairman, I move to strike the last word.
Gentleman is recognized.
It is pathetic that Republicans have chosen to retreat to the dark corners of the internet and to QAnon conspiracy theories rather than face the horrific, tragic reality of what happened on January 6th. On January 6th, Congressman Gosar, who introduced this resolution of inquiry, sent out a tweet claiming that the insurrection had, quote, all the hallmarks of an Antifa provocation. That myth was immediately debunked by news outlets through their documentation of and conversations with MAGA insurrectionists themselves. In search of a new boogeyman, a scapegoat to avoid Donald Trump or Republicans in Congress having to take responsibility for what happened on January 6th, Congressman Gosar latched onto a new conspiracy theory. In July 2021, he claimed in a fundraising email that, quote, the FBI might have had a hand in the January 6th attack. And in a plot twist worthy of Ryan Murphy's productions, Mr. Gosar actually targeted a fellow MAGA insurrectionist and election denier from Arizona by the name of Ray Epps. That's who we're talking about today. Let's set the record straight. On January 5th, 2021, the day before January 6th, Mr. Epps pranced around Washington, D.C., telling others that he thought it was a good idea to enter the Capitol. He did this again the morning of January 6th. All of this in a misguided attempt to help President Trump steal the presidential election. These comments from Mr. Epps received, at most, mixed reactions from his peers. Moreover, on January 6th, other insurrectionists reported that Mr. Epps actually tried to calm the crowd down, making it difficult to support an incitement charge. Mr. Epps never entered the Capitol, taking trespassing charges off the table as well. However, 2 days after January 6th, Mr. Epps saw his name on a list of persons that the FBI wanted to speak with. Knowing that he had acted, in his own words, stupidly, Mr. Epps contacted the FBI tip line and spoke with FBI agents for over an hour in an effort to avoid being prosecuted. The New York Times confirmed this from Mr. Epps' phone call records, and they also received transcripts of additional interviews that Ray Epps later conducted with the FBI. There is nothing unusual about a guy who did not actually go into the Capitol on January 6th and who did not actually incite violence not being indicted. In fact, hundreds of insurrectionists have not been formally charged thus far. Ray Epps is not special in this case. And frankly, I resent having to defend a guy who's so dumb that he still feels the election was stolen from Donald Trump. But Mr. Epps and his wife have now had their lives threatened, and they've had to go into hiding because of this latest conspiracy theory by MAGA Republicans to distract from the existential threat that Donald Trump and the Republican Party pose to our democracy. Mr. Chairman, I struggle to identify Republican members of this committee who take what happened on January 6th seriously. Certainly not the ranking member. Mr. Jordan was one of the biggest cheerleaders of the big lie that led to the insurrection, and he organized this body's election objectors.
I'd ask that the gentleman's words be taken down.
When it came time for Congress
I
to
ask that the
certify
gentleman's
the
words be
results.
taken.
Gentleman will suspend.
I would join in that demand for the words to be taken down. Jim Jordan is not a criminal as he's been portrayed.
Mr. Chairman, all I said thus far is that Mr. Jordan
gentleman
was
should
the biggest
suspend.
cheerleader.
The gentleman will suspend.
I'll leave mine on just in case I gotta go fast. That's good, I love it. That guy treats that issue pretty fairly.
Yes, he's pretty good. Occasionally lets him get away with something I wouldn't, but
He's probably not gonna get away with it here, but
he's probably right.
he said Jordan was a sponsor of the big lie. That's, you can't call somebody a liar.
Right, and leader of insurrection, didn't he say?
He said it's
Turn your mic on.
Would the gentleman like to withdraw his remarks and rephrase?
Of course, Mr. Chairman. The ranking member was the biggest cheerleader of the falsehood that the election was stolen from Donald Trump by President Biden. And he organized this body's election objectors when it came time for Congress to certify the results. Mr. Jordan has also refused to cooperate with the January 6th committee's bipartisan investigation of the events of that day. But I'm not picking on Mr. Jordan. Mr. Gates has referred to those present at the insurrection as, quote, patriotic Americans. What is so patriotic about a mob violently assaulting and injuring, and in some instances,
Will the gentleman yield
killing,
to answer his
if
question?
I have time left, sir, Capitol police officers to gain entry into the Capitol? I'm going to go to Mr. Bishop now. Mr. Bishop has said that if January 6th was an insurrection, it was the worst example of an insurrection in history. Did you want the insurrection to be more successful, sir?
No,
How many more people needed to die in order to
asking-
reach your definition of an insurrection?
I'm sorry, I thought
These
you
are
were
the
asking me a
facts.
question.
On January 6th,
Did you want me to answer the question, or you just want to talk?
The gentleman from New York has the time.
and I'd like
Sorry,
some-
Mr. Chairman, I was
and I'd like
confused.
some
I
of
thought he
that
asked me a
back.
question.
And I'd like some of that back because a good chunk of it was
The
stolen.
gentleman from New York has the time.
Just like the election.
These are the facts. On January 6th, at the direction of Donald Trump, a violent mob stormed the Capitol in an attempt to change the results of a free and fair presidential election. In the process, 138 Capitol and D.C. police officers were injured.
Mr. Chairman, the
A
gentleman's
Capitol
time has
police
expired.
officer was bludgeoned to death, and 2 more Capitol police officers died by suicide in the days that followed. I'm wrapping up, but I deserve my time back that you stole from me, Mr. Bishop. Liz Cheney, who until recently
I would ask that
was
the gentleman.
Time is the gentleman's.
Be taken down.
Liz
He
Cheney,
accused
who
another
until
member of
recently
Congress
is
Time
Mr.
is the
Mr.
gentleman.
Gohmert, Mr.
That
Gohmert,
is a
the time is
violation of
mine.
the rules of
Mr.
decorum.
Gohmert, the time is
His
mine.
words need to be taken down.
The
Gohmert.
gentleman's time is expired.
I'm wrapping up.
Gentleman's time is expired. Who seeks recognition? Who seeks recognition?
Mr. Chairman,
The gentleman
The
from
committee will
Texas.
suspend.
Mr. Chairman,
Which word? We are trying to find out which words he is objecting to.
Mr. Gohmert, what words do you believe should be taken down?
When he said that that Mr. Bishop stole his time, the use of the word stole impugns his integrity and says he committed.
Mr. Gohmert, that is a figure of speech with respect to time that is hardly taken downable.
Oh, okay, so there's nothing wrong with saying something was stolen. All right, so y'all take everything back about saying the president.
Mr. Gohmert, the difference is I didn't incite an insurrection.
No. The gentleman's time has expired. Who
Mr.
seeks
Chairman,
recognition?
Mr. Chairman,
I would
For
like
what purposes?
Gohmert would like
Does Mr.
time.
Gohmert seek recognition?
Yes, I do.
Gentleman is recognized. You have
Thank
to
you
strike,
very
the gentleman is recognized for 5 minutes.
I've learned a great deal here. And as far as Mr. Bishop trying to steal time, and now that I know from the chairman, there's nothing wrong with using the term steal. When Mr. Bishop was asked a question, reasonable minds would not think that he was stealing time to try to answer the question that was posed to him.
Will the gentleman yield?
But obviously there was no, I'm not going to yield because we couldn't get time to answer the questions before, so I need to do it now. Now, this is a reasonable request. Things that get transparency help calm things down. And there's nothing but secrecy that is surrounded very important, very legitimate questions arising out of January 6th. As I've said many times, anybody that engaged in violence, anybody that committed a crime needs to pay for the crime. But what we have seen is such a difference in treatment. I mean, Simone Gold, it appeared to her that people were being allowed in the Capitol. She is the first woman in the history of the Department of Justice to have no criminal record. She's got her JD. She's saved lives of friends of mine as a doctor. And she was guilty of misdemeanor trespass, first woman ever to be sent to a maximum lockdown facility for a misdemeanor trespass with no violence, no prior history. There's been a great deal of unfairness. And when I heard this comment that basically Republicans lied when they said no law enforcement officer was killed there on January 6th, there were law officers injured. And as a judge and as a member of Congress, somebody injures a law enforcement officer, that's serious and they need to pay a price of incarceration. That's just the way it is. You don't do that. But my understanding is no law enforcement officer actually was killed. I know there was a lot of false information that was put out. We had some tragic situations where because of January 6th, some law enforcement officers took their own lives. Tragic, but the person that was quite obviously killed was Ashley Babbitt. And as far as Trump's, as far as lies, you've got to understand some skepticism by Republicans because we're still hearing people talk about Trump's collusion with the Russians to steal the 2016 election. That's still being talked about. And we know for sure after the big time millions of dollars spent on Mueller's investigation and follow-up investigations, there was no collusion between Trump and the Russians to steal the election, but there was collusion between the Clinton campaign, the DNC, the FBI, who hired Danchenko. They all were working with a Russian spy to collude to try to take down candidate Trump. There's no question about that. That occurred, but it appears that that kind of crime is not going to be punished. And so you got to understand on the other side, the skepticism that arises when we hear these claims like Russian collusion for 6 years. And so, but still, when I see a guy on video demanding people go into the Capitol,
will the gentleman yield?
That's inciting a riot. That's inciting insurrection. And even though, as surely the lawyers on the committee know, you don't actually have to get somebody to do some destructive act. if you're inciting them. And people did enter the Capitol just as Ray Epps wanted. My time expired. I yield back.
Mr.
Gentleman
Chairman,
yields back. Who seeks recognition?
Mr. Chairman,
What purpose does Ms. Deming seek recognition?
move to strike the last word.
And ladies recognized.
I'd like to yield time to Mr. Jones of New York.
Thank you, Ms. Demings. I was going to wrap up, but since Mr. Gohmert wanted to chime in, I couldn't help but contemplate some of the words that he just uttered, about taking January 6th seriously and being horrified by the violence that occurred that day. I mean, I'm looking at an article in the Texas Tribune from June 23rd, 2022, titled, U.S. Rep. Louis Gohmert asked Trump for a pardon after insurrection, January 6th committee reveals. And so I would love, if he would like to appear on screen again virtually, for him to answer the question of whether it's true or not that he asked the former president for a pardon with respect to his conduct in connection with January 6th. But as I wait for him to appear on screen, I do want to proceed. These are the facts. On January 6th, at the direction of Donald Trump, a violent mob stormed the Capitol in an attempt to change the results of a free and fair presidential election. In the process, 138 Capitol and DC police officers were injured. A Capitol police officer was bludgeoned to death, and 2 more Capitol police officers died by suicide in the days that followed. Many of us in this room nearly died. Can you please treat what happened with the seriousness that it deserves? That is all I ask of my Republican colleagues. This resolution of inquiry is an absurdity, and it makes a mockery of people who sacrificed so much for us and for this country on January 6th. Would you please stop choosing Donald Trump over the American people? Liz Cheney, who until recently, until you kicked her out, was the chair of the House GOP caucus, recently shared a story from her experience on January 6th. In the cloakroom that day, one of the Republican members signing up to object to the 2020 presidential election results muttered out loud, "The things we do for the orange Jesus."
Would the gentleman yield for a question?
1 second. This loyalty to orange Jesus, Mr. Bishop, is going to ruin our democracy. And more innocent lives are going to be lost in the process if you guys keep this up. It is not too late to join House Democrats in honoring our oath to the Constitution. And yeah, I will yield to you.
Forgive me, I wasn't listening. We were conversing a bit. But did I hear, and I think, did you say that a police officer was bludgeoned to death by the crowd at the January 6 riots?
I said a police officer was bludgeoned to death. I did not say at the hands of whom, Mr. Bishop.
Just who are you referring to, if you don't mind saying?
I can get that information for you in a few minutes.
Well, I just want to make sure, because
are you denying that that at least one Capitol police officer was murdered in the midst of what happened on January 6th?
Yeah, I think I am denying. I mean, here's what I understood, that there were reports early on that Sicknick was struck with a fire extinguisher, and that subsequently was debunked as false. He died of natural causes that were not connected to the event. Are we talking about the same person, Sicknick, or are we talking about somebody else? Seriously, I mean,
It's a genuine question, because the medical examiner, the U.S. Capitol Police put out a report agreeing with the medical examiner finding the USCP officer Brian Sicknick died of natural
Bishop,
causes.
well, just an initial thought, and I know that Mr. Roy, you two are an attorney. Mr. Bishop speaks often about how brilliant of an attorney he is. We're talking about but-for causation of Officer Sicknick's death, and so I would hope that you would at least concede, at a minimum, that Mr. Sicknick died as a result of what happened on January 6th. And I'm disappointed if you would suggest otherwise, sir.
Well, I don't think that's correct either, but was he bludgeoned to death? Is that, because I think Ms. Demings was even looking at, we were sotto voce between me and her saying he was. I'm sincere as I can be. My understanding is that was debunked, and Mr. Roy just read the medical examiner's information. Do you guys contend that he was bludgeoned to death?
I contend that 138 Capitol and DC police officers were injured, and that multiple Capitol police officers died as a direct result of what happened on January 6th. And I hope that you...
It's your time. You don't have to answer.
I hope you can see how one would question the sincerity of such a minute point in the midst of the gravity of everything else.
Would the gentleman yield?
Yeah.
Would the gentlelady yield? Ms. Demings, would you yield? I am reading at approximately 9:30 p.m. on the evening of January 7th, United States Capitol Police Officer Brian Sicknick passed away due to injuries sustained while on duty. Officer Sicknick was responding to the riots on Wednesday, January 6th, 2021 at the U.S. Capitol and was injured while physically engaging with protesters. Unquote. I yield back.
I would hope that would answer your question, Mr.
What were you quoting? Time has expired. Google. I just Googled Brian Sicknick.
Google? An article or something?
The gentleman.
Well, it's not like you respect the press anyway.
Who seeks recognition?
I seek recognition. I'm sorry.
No,
Mr.
go ahead.
Massey.
Go ahead.
Yeah, I seek recognition.
The gentleman from Florida is recognized.
Mr. Chairman, what were you quoting?
Reading from statement from the family of U.S. Police Officer Brian D. Sicknick.
Okay, so what I think is giving some confusion to us is that when we review the medical examiner's report, it suggests one thing, and that maybe the family put out a statement that might not have been entirely consistent with that. But there was not a
No, actually, excuse me, I was wrong. Below that is the statement. This is actually a statement from the U.S. Capitol Police.
Okay, that's what I'm trying to figure out. Also, I think that statement predates the report that suggested a cause of death based on science, not based on chronology. The broader point is that there wasn't a Capitol Police officer bludgeoned to death on January 6th. People can take exception with what was written about Mr. Sicknick.
Yeah, but Mr.
Certainly
Gates,
it's a tragedy that he died.
Mr. Gates.
Hold, Mr. Jones, here's what I find real interesting. The January 6th committee got its authority to set the historical record, to deliver the truth to the American people. And they couldn't even deliver the truth to the gentleman from New York. I mean, we had this entire committee process that was supposed to inform the country as to what happened. And on this basic question, it seems as though my colleague fell for an urban legend.
Mr. Gates.
Would the gentleman yield?
You concede that if January 6th, if the insurrection had not happened on that day, Mr. Sicknick would still be alive.
That's not how cause of death is determined, Mr. Jones. Cause of death is not determined but for causality. It's a scientific thing that caused the death. You have the actual decision. Look, at the end of the day, this ROI is about whether or not we're going to get the information.
Time belongs to the gentleman from Florida.
Whether or not we're going to get the information about the federal.
Mr. Gates, will you yield?
I tell you what, y'all have not been too kind on the yielding, so I'm going to finish my point.
I yielded to Mr. Bishop.
Well, lucky for him, I guess. My point is that I'm supporting the ROI. I believe it should be advanced to the House favorably because we have not gotten straight answers from the federal government about their activities on January 6th. And that is what we seek. And we know that you're going to vote against this request for information, but we are utilizing this time today because it is important for us to showcase to the American people what they're going to be getting in a House majority. And by the way, some of the people making debate aren't even going to be part of the minority because they couldn't win their primaries. But in the majority, when we take over, accountability is coming. These questions are going to be answered, and you're going to have federal officials in depositions and before us responding to these things. And maybe after that, we won't have members of Congress saying that you had Capitol Police officers bludgeoned to death on January 6th when that is not a scientific finding.
But we will still have multiple Republican members of this committee having asked President Donald Trump for pardons in connection with
the gentleman from Florida.
Mr. Gates, that would include you, Mr. Gates.
I tell you what, Mr. Jones,
that would include
we'll
you,
have
Mr.
a great
Gates.
time. We'll have a great time on this committee.
The gentleman from Florida controls the time.
Yeah, and I would leave the Smarty Boy comments to those of us who win our elections. I yield back.
Gentleman yields back. Who else seeks recognition?
I do. I yield, Mr. Bishop.
I think the gentleman, you have time left? I thank the gentleman for yielding. I wonder whether, there are 2 minutes left. I wonder whether, Mr. Gates, you would yield to the chairman for an answer to one question. The chairman said, and this is quite important, we're saying this for a national audience from the House Judiciary Committee. And whatever I say, I'm perfectly willing to be held responsible for my comments. But I asked the chairman, what was the date of the statement that you cited from the U.S. Capitol
January
Police?
7th, January 7th, 2021.
Okay, then what I would like to relate to the committee and to the American people is that on April 19, 2021, that's later than your statement, Mr. Chairman, the U.S. Capitol Police issued a statement that says headline, medical examiner finds USCP Officer Brian Sicknick died of natural causes. And then the statement is, the USCP accepts the findings from the District of Columbia's Office of Chief Medical Examiner that Officer Brian Sicknick died of natural causes. It goes on from that, but there's no medical evidence that he died from any injury sustained during the January 6th event. There's no, he was sprayed by bear spray or some kind of mace during the course of that, but they've not connected that to his death. So
will the gentleman yield?
I mean, all this matters very much. I've seen, the thing is that the lies get piled on top of each other.
In earnest.
And then I've heard some people characterize, I see it say repeatedly by people that 5 people were killed during the riots. It's just, or whatever you like to call it, the insurrection. It's not true. I really genuinely, attack all you want. I think we ought to first deal with the truth.
It's not an attack, Mr. Bishop.
I mean, and I certainly don't want to argue about that. I think we ought to decide what the truth is. And if you're saying that there was somebody bludgeoned to death, a police officer bludgeoned to death on January 6th, or any number of other things that get more.
Mr. Bishop, you don't want to get to the truth because you didn't vote to impanel a select committee to investigate what happened on January.
Gentleman's time has expired. Who seeks recognition? For what purpose does the gentlelady from Pennsylvania seek recognition?
To strike the last word.
Gentlelady is recognized.
Pardon me, Mr. Chairman. I just have to say, whether Mr. Officer Sicknick died of, quote, natural causes, he engaged on our behalf, the insurrectionist. He engaged them, and following that engagement of people using Trump flags and American flags as spears to beat and to bludgeon police officers, he suffered 2 strokes. The conversation you all just engaged in is so shameful. I hope the Sicknick family was not watching this. You bring shame on this body for not saying we
I
are
ask that the lady's words be taken down. To accuse a fellow member is out. That language is unparliamentary. The fact that she engages in it a lot doesn't change the fact that it's unparliamentary.
What is wrong with my use of the word shameful?
Your accusation of a colleague as being shameful brings that colleague into disrepute. That's exactly what the rule is intended to prevent.
Mr. Chairman?
I'd ask for a ruling on my
Gentleman will
request.
suspend. The gentleman will suspend.
So I withdraw the use of the word shame or shameful because apparently that's not allowable or even happens anymore. People don't even recognize shame anymore. So I've been asked to take that down.
I'd ask the lady
I'll take
words
that
be
down,
taken down again.
and I'll say it's extraordinarily disappointing.
She said what you just accused us of is not being capable of recognizing shame.
Does the gentlelady rephrase?
Why don't you withdraw the improper comment?
Gentlelady rephrase?
You know what I would ask?
I
would think would be the proper remedy? I'll take my words down.
Good.
What would be the proper remedy is if that conversation from that side of the aisle would be taken down on behalf of the family of Brian Sicknick, who died defending us, suffered 2 strokes defending us.
I'd like to be heard on the request.
Will the gentlelady yield? Will the gentlelady yield?
I will yield.
Wait a minute. I'd like to be heard. She just requested that our words be taken down. I'd like to be heard on that request.
Well, I'd like to associate myself completely with the
before anybody else talks.
Point of order. Mr. Raskin is not recognized.
But how do I deal with this?
What? Oh, don't worry.
There are votes on the floor. The committee will recess until the votes are finished and the members are requested to.
Mr. Chairman, I'd ask that this
Point of inquiry.
Point of order.
Point of stands in recess.
Before the
We got a
meeting
ruling
travels
on
out.
that. You guys
We
can't-
need a ruling on her request, and I need to be heard on it.
We just wait for her to pop up on the screen.
She's popped up.
Well, no, we want to see her face.
Okay.
before we act.
Know that. The committee will come to order. Before we resume, I want to note that while the subject stirs strong emotions, I would urge all members to treat each other with respect as we engage in this debate. The gentlelady from Pennsylvania.
Yeah, Ms. Dean is recognized.
Is right. The gentlelady from Pennsylvania is recognized. Ms. Dean.
Thank you, Mr. Chairman, for recognizing me. And to continue where we left off, I wish to withdraw my request to have the words of the other side taken down in this most recent conversation. If that's acceptable to you, Mr. Chairman, that is my wish.
The request is withdrawn. And the
And
gentlelady
I
is
would like to
recognized.
yield. Thank you. I would like to use and yield the remainder of my time to Mr. Raskin.
If Mr. Raskin is here, he does not appear on the board. He was in the back.
Mr. Raskin can be recognized for his own time.
Mr. Raskin can be recognized for his own time. He doesn't seem to be here. Who else seeks recognition?
Then, Mr. Chairman, I yield the rest of my time. Thank you.
Gentlelady yields back. Who else seeks recognition? What purpose does Mr. Massey seek recognition?
I'm going to do the video if that's all right. I move to strike the last word and I have a video.
Gentleman is
show.
recognized.
We have a video to show if we could start that.
In fact, tomorrow, I don't even like to say it because I'll be arrested. Well, let's not say it. We need to go, I'll say it. All right. We need to go in to the Capitol. Let's go! So I'm going to put it out there. I'm probably going to go to jail for it. Tomorrow, we need to go into the Capitol. Into the Capitol. Peacefully. Fed. Peacefully. Okay, folks, grab the word. As soon as the president's done speaking, we go to the Capitol. The Capitol's this direction. Start speaking. We are going to the Capitol, where our problems are. It's that direction. He spread the word.
Well, there you have it. This is the only person that we have on video before the events on January 6th saying, go into the Capitol, go into the Capitol. He says, I'll probably go to jail for this. I'll probably be arrested. He knew what he was saying. And what strikes all of us on this side of the aisle as just incredible is the lack of curiosity on the other side of the aisle. They want to get to the bottom of this. They claim that somebody planned it. You've got somebody here the day before planning it, somebody the day of directing hundreds of people where to go, and then being present at the very first breach of that outer perimeter, the first bike rack that went over, he's whispering in somebody's ear. Well, the FBI knew this was somebody to investigate, and they made him number 16 on their most wanted list. Number 16. But by July, without explanation, they took his name off of and his picture off of their website. So what this resolution is getting information. What information does the federal government have? I've asked Merrick Garland this. I asked him in the committee almost a year ago. By the way, he's had a year to clear this up, and he hasn't done it. How many agents or assets of the federal government were present on January 5th and January 6th and agitating to go into the Capitol? Here are the kind of things that we need to get. The Epoch Times reported that Epps said in an interview with the FBI, "I was afraid they were going to set off an explosion on one of the side streets," Epps said in an interview. Why don't we have that interview? Why have none of us heard that interview? And this is the only man who had a premonition that there were going to be pipe bombs on January 6th, and then we find pipe bombs, one of them at the DNC, where Kamala Harris, Vice President-elect, Senator Kamala Harris, was taken to the DNC, allegedly, while this pipe bomb was there. The Secret Service swept the area, and they found nothing. They put her there. Later, they find the pipe bomb. How did Ray Epps know that there were going to be pipe bombs? Also, the other thing that we need to know, and comes from a New York Times article, Mr. Epps also said he regretted sending a text to his nephew well after the violence had erupted, in which he discussed how he helped to orchestrate the movements of people who were leaving Trump's speech near the White House by pointing them in the direction of the Capitol. Why don't we have that text? Does the FBI have the text? Does the New York Times have the text? Why are we getting Mr. Pillow's guy's phone and not Mr. Epps' guy's, or Mr. Let's Go Into the Capitol guy's phone? Why is there no interest on the other side of the aisle in finding these things out? This is all we're asking for. This is all the resolution does. It says to the president and to Merrick Garland, give us this information. Now, the January 6th committee allegedly interviewed him. They said they would release the transcript of that interview. They did not. They have not released it. A staffer released a carefully worded statement proclaiming his innocence. Yet we don't know if he was under oath. We don't know if he really said it. And I will yield back the balance of my time and urge adoption of this amendment by Mr. Gosar from Arizona.
The gentleman yields back. Who seeks recognition? For what purpose does Mr. Roy seek recognition?
Move to strike the last word.
Gentleman is recognized.
I might yield a little bit more time to Mr. Massey on this subject, give any time he wants, but I just want to take 2 minutes to just point out my concern with the exchange that happened earlier. Because my friend, Mr. Bishop from North Carolina, inquired of one of our colleagues on the other side of the aisle who had used a phrase, and that phrase was something in the zip code of beaten to death or bludgeoned to death. And which is a very specific and powerful word and invokes certain imagery and certain set of facts. We're lawyers, and we're the House Judiciary Committee, and I believe it's important that we get facts correct. And I believe Mr. Bishop was trying to do that, and we had a back and forth on that. And I think it was instructive, respectfully to the chairman, that the chairman pulled up a story to try to defend that characterization, Googled a story that was dated January 7th, which predated by 3 months the April, I think, 19th, that's from my head, dated release of the finding by the medical examiner that he died of natural causes. That's not to imply that there's not a connection of the natural causes to whatever he experienced. That's another question, right? It raises questions under civil liability in terms of but-for causation and so forth. Fine. I mean, we just want to pursue the facts and the truth. The truth is you had a determination by the medical examiner that there was natural causes. Subsequent to that in September, there were 2 individuals who pled guilty to attacking and spraying a substance on Officer Sicknick. And that's troubling and problematic, and we should seek that out. And I hope that this committee, should the Republicans have the gavel, will seek the truth about all of those individuals who have been charged with crimes under January 6th, to understand those that are charged properly because they engaged in behavior that was inappropriate, attacking police officers and causing harm to our officers and the Capitol Hill Police that are protecting us every day, and those that are being wrongfully charged or have parading charges because they crossed a certain line a certain day because things were barriers were pulled down. There are a lot of questions that I think this committee ought to be trying to seek the truth. But it is instructive and important that what we just saw happened, and that we should strive to not do that. We should strive to just seek the truth and to use the right words and then make our judgments. That's what I believe, and I think it's really important and instructive. I will yield the balance of my time to Mr. Massey.
I thank the gentleman from Texas, and I want to talk about what a senator from Texas said in a hearing and the response that was given to him by the Assistant Executive Director of the FBI. During a Senate hearing on January 11th, 2022, Senator Ted Cruz asked then FBI Assistant Executive Director Jill Sanborn, did federal agents or those in service of federal agents actively encourage violent and criminal conduct on January 6th? In response, Sanborn stated, not to my knowledge, sir. Senator Cruz then asked, was Ray Epps a Fed? And Sanborn responded by saying, sir, I cannot answer that question. This was January 11th. If the reason she couldn't answer that question is she did not know, she's had 9 months to answer that question. Merrick Garland has had almost 12 months to answer the question I posed to him. And he saw the same video that I just showed here. Now, our chairman today said that these theories have been thoroughly debunked and they're easily proven false. Well, it's easily proven false if they would release this information. If the federal government would tell us, point blank, no uncertain terms, under oath, not some staffer, not some statement released on some hearsay, not by leaking it to the New York Times, not by trying to soften the blow by putting things out in the press. Just come here and tell us. And in the chances they've had to come here and tell us, they haven't told us, and that is why the resolution is necessary. We need to know about this person because it just defies logic that he would be not a person of interest to the FBI or to the Democrats, since he's the one who had the premonition of the pipe bombs on the side streets, which, by the way, did show up, which, by the way, we don't know how they got there. They're still trying to figure that out. And you would think if a pipe bomb at the DNC that was foreseen by this man, Mr. Ray Epps, you would think that that would be of interest to Democrats. And I'm at a loss to understand why not. And I yield back to the gentleman from Texas.
Yield back.
Gentleman yields back. Who seeks recognition? What purpose does Mr. Bishop seek recognition?
To speak to the matter.
Strike the last word.
If you prefer it that way, Mr. Chairman, yes.
Gentleman is recognized.
What is interesting about today and the debate that occurred and the multiple times that members on the majority side were compelled to withdraw their statements to avoid a determination that they're unparliamentary is, and also the underlying merit of this resolution is that truth matters. The facts matter. The old saying is you can have your opinion, everyone can have this opinion, but there's only one set of facts. Actually, it said, it's not a correct quote, but it's somewhere close to the sentiment. For the administration, let me make a
correct quote is everyone is entitled to their own opinion, but not to their own set of facts.
Thank you, Mr. Chairman, for cleaning up my distortion of that, or my butchering of that statement. But it's been so potent because it's self-evidently correct. And another very clear idea is that for the administration of justice to command respect and to function, it must be fair and impartial. Fairness and impartiality requires that similar acts be treated the same and regarded the same. Many Americans today, I say many, I can't speak for 330 million Americans, but I can read polls and then I go out and encounter people out in public, and that's how I gain whatever information I'm about to assert. But I would submit to you that many Americans believe that there is a dual standard of justice in the country. They look at the incidents of Hillary Clinton's email scandal and how that was resolved, and they compare that to the FBI's investigation of Donald Trump and the following Mueller investigation. They see inequality. They see inequality, by the way, between the email scandal and the way President Trump was treated in Florida with the criminal search warrant execution at Mar-a-Lago. People watched the courthouse, the federal courthouse in Portland, attacked consistently and with an obvious plan and purpose for 200 and something nights in a row, if I remember correctly, where federal officers would have to, federal protective services officers would come out and try to defend the courthouse, put out fires, and it happened over and over and over again. And they saw, they saw the Capitol riot. I'm actually not equivalating those two, because the Capitol is the capital of the United States, no doubt about that. But they've seen they believe a very different treatment of people, particularly in the concept of pretrial detention and discretionary determinations about how that should apply, and dismissal of charges and the like. Nothing, though, reinforces, and by the way, I'm going to say one other thing quickly, because I'm often accused, I was accused today, using my words about if it was an insurrection, it was the worst insurrection in the history of the world. What I meant there is, it appears more to have been a riot. It is a very disgraceful riot. But it was a riot. An insurrection would have taken, and there were maybe some groups of clad people in helmets and so forth who had a plan, some small people, but in the main, it was a split off of protesters in Washington, and that crowd in the main were, kind of just came in and started a riot at the Capitol. That was mainly what we saw. I'll contend that, someone can say that it's, or believe that it's shameful for me to even speak to that, as though it's like Voldemort, you can't talk about it. I'm never going to submit to that kind of intimidation. Nobody should. We should get at the truth and be fair in our assessment. But it requires seeing the same things that are similar as the same and treating them that way. Nothing reinforces Americans' sense of a dual standard of justice more than the vehement embrace by Democrats of unequal consequences for like conduct. And it is done all the time. If I were to do that, if someone wants to bring up an analogous circumstance and say where I've treated something as nothing or cavalier about it as compared to another circumstance that I've been really serious about, I'd like to hear it. I think that's fair debate. I don't think we'll make any progress in this country if we have our own sets of facts. No one was bludgeoned to death at the Capitol that day. No one. I yield back.
The gentleman yields back. Who seeks recognition? No one seeks recognition. For what purpose does Mr. Benz seek recognition?
Correct the last word.
Gentleman is recognized.
Yield to Mr. Massey.
I thank Mr. Benz for yielding. I want to read from an article here. There's another person who was there present on January 6th. This is from Epic Times, and I'll just read you the passage of the article. Ray Epps, the former Arizona Oath Keepers leader who was famously captured on camera a day before January 6, 2021, urging protesters to go into the U.S. Capitol, allegedly directed a group of individuals who removed siege weapons, including a long piece of 2x4 lumber from a utility hatch on Capitol grounds after telling witnesses they needed to slow the crowd so it didn't F up the plan, a man claims. So you've got a witness who said that he was close enough to him, and also on the camera footage, if you go back, you can find that this witness was in close proximity with Mr. Epps several times and for a prolonged period of times, long enough to hear these words, if they were indeed stated to him from Mr. Epps. Is nobody curious about this? Does nobody care? On the other side of the aisle? I mean, I thought you'd set up a whole committee, a whole January 6th committee to get to the bottom of this. And the one person who there seems to be more information, more video of than anybody else that can be identified positively, and who is the only person that we see the day before urging protesters to go into the Capitol. the only person who's told the FBI that he thought there were going to be pipe bombs or there were going to be bombs on side streets, and that's one of the reasons he came. By the way, it seems like every time he talked to the FBI, he had a different reason for saying why he came to the Capitol that day. But why is nobody on the other side of the aisle interested in that? Why is the FBI not interested in that? Why are you rushing to his defense? This is the thing I don't understand. President Trump said far less than to go into the Capitol. That's where your problems are. And yeah, peacefully and patriotically, make your voices heard. But this guy said, go into the Capitol. I'm probably going to jail for it. I'm probably going to get arrested for this, for saying this, and he said it the day before. Why is there no interest in him? Why is there, by the way, and this is the one that we can identify. Why are there no interest in the other people who were urging them to go into the Capitol? We have photographs of them. Some of them never have even appeared on the FBI most wanted list. Whereas at least Ray Epps appeared there for a while before he disappeared.
Like he used to tap loud.
And,
well,
Mr. Chairman.
Remind members to mute their microphones.
So I would just close this out, and I'll yield back to Mr. Bentz, but by saying that this resolution is important. You're not going to memory hole this. There were cameras everywhere. You can create your own thesis for what happened, but if your thesis is in contradiction with things that hundreds of millions of Americans can observe and nobody disputes, you have to resolve that. And the only way we can do that is by getting to the truth. Give us the information, Mr. President. Give us the information, Mr. Attorney General, about this individual so we can put it to bed. If it's a conspiracy theory, we'll put it to bed once we get the information. But in the meantime, don't hold us from it. Don't withhold it. You're just making people less trustful of our government. With that, I yield back.
Mr. Chair, I yield back. Gentleman yields back. Who else seeks recognition? What purpose does Mr. McClintock seek recognition?
To speak on the resolution.
Gentleman is recognized.
I just wanted to underscore what Mr. Massey has said. Here's what I don't understand. I think all of us.
How do I get this back to?
I remind all members to mute their microphones unless they're speaking.
I think all of us on the Republican side join all of you on the Democratic side to say that what happened on January 6th was an outrage and it was an abomination. Maybe it's a stretch to suggest that we were minutes away from our government following to a lunatic with buffalo horns, but it was certainly an affront to the Constitution. It was an embarrassment to our country, and we should all be outraged. And we should all want to get to the bottom of it. I admit it sounds a little conspiratorial to suggest that there were agents provocateur egging on an already agitated crowd. It sounded preposterous to me until we discovered that this is exactly what happened in the so-called Gretchen Whitmer kidnapping, and we found that out at trial. It could still be preposterous, but what better way of exposing this as a preposterous conspiracy theory than getting the documents that this resolution is trying to get? You know, Joseph Welch told Joe McCarthy that if there were communists in the government he knew about, he should want to get that information before the sun goes down. Why aren't our colleagues chafing at the bit to get this information so they can wave it in our faces and prove what a silly proposition it is? Or conversely, shouldn't we all find out and expose all of those who are responsible for the disgraceful riot that interrupted the counting of electoral votes on January 6th? I should think that's something that should unite us all. And for that, and I yield to Mr. Roy.
I appreciate the gentleman from
Say it again. Alex Jones.
I appreciate the gentleman from California yielding. And I would just underscore, and I'd like to associate myself with every word, as usual, with what the gentleman from California said and the way he said it. And I would only add, in underscoring what I tried to make the point earlier with respect to the unaccompanied alien children, with the same point I tried to make last week with respect to the questions involving the FBI and parents and email exchanges at the White House and between the Department of Justice, that, again, our job in Article 1 is to check Article 2 and seek the truth. And I believed that when Donald Trump was the president. I believe it now. I will believe it whoever the next president is. We need to reassert Article 1 primacy. And this is a way to do that, in addition to following up on the words of the gentleman from California of seeking the truth. I'm not afraid of wherever the truth may lead. I just simply want to know the truth. And I think there's just genuine information here to find out. There was genuine information with respect to the unaccompanied alien children. There's genuine information about the exchange of emails and the coordination among the National School Board Association, the Department of Justice, and the White House involving tagging domestic terrorists to parents with a domestic terrorist tag. That, I think, is a simple position for us to take, and it's an important one that should be bipartisan. I yield back to the gentleman from California.
And I yield back the balance of my time.
Gentleman yields back. Does anyone else seek recognition?
Yes, Ms. Jackson Lee.
For what purpose does the gentlelady from Texas seek recognition?
Mr. Chairman, to strike the last word.
Gentlelady's recognized.
I am having trouble even capturing what I'm hearing today. And I have great respect for my colleagues on the other side of the aisle. But the absurdity of their discussion it really isn't worth response. But I can't help trying to defend those who I saw bloodied, beaten unconsciously, unconscious, and the persons who died on that day. I heard someone use the term hoax. I'm trying to find out what is the hoax that they're trying to suggest. Are they trying to suggest that President Trump did not provoke and aggravate the mob that was down at the White House to mob themselves up to the Capitol? Is he trying to suggest that law enforcement, Capitol Police, and others were not bloodied? That people are not still trying to mend law enforcement officers, even today? That many are suffering from post-traumatic stress disorder? Is he not, or the persons representing these outrageous comments about a hoax of January 1st, January 6th, suggesting that they did not say lynch, hang Vice President Pence, and cared nothing about the safety of him or his family? Are they not suggesting that there's no evidence to suggest that people were after the Speaker of the House and other leaders? Are they to suggest that the January 6th committee has not made its case? And that we want documents, which I'm sure if there are relevant issues to our jurisdiction, Chairman Nadler will allow us as we proceed and look to legislation that should be offered pursuant to the January 6th report or our hearings. I'm interested in Uvalde and the cover up there, and I will continue to pursue that. But I'm not calling Uvalde a hoax. I want additional facts. But to suggest that you need information to see whether it happened, it is as I said, there are no words to express my outrage. That people died, police officers are suffering still today. And the world was in shock. So anyone who's traveled overseas knows that the world pats us on the back and said, thank God you're back. We were so frightened. The defender of democracy looked like it was getting ready to crumble over some absurdity about that there was a fraudulent election and that Donald Trump won. He still pursues these incessant lies that are destroying the very fabric of what this nation was built upon. Abraham Lincoln is not only turning over in his grave, he's taking more dirt to put on him so that he cannot hear the horrific sounds of lies. He had integrity. He loved this nation. That's what I think all of us should do. My friends, carrying on this redundancy of denial is just not befitting of those of us who've taken the oath to serve in the United States Congress. It's just not befitting. You have a right to your opinion, but I don't think you have a right to deny the violence of January 6th, the threats to members of Congress, the glass breaking, the absolute rage of both the House and the Senate, the walking on desks, the standing in the area in the Senate chamber where the President pro tem would sit, I don't think anyone can deny that. If you want to get visual proof, go pull up the old tapes. They're there. There's 1,000 words in a picture. So I've listened to this go on and on and on. I appreciate the desire for me to yield at this time.
Will the gentlelady
and I
yield?
have great respect to do so, but I'm just not going to be able to do so because I just cannot counter what we're talking about here. And I cannot see why we're pursuing it. You have every right to do a resolution of inquiry, what you have done. But the effort to try to put truth behind this resolution or facts that are contrary to truth is not becoming of the Judiciary Committee and all the distinguished chairpersons we've had and members that we've had, and you as members as well who take this oath. It's just not befitting. And I think enough is enough, and I can't tolerate insulting those brutalized officers, those people who've had personal trauma that have continued, civilian staff that were frightened out of their life, and many members who still suffer today from January 6th. And if I remember anything, I remember the gunshot that I wish had not occurred, not because it was not what should have been done to save and do what the officer's job was, but because I value all life. But I do remember being flat on my stomach, hoping for the best as we ran for our lives.
Time of the gentlelady
Let us
is
not make mockery of this, Mr. Chairman. I yield back.
Time of the gentlelady yields back. Who seeks recognition? For what purpose is the gentle?
Move to strike, Mr. Chairman.
Move to strike the last word.
For what purpose does the gentleman from Maryland seek recognition?
Where is he?
I move to strike the last word.
Gentleman is recognized.
Mr. Chairman, on the evening of January 6th, some of our colleagues, both on the floor and off the floor, made an effort to blame Antifa for the assault on the Capitol. And that effort has failed because there's no evidence behind it. We know the Proud Boys were looking for Antifa. They were eager to get into a street brawl with Antifas. They were excited to have those photographs go out, but there was no Antifa present. But I wonder if it turned out that it had been Antifa. Let's say Antifa had done what the Proud Boys and the Oath Keepers and the Three Percenters and the militia groups and the QAnon networks and others who were assembled by Donald Tweets Trump had done. What if they had smashed our officers over the head and in the face, breaking people's noses, causing them to lose fingers, breaking ribs, breaking ankles, legs? These are our cops, giving them contusions, concussions, traumatic brain injuries, causing post-traumatic stress syndrome. I wonder, would we get a different response from our colleagues on the other side of the aisle? In other words, to what extent does the ideological provenance of this violent insurrection, this unprecedented massive assault on the Capitol, affect their estimation of the gravity of these events? And it's a serious question. I'm happy to yield.
You want an answer?
I would.
But please.
Well, in my situation, it's not ideological. On January 3rd, myself and 3 members of this committee, Chip Roy, Ken Buck, and Tom McClintock, issued a statement urging people not to come here, to accept the results of the electors. And so today, I don't have an ideological axe to grind either. I find it odd that you all are defending one of the people who assaulted the Capitol.
Defending who?
Ray Epps.
I literally have no idea what you're talking about.
That's the resolution.
Okay, well, I'll reclaim my time here. The GOP side has boycotted and rejected every attempt to have an independent or a House of Representatives investigation. Now, originally the Republican proposal was to have an outside 9/11 style commission with 5 Republicans, 5 Democrats, equal subpoena power on both sides, equal staffing on both sides. And you know what? A lot of Democrats were opposed to it because they said, why should we do that? We're in the majority. But the Democrats agreed to it. And they agreed to it with Mr. Katko, who is the representative of the minority leader, Mr. McCarthy. And after we went back and conveyed our agreement to the GOP proposal, it was vetoed by the fourth branch of government. I'm not yielding now. It was vetoed by the cult leader, Donald Trump, who said he wanted no investigation at all. That's your guy. Donald Trump, he said he wanted no investigation. And so you pulled the plug on the investigation you originally advocated because Donald Trump didn't want it. Let's tell some truth.
Would you like
You're talking about truth and facts. I'm giving you the truth. I'm giving you the facts about it. And then when Speaker Pelosi said, well, in that case, the House of Representatives will conduct our own investigation, then again, you guys boycotted it because you wanted to put pro-insurrection members on the committee. And so we ended up with a bipartisan committee of people really interested in getting to the facts. And you know what? This is what you guys can't stand. America listened to it because we had real congressional hearings. Unlike what goes on here with the temper tantrums and the diatribes, and too often our side gets pulled into what you guys are doing, but we had real hearings. And 25, 30 million Americans watching because we told the truth about Donald Trump's assault on democratic institutions and the right to vote in America. And maybe you can't handle the truth, but that's the reality, and nobody's laid a glove on any of the testimony that has come out during those hearings. So we hear this absurd whining about Ray Epps, who has absolutely nothing to do with any of it, and all of these conspiracy theory allegations have been debunked up and down. Up and down. You think you've got something? You bring him in and talk to him or send us a letter or do something. But why don't you deal with the reality of the situation? Do you think that Donald Trump tried to get the Secretary of State of Georgia, a lifelong Republican named Raffensperger, to just find him 11,781 votes? Is that real or is that fake? You interested in facts? Is that real or is that fake? You think Donald Trump?
Are you offering to yield now?
Time of the gentleman has expired.
Okay, I'm just saying, I would like a serious response to our hearings because
the time of the gentleman has expired.
If you wanted a serious response, Republicans would have been allowed to be on the committee.
Who seeks recognition?
Right. Louis Gohmert wants recognition, please.
Mr. Gohmert has already spoken on this, on the amendment nature of a substitute. For what purpose does the gentleman from Georgia seek recognition?
Move to strike the last word.
Gentleman is recognized.
I yield to Mr. Raskin.
you're very kind. Thank you, Mr. Johnson.
Well,
I'll come back
for an answer.
It's not my time. You know, I could take more seriously some of the frivolous conspiracy theories afoot in the far reaches of the internet, which somehow crawl into Congress, if at least our colleagues would accept the reality of what the rest of the country has embraced. Donald Trump's big lie is nothing but propaganda and disinformation. And the moment one of them says, you know what, we were wrong about this guy. He's an enemy of our constitutional order. He's a compulsive liar, and he's in it for himself. And he tried to convert the presidency into an instrument of money-making and profiteering on the backs of the American people. Then I could listen to you. But instead, I heard on January 6th, members of this committee, members on the other side of the aisle try to blame the whole thing on Antifa. And when that didn't work, well then, let's crawl down some other rabbit holes and throw out some more propaganda. They spread the big lie further. It wasn't enough to lie about the election, a lie that was rejected by more than 60 federal and state court judges, including 8 named to the bench by Donald Trump himself. Every allegation of election fraud, every allegation of electoral corruption thrown out by the courts, including by his judges, and they won't say a word about it. But instead, they will come up with some utterly frivolous rabbit hole conspiracy theory to try to pull a smokescreen over the eyes of the public. And they think that that's going to work. Well, we'll see if it's going to work. You know what that kind of attack on democracy gets you? It gets you an attack on freedom. Because Abraham Lincoln, the founder of the real Republican Party, a Republican Party that was an enemy of slavery, an enemy of racism, an enemy of know-nothingism and immigrant bashing, That's how Abraham Lincoln caught it. But it was Abraham Lincoln who said that democracy is like the beautiful silver platter upon which rests the golden apple of freedom. And today, obviously, democracy is under attack, a violent attack by these forces, and freedom is too, by the Supreme Court, which they packed. And that's what we're fighting, to defend our democracy and our freedom against the autocrats, the kleptocrats, and the bullies and the tyrants and the despots. All of them. I yield back, and thank you for the time.
Thank you. I yield the balance of my time to Mr. Jones.
Thank you, Mr. Johnson. You know, when I heard Representative Jackson Lee, followed by Representative Raskin, talk about the myriad injuries, including numerous deaths resulting from what happened in the insurrection at the Capitol on January 6th, I got a little nervous. The reason I got nervous is because when I started talking about the injuries earlier, my Republican colleagues erupted in unison. They tried to take down my words. They said I was, and in fact, I think they accused Representative Dean of doing the same thing, of being not generous enough in terms of the words that we used. We devolved into a conversation about whether it was the physical contact with Officer Sicknick that caused him death, or whether it was more proximately caused by the heart attack that he suffered as a result of that physical contact. And it just speaks to a larger problem. And that is the beholdenness that Republicans in this Congress feel to Donald Trump. They will do and say everything to stay in his good graces, even to the point of dismissing the tragedy, the horrifying existential crisis that January 6th represents. Mr. Roy had the nerve to talk about Article 1 of the Constitution. As a member of Congress, along with the rest of you, I too want to vigorously assert Congress's Article 1 powers. You know what the most powerful thing to do is under Article 1? As a legislative branch, we get the authority to impeach the President of the United States. And far too few of our Republican colleagues joined us in that democracy-saving effort following the events of January 6th. Only a handful of Republicans in the House had the courage to do that, even though the evidence was voluminous. We experienced it and we observed it in real time, in fact, leading up to and of course on the day of January 6th, to see the former president, through pushing the big lie and then holding his rally and then instructing people to march on the Capitol, literally incited the violent insurrection at the Capitol. And you did not join us in exercising our power under the Constitution to make sure that something like that never happened again. I yield back.
Gentleman yields back. Who seeks recognition?
Could I, yes, Owens, Burgess Owens.
For what purposes does Mr. Owens seek recognition?
I just strike the last word.
Gentleman is recognized.
Would like to yield my time to Mr. Roy, if he's still there.
Mr. Roy's not here, but Mr. Massey would take some time.
All right, well, all right, Mr. Massey, please take the time. Thank you.
And if he has time, I would ask the gentleman to yield.
I thank the gentleman from Utah. I wonder if the other side thinks it's a conspiracy or a rabbit hole that at least half a dozen FBI informants were involved in the kidnapping plot of Governor Whitmer. I don't think it is, because that's been shown in court. And I just find it amazing. They're talking about lies, but we're not here to make statements today. We are here to ask questions. We want to disprove or prove. I prefer to disprove that Ray Epps' his involvement is deeper than what we see, but what we see is troubling, and I find that the other side is defending it. Like, the gentleman on the other side said he didn't know what I was talking about when I said they're trying to exonerate Ray Epps.
Will the gentleman yield?
No, I will not. It baffles me. Here's a man who you say assaulted democracy, and you have the other side has no curiosity whatsoever. And if you want to disprove a conspiracy theory, as one of my colleagues already said, the best way to do it is release the truth. Every time the Attorney General has been asked, every time the FBI has been asked, they hide behind their policy. But their policy does not trump Congress. We created the FBI, we created the DOJ. They are creations of Congress, and we fund them every year. They don't have the option of not answering us, yet that is what they're trying to do every time they come here. It is their refusal to answer these questions. It is their attempts to target parents at school board meetings. It is their involvement in the FBI, I almost called it FBI kidnapping plot, well, it pretty much was, in the kidnapping plot in Michigan that created this question that we have to answer here today. So I don't know, don't call them lies, they're questions. We're asking questions of the president and the attorney general. Give us the information that's in your possession. Don't keep showing up to these committees in the House and the committees in the Senate and saying our policy doesn't allow you to answer this question. I thought this was the question of our time. What led to this day, to January 6th? With that, I would yield back to Mr. Owens or to Mr. Gomer.
Mr. Gomer, please. Yield to Mr. Gomer.
Yeah, thanks so much, Burgess. We were asked earlier about, how would you react if that had been Antifa out there hitting? Look, I've been very consistent. I was as a lawyer, as a judge, as a chief justice. I got no tolerance for anybody that would attack a law enforcement. I wish the Democrats felt the same way, and we would have brought more people to justice as they were attacking law officers and doing damage, burning down federal and other buildings. But those people go free, which lends itself to the concern of so many Americans now about a double standard in justice. With regard to election fraud, we heard that was totally debunked. We've heard that for 2.5 years. Well, at least a couple of years. But the truth is, those cases that we were referred to as totally debunking them, you had judge after judge that did not allow an evidentiary hearing. And so the judges threw the cases out. They refused to take them up. And that is very important that courts take up cases, give evidentiary hearings, because those are the institutions that are set up to resolve our disputes amicably and civilly. And that is the bastion where we've got to resolve things civilly, as well as in the legislature. And so that's not true that they've been debunked. And in fact, anybody, I'm sure we don't have many that have been involved in extremely complex litigation, but to have to come forward and prove a case within 2 months, that's pretty tough. I have other things, but my time's expired. Thank you, Mr. Owens.
Thank you.
The gentleman has expired. The gentleman yields back. For what purpose does the gentlelady from Texas seek recognition?
Mr. Chairman, I move to strike the last word.
Gentlelady's recognized.
Mr. Chairman, this discussion has been exhausting, and I agree with my fellow Houstonian and Texan, Congresswoman Sheila Jackson Lee, who said that some of these comments and some of the arguments and some of the theories that are being presented by the other side of the aisle just do not deserve any discussion. And I'm one of those who feel strongly like that. I think that this whole issue with Mr. Epps, whoever he may be, if it's any kind of credible referral that has been made to the Attorney General's office, I'm sure they will look into it. And I think any of us that are lawyers in here or former judges, as I know Mr. Gomer is and I am, and Ms. Jackson Lee also is, that we know that when investigations are taking place, we let the investigations go through and to completion, and then we'd let the chips fall where they may. And I'm one of those who subscribes to that. I believe in our justice system. That's what it's all about in our Constitution. With that, Mr. Chairman, I yield the remainder of my time to my colleague and friend, Mr. Raskin.
Thank you so much, Ms. Garcia. You're very kind. Mr. Epps does not work for the FBI. Mr. Epps is not an FBI agent. It is perfectly clear he's just another conservative, right-wing person who participated in the mob violence. He was one of tens of thousands who participated, and he basically says his life has been turned into hell by this conspiracy theory because they've turned on him and tried to blame it on him. Apparently, all that he did is when the FBI put his name out as somebody who was there, he got in touch with them in a hurry in order to try to tell exactly what he knew and what he didn't. And for that, he's been made into a sacrificial lamb. And the entire conspiracy, which certainly lies a lot more with Donald Trump and his inner circle than with one guy who showed up at Donald Trump's urging, is now being blamed on him in this desperate attempt to distract everybody from what really happened. But here's the thing that gets me about that, which is the way that the right wing in America devours its own. I mean, I have watched Donald Trump utterly destroy the lives of people around him, people who went to work for him, people like Michael Cohen, people like Cassidy Hutchinson. Look what they're doing to Liz Cheney and Adam Kinzinger. Mike Pence, hang Mike Pence. He hung his own vice president out to dry. The mob was after Mike Pence to assassinate him, to hang Mike Pence. They had a gallows and a noose outside. They unleashed him. They unleashed the mob on Mike Pence, and then Donald Trump sends out another tweet after he knows Pence is in danger to say Mike Pence did not have the courage to do what needed to be done. I mean, how far does this have to go before you people wake up? And now they pick this poor guy Epps out of nowhere and say, let's blame the entire thing on this guy.
Would the gentleman
It's the most
yield for a
absurd thing
question?
I've ever seen in my life.
Quick question.
I'm sorry?
Would you yield for a quick
Sure,
question?
by all means.
Mr. Epps was in front of the January 6th committee, and we were told that a transcript of his interview would be released, but it's never been released. And I wondered, was he sworn
None
in?
of the transcripts have been released, so you don't need a conspiracy theory about that. We haven't released any of them.
Were you present when he was interviewed? That would give me some.
No, I was not. I was not. We've done more than 1,000 interviews. You guys are trying to make this poor schmuck who showed up to your protest into something a lot bigger than he is. Okay, he's just trying to survive, and he's on your side. You don't have many voters left. You might want to try to hang on to them without demonizing and vilifying your own people. But that's the Donald Trump way. Sell everybody else down the road. Unless you're going to get a pardon. Some people are still hanging around waiting for their pardon. But most people have opened their eyes about what he's done to our country. What he's done to his family. Have you guys ever read the book by Mary Trump about the way that Donald Trump has absolutely destroyed their family, wrecked her father's life? They do it to family, they do it to friends, they do it to their own associates and employees. And now you guys are doing it to this poor Ray Epps. Leave that guy alone, whoever he is. I yield back to Ms. Garcia. Thank you.
Thank you, Mr. Raskin. I yield back, Mr. Chairman.
Gentlelady yields back. Who else seeks recognition? In that case,
Have an amendment.
Anybody?
for what purpose does
Mr. Chairman,
Massey seek recognition?
Mr. Chairman, I have an amendment to the amendment in the nature of a substitute.
The clerk will report the amendment.
I reserve a point of order.
Point of order is reserved.
Amendment to the amendment in the nature of a substitute to H.Res. 1356, offered by Mr. Massey of Kentucky. Page 1, line 12, strike Ray Epps and insert agents or assets of the federal government who encourage protesters to enter the Capitol building on January 6, 2021.
The gentleman is recognized for 5 minutes to explain his amendment.
I thank the chairman. You know, when we had Merrick Garland here, I showed him the video that I showed today. And Ray Epps was in the video encouraging people to go into the Capitol, saying he would probably go to jail. He was present there at the first breach, whispering into somebody's ear. But I didn't use Ray Epps' name. I asked him about if he had information on anybody that was urging people to go into the Capitol, and he said he wouldn't comment on a specific case. So then I rephrased my question, and that's what this amendment seeks to do, is sort of rephrase the request to the Attorney General and to the President. I asked Merrick Garland, can you tell us, without talking about particular incidents or particular videos, how many agents or assets of the federal government were present on January 6th? Were they present? whether they agitated to go into the Capitol and if any of them did. The reason I had to ask this question was at the time we already knew there were so many who were involved in the Michigan, so many agents or assets of the government present and agitating for the kidnapping of Governor Whitmer. So it's a fair enough question. It's not some wild conspiracy theory. In fact, I'd be shocked if there weren't agents or assets of the government who had infiltrated that group and present. The question is, to what degree were they participating? That's really the question. You can't say they weren't there. We know they're going to be there. And I also think maybe it's not the right question to pick, it's not the right thing to pick one person and question about him. Now, if the FBI were doing their job, if the DOJ were doing their job, they would be involved in the particulars, the particular people. But what hundreds of millions of Americans could see is that there's the most obvious guy who's agitating for this thing to happen that day he's never spent a day behind bars, he's never been indicted, and they want to know. So that's why I know my colleague, Mr. Gosar, decided to specifically mention Ray Epps. But I think we need to ask the broader question, and this also avoids the issue of Congress going after one person, is to ask the question, agents or assets of the federal government. And by the way, in just a second, the reason we need to say agents or assets of the federal government is because the denial it didn't come from a member of the January 6th committee, it came from a staffer. And the carefully worded statement said he wasn't associated with law enforcement. Okay, law enforcement is not the only aspect of the executive branch. There's intelligence, there's military, don't pick a specific thing. You just make more people suspicious when you lawyer up and make a statement like that is so specific that it leaves everything else open. So the amendment that I've got here should put everything to rest. And I'll yield to my colleague from Florida.
I suspect that this amendment will be rejected on procedural grounds, but it shouldn't be because it is highly responsive to a good point made by Mr. Raskin. Mr. Raskin made the point that whatever your view of January 6th, the idea of localizing the entire thing on Ray Epps would seemingly be unfair. And what we saw in the Michigan case is that you saw a dozen federal assets and agents involved in just one small matter. And so I think that the amendment is well-founded to ensure that we are responsive to the Raskin concern that is a legitimate one. And one thing you kind of notice is that feds are like cockroaches. You see one outside the walls, there's probably 10 behind the walls that you don't see. And in this particular case, we deserve the truth. The answers about what the federal government's involvement was, as Mr. Massey has correctly chronicled throughout this debate, when the Department of Justice has been given the opportunity to say that nobody associated with the federal government, prompted by the federal government, encouraged by the federal government, working for the federal government, increased the criminal acuity of January 6th, they have demurred in doing so. All they would have to say is nobody associated with the federal government increased the criminal acuity of that day. And I think that a lot more Americans would have comfort that at least on that day and that moment, assets of their own government weren't weaponized against them. But what we do know is that there were a lot of people who may have committed some technical violation of federal law because they crossed over a barricade that they didn't know had been erected, half an hour, 40 minutes earlier, and then saw their lives destroyed and ruined. And it's quite something to hear like the crocodile tears from Mr. Epps on the left when he is the only person we have direct video evidence was encouraging folks to go inside the Capitol. That's what we need answers on.
Time of the gentleman has expired. Does the gentleman insist on his point of order?
Yes, I do. First of all, on the point of order, both the gentleman from Florida and the gentleman from Kentucky just explained what's wrong with this amendment because they said they've had a change of heart. They want to extend it from Ray Epps to all the agents and assets of the federal government, presumably all of the right-wing Republican congressmen who were encouraging protesters to enter the Capitol building that night too. But in any event, that sweeps way beyond the original resolution. So if you want to do that, you're going to have to put in another resolution because we were just assured for the last several hours that all this concerned was one guy, Ray Epps. and what he did, and now suddenly you want to rewrite the entire resolution. So I will insist upon my point of order.
The gentleman is.
But I'd like to make one other point, if I could, Mr. Chair, before I break, which is I believe my friend from Florida just described federal law enforcement officers as cockroaches.
Does he have time to speak? He's made
Of course, I don't believe they're cockroaches. I was describing their propensity to be behind the wall, invisible or not. And so,
would you withdraw that comment, calling feds cockroaches? Would you withdraw that?
My characterization wasn't intended to be derogatory.
Yeah.
It was intended to describe what a Florida man would realize about the propensity to see something when there's evidence behind the wall.
The time of the gentleman. The debate must be constrained to the subject matter. Does Mr. Massey wish to be heard on the point of order?
I wish to be heard on the point of order.
Gentleman is recognized.
I think this amendment shouldn't be out of order. It restates the amendment, but it gets to the heart of the resolution without directing the resolution at any one individual. And that's why I think it should be in order. It's still well within the jurisdiction of our committee. It's still directed at the Attorney General and the President. It's still, the subject is still January 6th. And I just wonder, I mean, this will get to a point of judgment. I understand, and I understand we're outnumbered here on judging whether it's in order or not in order. But I would ask the other side to consider, we're just trying to get to the truth. And you can make this point of order, and you can drive it, very strictly. And I understand you have the power to rule this out of order, but I don't think you should. I think it's in the interest of this country to use the latitude that you have in interpreting whether it's in order to grant us this amendment, the debate on, even just the debate on the amendment. Let's have the debate. We know we're going to lose at the end of the debate. Just grant us the debate on the amendment. It'd be good for the country. I yield back.
The chair is prepared to rule on the point of order. The amendment is out of order, not because it is not within the jurisdiction of the committee. The amendment is out of order because it broadens the scope of the bill. The bill concerns one individual named Ray Epps. The amendment inserts a whole class of people, agents or assets of the federal government. It is therefore broader than a resolution, than a bill limited to Ray Epps, and therefore the amendment is out of order. Who seeks recognition? If no one seeks recognition, the question occurs on the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the resolution. All those in favor of the amendment in the nature of a substitute will say aye. Aye. Opposed, no.
No.
Opinion of the chair, the ayes have it. The amendment in the nature of a substitute is agreed to. Reporting quorum being present, the question is on the motion to report the resolution H-Res 1356 as amended unfavorably to the House. Those in favor respond by saying aye. Aye. Those opposed, no.
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 The ayes have it.
No.
Recorded vote.
A recorded vote is requested. The clerk will call the roll.
Mr. Nadler.
Aye.
Mr. Nadler votes aye. Ms. Lofgren. Ms. Jackson-Lee. Ms. Jackson-Lee. Mr. Cohen. Mr. Cohen votes aye. Mr. Johnson of Georgia.
Aye.
Mr. Johnson of Georgia votes aye. Mr. Deutsch.
We are now voting on final.
Ms. Bass. Mr. Jeffries. Mr. Cicilline. Mr. Swalwell.
Aye.
Mr. Swalwell votes aye. Mr. Liu. Mr. Raskin.
Aye.
Mr. Raskin votes aye. Ms. Jayapal.
Aye.
Ms. Jayapal votes aye. Ms. Demmings?
Aye.
Ms. Demmings votes aye. Mr. Correa?
Correa votes aye.
Mr. Correa votes aye. Ms. Scanlon?
Aye.
Ms. Scanlon votes aye. Ms. Garcia? Ms. Garcia?
Aye.
Ms. Garcia votes aye. Mr. Neguse? Ms. McBath? Mr. Stanton?
Aye.
Mr. Stanton votes aye. Ms. Dean?
Aye.
Ms. Dean votes aye. Ms. Escobar? Mr. Jones? Mr. Jones votes aye. Ms. Ross?
Ross votes aye.
Ms. Ross votes aye. Ms. Bush?
Bush votes aye.
Ms. Bush votes aye. Mr. Jordan? Mr. Jordan votes no. Mr. Shabbat?
No.
Mr. Shabbat votes no. Mr. Gomert? Mr. Isa?
No.
Mr. Isa votes no. Mr. Buck?
No.
Mr. Buck votes no. Mr. Gates? Mr. Gates votes no. Mr. Johnson of Louisiana?
No.
Mr. Johnson of Louisiana votes no. Mr. Biggs? Mr. McClintock? Mr. McClintock votes no. Mr. Stubbe? Mr. Tiffany?
Tiffany, no.
Mr. Tiffany votes no. Mr. Massey?
No.
Mr. Massey votes no. Mr. Roy? Mr. Bishop?
No.
Mr. Bishop votes no. Ms. Fishbach?
No.
Ms. Fishbach votes no. Ms. Sparts? Mr. Fitzgerald? Mr. Fitzgerald?
No.
Mr. Fitzgerald votes no. Mr. Benz?
Votes no.
Mr. Benz votes no. Mr. Owens?
Mr. Chair, how am I recorded? This is Mr. Neguse.
Mr. Neguse, you are not recorded.
Neguse votes yes.
Mr. Neguse votes yes.
How am I recorded? This is Bass.
Ms. Bass, you are not recorded.
Bass votes aye.
Ms. Bass votes aye.
Madam Clerk, Cicilline votes no.
Mr. Cicilline votes
I'm
no.
sorry, votes aye.
Mr. Cicilline votes aye.
How is Escobar
How am I recorded?
Ms. Escobar, you are not recorded.
I vote aye.
Ms. Escobar votes
How am
aye.
I recorded?
Ms. Jackson Lee, you
How
are
am I
not
recorded?
recorded.
I vote aye.
Ms. Jackson Lee votes aye.
Lou votes aye.
Mr. Liu votes aye.
How is Mr. Cicilline recorded?
Mr. Cicilline is recorded as aye.
Mr. Chairman, this is Rep. McBath. How am I recorded?
Ms. McBath, you are not recorded.
Rep. McBath votes aye.
Ms. McBath votes aye.
Are there any other members who have not been recorded who wish to be recorded? Clerk will report.
Mr. Chairman, there are 22 ayes and 13 noes.
The ayes have it, and the resolution as amended is ordered reported unfavorably to the House. Members will have 2 days to submit views. Without objection, the resolution will be reported as a single amendment in nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. This concludes our business for today. Thanks to all our members for attending. Without objection, the markup is adjourned.